Good morning and welcome to the LawNewz Network. I'm your host, Amy Dash. Wow, what a day yesterday. OJ freed on parole. He will walk free on October 1st. But today, and I'm sure our chat room bloggers will appreciate this, we're going to shift our focus back to the Campbell trial. This is a trial in North Carolina where a young man, 21 years old, Eric Campbell, was with his father on what he thought was a road trip. All of a sudden, it turned into a killing spree, and Eric Campbell was there for the ride. Well, he took the stand yesterday. His father committed suicide, and now he is on the hook for the murder charges, and he's facing the death penalty. It was a critical decision whether or not to put him on the stand. The defense decided to do it, and we'd like to toss to a clip from yesterday that we can preview because he's going to be back on the stand today. So let's listen to what he had to say yesterday.
Now, is that the photo of your family?
Yes, sir.
And who's in that photo?
The smallest one, at the very bottom, that's me. At the right is my brother Nicholas. Middle is my mother, and on the left is my dad.
Do you have any idea about how old you are in that picture?
I don't. I'd maybe say about a year.
And if I may, publish Defense Exhibit 22 on the television.
Yes.
And what's that a picture of?
That's my mother.
And you said in your testimony that was what your mom looked like before her injury. Could you tell the jury a little bit about that?
I only know most about it from my father.
I
only know most of it from my father, what basically he's said about it. We lived in the south tip of Texas, about as close to the Mexican border as you can get. We had a ranch, and my father, he had always used drugs in his life, and my mom would partake. And my dad told me that
I object. That's the hearsay.
Sustain that.
that she was using fin fish.
Motion strike.
What?
Mr. Campbell, when there's objection, you can stop talking. And if the judge says sustain, that means you just have to wait till the next question. If he says overrule, then you can answer the question. If you're ever confused about that, just ask me and I'll let you know.
Yes, sir.
Now, in that photo, does that look like your mom as you remember her?
I've never seen that photo, but it looks like the other one. Yes, sir.
But in your memory, in your memory of her as a child, she looked differently than that. Is that right?
Yes, sir.
And if you would tell the jury, what's your memory of her as a child? What was she like in your memory as a child?
She was confined to a wheelchair, an electric wheelchair. My first remembered memory of her is her telling me that she's hungry, and I can barely open the refrigerator, and I pull out a slice of ham and cheese to feed her. And the other is having to brush her teeth. She could barely speak, couldn't move. It was a brain aneurysm.
No, I'm handing state what's been marked. It's exhibit 23 and 24.
Yes.
Mr. Campbell, I'm handing you what's been marked as defendant's exhibit 23 and 24. Starting with 23, can you tell me what that is? If you can speak up, I know.
That's my mom.
And what do you mean by that's your mom?
That's how I've always remembered her.
And what is she doing in that picture?
She looks upset. She's has her seatbelt on in a wheelchair. Her left arm has always been locked in that position. She couldn't really open her right hand either.
And Defendant's Exhibit 24, do you recognize that?
Yes, sir.
And what is that?
It's me and my brother. And we're taking a picture with my mom.
And is that your mom as you remember her? And would these photos help illustrate your testimony?
Yes, sir.
Your Honor, I would offer Defense Exhibit 23 and 24.
Objection.
Objection to relevancy ground.
Overruled.
Your Honor, may I publish Defendant's Exhibit 23? Now, that's the photo you said when your mom is sitting in a wheelchair.
Yes, sir.
If you would tell us a little bit about what she's doing in that photo.
I don't know. She looks upset.
Is that an accurate, or what's the way you remember your mom?
To be honest with you, I couldn't really tell you. She never really talked very much.
Well, besides having difficulty speaking, were there other limitations she had?
Just about everything.
And tell me more about what you mean by that.
She couldn't walk. She couldn't go to the toilet with herself. She bathe, eat, brush her teeth. Nothing.
Now, may I publish Defendant's Exhibit 24? Now, is that the photo you're saying of you and your brother and your mom on the couch?
Yes, sir.
And do you have any idea how old you and your brother are in this picture?
I don't. Seven maybe.
Now, during these years, when you were in elementary school, who else lived with you besides your mother?
They're in elementary school.
Yes.
Fourth grade and on up. My stepmother, or who became my stepmother, Holly Smoot.
Before your father met Holly, who lived with you and your mother?
There was a variety of women. Before Holly, it was a woman named Wanda Nolan. Before her was Linda Lamont.
And was your dad present in the home during those times? And what was your father like when you were in elementary school?
We had just moved to a town called Alvin, Texas. We lived in a house that was a fixer-upper. It was basically a trashed house. Every day, go to school, we get home, we would work. As to things, he was as he always was, I guess.
And what do you mean by that? How was he like he always was?
He obeyed, he listened. That was what life was.
And did your dad ever use physical force against you?
Yeah.
If you could tell us more about that.
You know, for basic about any kind of mistake a boy could make, you were hit. If he was feeling more formal, he'd take you to the bedroom and strip you down from your waist, and just go ham with the belt. Sometimes he'd turn it around and use the metal end. It was basically, when he was done, you were black. From the bottom of your legs to the back of your neck. Sometime he had me come back out of the bedroom and strip off my pants in front of Holly to show her. I don't know if he was looking for her approval or whatnot.
I object to this. That's not responsive to the question, Your Honor.
Stand.
And that was Eric Campbell taking the stand. I'm joined now by Deborah Bloom. She is a LawNewz trial analyst and a criminal defense attorney. What do you think about that decision of him to take the stand in his own trial?
Well, I think in a case like this, the jury really wanted to hear from him to back up his defense attorney's opening statement, where the defense went through all of the abuse that this young man suffered at the hands of his father. So I think the jury really is going to benefit from hearing firsthand from his mouth about all of the horrors of his childhood and young adulthood.
Do you think that that decision was made specifically because this is a death penalty case, or that either way he would have been taking the stand in his own defense?
It's really hard to say when you're not there making these decisions. You know, we can guess and speculate, and of course I do think that the fact that this young man is facing the death penalty,
yeah,
since it's a capital case, played into the fact that his defense attorneys decided to roll the dice. That's basically what you're doing. You're taking a very big chance when your client testifies, because that person could practice, you could go through their testimony time and time again, but when they actually take the stand, they might be nervous, they might just become a completely different person than what they're like when they're with you.
Oh, that's really interesting. So that it's really hard, you're saying, for the defense attorney to even know how the person's going to come off, because you could spend all this time with your client and the second they take the stand, all of a sudden, like you said, they turn into a totally different person, maybe because of the pressure or the new experience, or even upon cross-examination. A lot of people don't know how to handle that.
Absolutely, and especially in a case of this magnitude, I assume that the defense took the time and prepared adequately with their client and anticipated what the prosecution would do during cross-examination. But it's very different when you're either at the jail or at your office and speaking with your client versus when they're on the stand and nerves kick in.
Yeah, and we just saw a little bit of the defense's approach, and it basically is go back in time and go through this young man's childhood and let the jurors feel and hear about what he experienced. Was that effective? Because I found him to be very believable, and I felt myself feeling really bad for him, his mother in the wheelchair, and he is describing in detail how his father brutally beat him with a belt. That's
right.
Effective for me.
You know, I read somewhere that he was beat with a gun even at the age of 3 or 4, that his father would hit him that way. So yes, I think that he is giving extremely effective testimony, and he is believable and credible, which is the most important thing. Is your client going to sound credible and believable when they testify? It's also extremely important for the prosecution to make sure that their witnesses sound believable. In this case, I do think the prosecution did a standout job in keeping their testimony limited to what was critical. Although we heard a lot of testimony, it was a short period of time, and I think that plays much better for the jury. On a lot of cases that we've covered here on LawNewz, I find that the prosecution has gone on and on with their witnesses, and that was most likely to their disadvantage when the verdict was rendered against them.
Yeah, you know, we were covering the O.J. Simpson parole hearing yesterday, and I spoke with Alan Dershowitz. He was from the Dream Team, and he was saying the same thing about what happened with that 95 murder trial, that the prosecution just piled on the witnesses. I mean, that was a notorious example of just throwing way too much into the pot, where it becomes confusing to the jurors. And sometimes, like you're saying, a simpler case is easier to absorb. But how do you think that the prosecution will counteract this testimony? Because basically, you have him looking drastically different than what we've seen. He looks like a librarian almost, with the glasses, and he's all conservative and buttoned up. He's soft-spoken, he's believable, he's a sympathetic character, which is very strong for the defense. So how do you counteract that?
Well, really quickly, I want to go back to the Dream Team and Professor Dershowitz's comment. I think that in the OJ case, aside from the prosecution presenting way too long of a case and the jurors being secluded for way too long, their number one mistake was not changing venue. They had that option available to them, but they left it where they should not have, because way too many of the jurors were sympathetic to OJ, and this became a race thing. And the second issue with that case becoming a race matter is the prosecution could have eliminated more of the African American jurors who, in my opinion, were sympathetic towards OJ. I certainly can't blame them because they've had years of oppression by the police, so I understand their rationale and what they did. But I think that the prosecution made many mistakes even before presenting way too long of a case. In this trial, I think that the prosecution is simply going to go back to what they focused on in their opening statement, which this was a conscious choice. This young man could have ran away from his father. This young man could have made the decision not to go into that home, or the second that he entered the home and saw what the scene was like with the bow and arrows in these people's body, which is just so tragic, he could have left. And that's what the prosecution is going to say.
You know, to address what you said with the OJ hearing, that was also something that Dershowitz brought up, which was really interesting. Obviously, race may have played a role here because you had a majority African-American jury, but he said something really interesting, and that is that this was a unanimous verdict, and that there were Asian Americans, there was a white woman on the jury, in fact, somebody who had served in another trial and completely turned the whole jury to vote guilty, but in this trial, she was convinced that OJ was innocent, so she had sort of flipped her position. She was known as somebody who really led the jury to a conviction in another case and not so in this one. So he said it was just really interesting that, yes, it was a majority African American, and he agreed that they should have changed the venue, but that really was a unanimous verdict. With this case with Eric Campbell, I think what you're saying is exactly right. Now, what do you think about these jurors? Do you think that they will believe Eric Campbell, and do you think that because he is so compelling that they will decide not to give him the death penalty?
It's most likely that they're not going to give this young man the death penalty. They will most likely convict him on certain counts that he's charged with. I don't know that they're going to do the top counts, but So
you think definitely a conviction?
I think that there'll be a conviction on some of the counts. I don't think that we're going to see a conviction across the board, so I don't think that they're going to have guilty all of the way, but I do think that they're going to have guilty on some of the counts. And I don't think that, you know, even if you find a top count guilty verdict, I don't think that the jury is going to ask for this man's life.
Yeah, I think that this testimony is critical in convincing the jury not to put him to death because it humanizes him. But like I said, what you were saying before is exactly right, that he was making conscious decisions, and the jury is going to be reminded over and over again that 2 innocent people died. But what he's saying, what he said a little bit of yesterday on the stand, is basically that he's putting forth this argument that he went with his father to try to prevent these things from happening. The fact that he didn't actually try to prevent them, because then he says that he got a little bit scared, was fearful for his life, and it all happened so fast that he just couldn't get in there. Is that enough to excuse the fact that he went with the intention, like he said, to try to stop it, but didn't actually do anything?
Well, we're going to have to wait and see what the jury says, because it's ultimately up to them to make the determination in this case. I do think that it is very crucial that he suffered so much abuse, and there was testimony even during the prosecution's case in chief of another family member to say that his father was an abusive man who did terrible things to family members, to his children, to his wives. So that's a huge problem for the prosecution, in the sense that we know that this young man had good reason to be fearful for his father, had good reason to fear that in the moment that if he would have tried to run away, that his father might have turned on him and killed him, because it sounds like the father came close to that in the past.
Yeah, but is this even a defense? I mean, we're hearing all about his childhood abuse. Is it a recognized defense?
Well, it's a mitigating factor. It's not an affirmative defense, or I'm not sure if they're trying to use it like an affirmative defense here, because to do that, it almost seems like this is a mental defect defense, in the sense that this boy is so helpless and had been abused for so long by his father that he just couldn't act on his own. So he didn't form the mens rea to commit a crime.
Right, and is there truth to the fact that part of this theory is also not only that he didn't form the mens rea, but perhaps he didn't even have the skills to know what the right thing to do was, because his role model is this terrible, sick, abusive man.
You know, unfortunately, many people that commit crimes are in a similar situation where they've grown up abused and they're found guilty, or they don't take the risk of going forward to trial and they take a plea deal. So there is a lot of abuse. We don't know what goes on behind closed doors, but we do know that here we're finding out what went on behind closed doors, and it's extremely tragic, but it's also tragic that you have the death of two completely innocent people.
Of course, but now, do you think that the prosecution would have offered Eric a deal if his father were still alive, and that they're only really putting him on trial and asking for death for him because they have nobody else to hold liable for the murders of these two people?
You know, I think that the prosecution here, in putting forward such a strong case against him, is doing their job, and they have to have someone be responsible for these deaths of these two individuals, and we know without a question that this young man was there. So it's not like they're going up against somebody or trying somebody who it's a circumstantial evidence case where we don't know that they were involved, we don't even know that they were there beyond a reasonable doubt. Here, beyond a reasonable doubt, this young man was at the scene of the crime.
Right, but do you think that it's fair if his father were alive and they would have offered this guy a plea? Do you think they just can't offer him a plea in the circumstance that it really wasn't even an option because two people are dead? So he's got to go to trial, but on the flip side, if his dad didn't kill himself, maybe he would have been offered a plea.
I mean, his father really left him in a terrible situation by committing suicide, because now he's the only one that has to face the wrath of the fact that there are two people that lost their lives tragically. So his father didn't do many favors when he went on this joyride with him across the country and then killed two people, and he also didn't do any favors when he killed himself, because maybe the father would have taken the stand and said, don't find my son responsible. I mean, it brings up a lot of interesting questions that you just raised. Like, for example, if this would have gone forward, would the son gotten immunity to testify against his father? Would he have made that choice? Or if he didn't get immunity or didn't make the choice to testify against his father, would they have been tried together, and then would the father have been able to take the stand and protect his son, because he did try to tell certain law enforcement that his son wasn't responsible. It's just the judge won't allow that in.
Yeah, what do you think of that? That testimony from the father was not admissible, the words he said before he passed?
I don't know enough about this case to find out to know the judge's exact ruling and why that determination was made. You know, I don't believe that those statements were given under oath. They weren't dying declarations in the sense that the father maybe even would have left a suicide note saying my son isn't responsible, because that could have been deemed a dying declaration. Or if he would have told another inmate, my son isn't responsible, and then killed himself. So it seems like the judge's ruling that this was hearsay is a permissible ruling, not something that's going to be granted on appeal, you know, as an error. So unfortunately, this young man is left to go at this on his own.
Yeah, and it's a really controversial case, because I feel like a lot of people in the system think that anybody who has played any role, as we know, there's things like the felony murder rule or joint venture liability. Anyone who plays any role is liable for the highest crime. But there are other people, and a lot of people in the public, that they just don't know this. And when they hear, wait, I could be responsible for killings when I didn't actually do the killings, in this instance, when he didn't actually stab the people or shoot them with their crossbow, that's surprising to a lot of people. What do you think of accomplice liability in this case, applying it here?
Well, I think that it's really going to be something the jury determines, is whether they find that by his sheer presence is enough to find him guilty, is enough to say, you know what, he had the intent to commit a murder. He knew about his father's purchase of many of these materials used in the commission of the crime. Is that enough? It's going to come down to the juror's choice.
And so, but they would have to find also that he had the intent for the underlying crime of the robbery. That would be enough just to find him guilty on the murders. Do you think that the facts support that he intended to commit this robbery?
I think they could when you present it that way. That's the issue, is that the prosecution should be listening to you, and then they're going to be able to say in their summation that, you know, he knew that his father was going to rob this couple, so he should have stopped it, or he should have gotten out of the car and not participated. You know, he could have made a choice and ran the other way, but then the defense is going to counter that with, he really couldn't. You know, this is a man that was so used to being abused and beaten by his father that he really almost lost his free will.
Yeah, because I think the assumption within the accomplice liability is that if there's a felony in progress, you have to be able to foresee that something could go terribly wrong and someone could get killed. So it's really like it's almost like you have to have this prediction of what's going to happen. And the question is somebody who's 21 years old, I know we're always cutting the line at like 17, 18 years old, juvenile, but even 21 these days, it is still young. Do you think someone who's 21 years old can have that type of foresight when they've grown up in an environment like that he could think, you know what, my dad said that he's going to go rob somebody, someone could potentially get killed. I mean, I think that his statement that he wanted to try to stop bad things from happening actually supports the prosecution in showing that he understood that something could go wrong, people could get killed.
I think it could go either way, and you know, unfortunately, a lot of times crimes are committed over a split second, and that's all that it takes to have a loss of life, and then you have a prosecution and responsibility for the commission of the crime. I think the strongest thing the defense has going for them here is that this young man was along for his father's terrible ride, and he wasn't the one that planned these things, he just was there.
And the fact that he said he couldn't really act fast enough, that things were happening so quickly, is that a viable defense?
I think that what you do as a defense attorney is you throw as many things out there to protect your client, or to try to protect your client as possible. So I think that all of these things add to doubt, and all of these things add to protecting this young man and trying to spare his life.
And lastly, before we go back to Eric Campbell on the stand from yesterday to preview that before he takes the stand again today, what do you think of the strategy of not only focusing on the abuse by the father, but on the disability of the mother, and the fact that he really didn't have anyone who was capable of being a strong role model for him? He had a lot of grief and a lot of stress in his life growing up with a mother who may also have been the victim of the father, and so it seems like he had a hard life.
You know, unfortunately, I've tried to use that when I defend my clients who are charged with grave crimes, and it doesn't always work.
Oh, interesting.
You know, like sometimes, oops, I killed somebody, it was a mistake. That's not a defense. Mm-hmm. So unfortunately, you can see the human aspects of many of these individuals who commit crimes. It's not so black and white. It's extremely tragic when there's a loss of human life, and that's completely, totally unfair, and there are so many ways that we could get into the travesties that go along with murders. Mm-hmm. But there's also this person who's the accused, who perpetrated this act, and you know, we're looking at them as a human being and seeing what happened in their lives, and a lot of times they had terrible things happen in their life, so it's very complex.
Yeah, and it's like you said, it's not always an excuse. So do you think that the jury, and in your experience, has the jury in your cases stuck really to the black letter of the law, or do they kind of get influenced by the emotional aspect, like you're saying, of everything?
I think that the jury does the right thing, and I think the right thing here is going to be find him guilty of some counts, not the top counts.
Mm-hmm. Because that's sometimes in the sentencing phase, that's when the more emotional impact comes in.
Well, I don't even think it's that. I think that they're going to be given a list of charges, and they're going to make a decision as to whether he had certain levels of intent, and I don't think they're going to find him guilty of the first-degree murder charges, but I do think that they're going to find him guilty of the lesser charges, which he is guilty of.
And lastly, you know, he would be, if he were found guilty and he would be eligible for the death penalty, they're going to consider the aggravating factors, which really focuses on the way that these people were killed. It seems like there may have been some suffering, so maybe they can apply the heinous and What's that factor, the aggravating factor?
Right,
It's like
well-
heinous and atrocious.
Yeah, I mean, we're certainly...
If somebody suffered, basically.
The people here definitely suffered, and what was really terrible, I was reading about how their son serves as a fireman, and he was one of the first responders. He went over to his parents' home, and they were missing, and he saw blood, and, you know, he began to understand that his parents were most likely dead. So that's extremely tragic. But I think that the father here who committed suicide is the one that would have gotten the death penalty. I don't think that the son is deserving of that.
Yeah, because that was my point, and I just pulled up the aggravating factor. It's heinous, atrocious, or cruel, and basically it relates to the people that are being killed. Are they suffering? Is it a prolonged killing? So really, in their final moments, it's not like in a second they're dead. I mean, they really have to go through some pain to reach that conclusion. And so that's what I'm wondering is, can you even take it that far? Can you take it from, okay, he didn't do the actual killing, but he should be held responsible, to he didn't do the actual killing, he should be held responsible, and he should be held responsible for the way the killing was conducted?
No, I think that's a stretch. I don't think that he should be punished for his father's acts of making this a prolonged, heinous thing where these people really were tortured. You know, that was his father's choice, not his. You know, he brings up an important point that it all happened so quickly. That's not an excuse, but that is something that I've heard my clients say over and over again, that when this unfolds, it's happening so quickly, and he wasn't the one that was calling the shots.
Yeah, and so it calls into question whether, in fact, he could make a conscious decision and a conscious choice in those final moments. So we're going to toss back to Eric Campbell on the stand from yesterday, and we are expecting the Campbell trial to resume any moment now, and we'll go straight to the courtroom when it does.
Cool.
So, Mr. Campbell, if you can keep your voice up and tell the jury about times in your childhood when your father hit you with an instrument.
Instruments weren't used too often. My dad liked to use his hands.
Did he ever hit you with an instrument, though?
Yes, sir.
And if you could tell the jury about when he hit you with an instrument.
About just a mistake done. I don't remember what the mistake was, but, you know, flipping the screwdriver to the other side and just laying a hollow, resounding thunk on the head. It was just in passing.
Did your father ever hit you with a gun?
Yes, sir.
If you would, try to keep your voice up and tell the jury about when that happened.
I think I was 4 or 5. This was back in the south border of Texas, and you know, my dad was taking us to go shooting, and he was walking out there to set up targets, and I remember aiming down the barrel at those targets, and my dad saw me, and he was out there setting them up at the same time, and he ran back and grabbed the gun out of my hands, and a pistol hit me with the butt of the gun on my head. And I just remember after that laying in my bed, and I was holding paper towels to my head to stop the bleeding.
And when that happened, what were you thinking? What were you feeling?
I don't know. Just fear. Just not wanting to touch those things again.
And that was Eric Campbell, 24 years old now, testifying in his own defense in his death penalty murder trial. And right now the trial is starting today, so we're going to go right to the courtroom, and Eric is expected to take the stand again.
Good morning, ladies and gentlemen. Good morning. We thank you for coming back being with us today. Mr. Campbell may be found by his oath to tell the truth that he took yesterday.
Mr. Campbell, when we finished up our examination yesterday, I had showed you that gun. Is that right?
Yes, sir.
And that was a .22 pistol that you had in your pocket in the West Virginia woodline. Is that correct?
Yes, sir.
And you told the jury yesterday that you had taken that gun and smashed it with a rock.
From what I remember, yes, sir.
All right, and then you told us later that you placed a rock very hard on top of it.
Yes, sir.
And that's because you never smashed it with a rock, is that right?
I don't see the difference between this and...
When you were talking to Roger Baker on January 1st of 2015, and he asked you about the gun, you said it was already in my pocket. Is that a fair and accurate statement?
Yes, sir.
And he asked you, he said, okay, so you had the gun on you when you got out there in the white vehicle, so you had a gun on you too? Question mark. And you said, yes.
Yes, sir.
And he asked you, was that the 22? You said, yes, sir. So when Roger Baker asked you, when you went over the hill and you got out of the truck and you ran, how far from that truck did you go before you threw that pistol away? And you responded, it crashed. It kind of crashed into a ditch. Over the first hill, it's buried. Did you bury it or just throw it down? You said, buried it. Is that a fair and accurate statement?
Yes, the gun was smashed and buried.
Okay, so with respect to Sergeant Baker, who you were giving a statement to at the time, you're telling the jury that you did not tell all the facts to him. Is that correct?
I told him everything that I could, that,
Okay.
that I possibly remembered.
Now, at the time Roger Baker was questioning you, he was concerned about the whereabouts of Holly Smook. Is that right?
I
On him.
Yes, sir.
And he asked you, did he beat her up or something? And you said, I assume so. He never told me.
Yes, sir.
Now, that's not true, is it?
He never explained what happened that night.
But you knew what happened that night, didn't you?
From the charges that he was charged with,
You knew because you visited the home that night. You walked out of there on Holly, didn't you?
I walked in. Shane was with me at the time. I heard they were fighting, and I turned around and walked right back out.
You didn't hear a fight. You heard your dad beating Holly. Isn't that right?
No, they were arguing back and forth.
They were arguing back and forth. Now, you visited that home often, is that right?
Yes, sir.
But you weren't living there.
No, sir.
And when Roger Baker asked you where you lived, you said, no, at the time I was living at a different home. Okay, my driver's license says 2015. I did that so I could keep going to school and getting my grants because I couldn't afford it all the way. And he said, okay. And you said, I lived at 816 Riverside Drive.
Yes, sir. It wasn't 2015. It was 3015.
3015.
Yes, sir.
And you were living separate and apart from your father at the time.
A few miles away. Yes, sir.
A few miles away. You had a job.
Yes, sir.
You were getting ready to go to work for Gary Edmonds at that time.
Yes, sir. I was working for him.
Okay. Now, after the assault, Holly moved out, didn't she?
The house was empty.
And you moved back in.
Yes, sir.
Okay. And you don't know where Holly was, do you?
No, sir.
During that time, you never had any idea. But when Roger Baker asked you, you don't know or he didn't kill her, you said he didn't kill her.
Yes, sir.
And the reason why is that from the time your dad got out of jail, you were with him a lot, weren't you?
I knew he didn't kill her because I saw her when she showed up at the house.
You knew he didn't kill her because you made sure he got up to Huntsville State Park, right?
Yeah, he was going on a lamb, and it was the closest state park.
And he was up there dependent upon you and your brother for support.
Yes, sir.
He was dependent upon you and your brother to help bring him food.
Yes, sir.
He was dependent upon you and your brother to help communicate for him.
Yes, sir.
He was dependent upon you and your brother to help him evade the authorities.
Yes, sir.
So, yesterday when you were kind of acting befuddled about this white Suburban, the truth of the matter is you knew that he was entirely without resources, didn't you?
While he was camping, he wanted to stay in the state park. I mean, your resources have to be brought with you.
All right. Well, Sergeant Baker said, hold up, hold up. The stolen vehicle is the least of your worries right now. I don't care about the stolen vehicle. Where did he get that vehicle? You said, he told me he got it from Huntsville. Sergeant Baker said, Huntsville? He went down, and I'm sure you told you it was stolen. He said, once we had left. But you knew from the time you saw it, it was stolen.
No, sir, I've never seen a stolen vehicle before.
Right, but your dad was up there dependent upon you for food.
Yes, sir.
Communication.
Yes, sir.
Money. Your dad was not going to use a credit card up there, was he?
I don't know. I wouldn't think so. No.
Well, you wouldn't think so because he did not want to have a credit card transaction for anybody to know where he was.
Yeah, that makes sense. Yes, sir.
And you're well aware of that.
Yes, sir.
He didn't even want to have a cell phone.
Yeah, he's paranoid.
Well, he was paranoid, but he was thinking that if I have a cell phone, I'm going to give away my location. Is that right? And he told you that.
I guess so. Yes, sir.
And because of that, you continue to aid him by being his pipeline for communication for all kinds of messages. Is that right?
I didn't see him after I dropped him off in the forest. Next time I saw him was at that field next to the airfield.
Okay. And the time you saw him after that was at your brother's house?
Yes, sir.
And y'all were in the Nissan?
My dad left with me in the Nissan.
Okay. And you had gotten everything on that list that he'd asked you to get, right?
That and food stuff and other things. Yes, sir.
Okay. And you went and got the Suburban because you wanted to have a vehicle that if things turned out a certain way, you could ditch it. Wasn't yours, was it?
I don't know what was going through my dad's mind when he picked the Suburban.
I'm not asking you what's going through your dad's mind. I'm asking you what's going through your mind.
I didn't know it was stolen at the time.
Yesterday, when you were telling the jury about leaving the Faulkners' burning residence, you told the jury that your dad pulled out and he said, "Stay tight on my ass." Is that what he said? Is that what you said?
wanted me to stay behind him
Okay.
in the vehicle.
But that's not what you told Roger Baker, is it?
I don't remember the transcript.
Okay. Would it surprise you to know that you said, when asked if you're following him or is he following you, you said he was following me?
That wouldn't surprise me.
Okay, because as it turns out, when you were in that Suburban by yourself, you took a left and headed up north into Virginia.
And I went the way I was instructed.
Instructed. You went the way that you planned.
My dad planned the way.
And you went along with that plan.
At that time, yes, sir, I did.
Okay. Now, that's not the only statement you gave to law enforcement authorities, is that right?
That's correct.
Because the next day, you met with Detective McPhee and Sergeant Hayes,
Yes, sir.
and you heard them testify here earlier this week.
Yes, sir.
Okay. And they advised you again of your right to remain silent,
Yes, sir.
that you had a right to an attorney,
Yes, sir.
that at any time you could discontinue it,
Yes, sir.
and once again, you made a knowing waiver of your rights. How tall are you, Eric?
5'10".
5'10", and do you weigh about 160 pounds?
I've gained some weight since I've been in prison. Probably weigh 170 now.
Okay, because you were pretty fit when you were before you were pretty fit before, right?
I think I weighed about 150 pounds.
Okay.
Well,
And your dad, he was smaller than you, wasn't he?
I don't know what my dad's weight was.
Well, I'm not asking you if you knew exactly what his weight was, but you knew that he was about 5'7", didn't you?
Yes, sir. I was a little taller than him.
Okay. And you knew that the two of you together still weren't as big as Mr. Jerome Faulkner.
My dad was a Thai fighter in his earlier life.
And you did some kickboxing too, didn't you?
I had a punching bag that I would just work out on.
Did you ever break your foot kickboxing and have to go to the doctor about it?
I don't know.
So again, for Detectives McPhee and Detective Hayes, you recounted the story that evening of the last evening of the Faulkners. Is that right?
Yes, sir. That was all they wanted to hear.
Okay. And Detective McPhee said, so y'all were driving down the road and he told you to turn around because he saw, ? And you said, so we got, well, an elderly man had gotten out of his truck. He was checking the mail.
Yes, sir. My dad explained to me why he chose that house.
Okay. And in response to his next question, he said he got, there was a truck next to the box and he had gotten out of his truck. It was at the mailbox when I had driven by, because you were driving the car, as we have covered, right?
Yes, sir. I was driving the vehicle and it was...
He told me to turn around and he was looking at the house. He was like, told me to pull over to the left, and it was like an abandoned house. He told me to get out, switch seats with him, and he pulled out to there was a field across the street.
Guess so, yes, sir.
Okay. And you go on to say the sun had finally set all the way. And we came up on this guy's house in the back. And Detective McPhee said, so you came up from the back of the house? He said, yes. And you're going to say it was dark in the house, and he went up some of the windows and tried to open them up. Tried the back door, it was locked. And he was going to break in, and he kept saying he needed money, so he was going to break in and rob the place. He wanted to make sure it was empty before he busted out the window. That's not what you told the jury here yesterday, is it?
Those are things that my dad told me, and that's what I thought he was doing when he walked up on that place
Well,
and went inside.
but you said yesterday that you just came up on this house.
I could see my dad's shape from the tree line as he was running up to the house.
And you met him at the corner of the house on the sidewalk outside. Is that what you told the jury?
No, I met him when he was walking down the patio.
The patio. And you said, hey, what's going on? And you said he kind of shushed you a little bit, right?
He didn't want me to even ask anything at all. He didn't want me to talk.
And then he went over and rang the doorbell.
Yes, sir.
And you said you thought y'all were all getting ready to run.
Yes, sir.
Kind of like it was a prank.
I didn't know what to think at the time.
Well, but when you talk to Detective McPhee, it's a different story, isn't it?
Yes, sir. I didn't remember at the time that my dad had rung the doorbell and ran.
Did you remember at the time that when he was going up there and trying to pry open the windows
Yes, sir. That's what he
in the
said.
dark of the night, that he intended to enter that house?
I didn't know he was trying to pry the windows at the time, but he said that's what he said.
You didn't tell Detective McPhee that's what he said.
I know, I was trying to tell him everything I could. I didn't get everything right.
But the point is, it's not about what your dad said. It's about what you saw and what you did.
From what I saw and from what he said, I put together everything I could, and I told him that.
Okay, but you were here yesterday, and you testified after swearing to tell the truth, the whole truth, and nothing but the truth. You told the jury that you were on the patio, that you were at the corner of the house.
Yes, sir.
You were right there.
Yes, sir, I was.
So you weren't telling Detective McPhee what he said. You were telling Detective McPhee what you saw.
I saw from the tree line, I saw my dad go up to the window. I could see his silhouette moving along the back of the house. And when I got to there, he was walking down off the patio.
Okay. While you were at the corner of the house, posted as a lookout.
My dad didn't tell me to look out or anything like that.
But when the car drove up in the driveway, you certainly alerted him to that, didn't you?
He had told me to be out there and look on the driveway.
Okay. As in to keep an eye out. To keep an eye out for an intervening neighbor? Is that right?
Yeah, yes, sir.
One of the many friends that the Faulkners had that would have come to their rescue had they just known?
Yes, sir.
For the sheriff's department, they would have come to stop you if they could?
Yeah, yes, sir. My father, too.
To keep a lookout for them.
Yes, sir.
When you talked to Detective McPhee about the sprayer, he was stunned, wasn't he?
I don't know.
He asked you, do you know what was in the sprayer? And you said, it was water he had put into it that I saw.
Yes, sir.
And Detective McPhee said, just water? Question mark. And you said, no. Later because I asked him about when he was started spraying him. He said he put lye in it.
Yes, sir.
So you are telling this jury that that at the time when you're here, you're telling Detective McPhee that he just put water in the sprayer.
When we were at the campground and I was leaving, I saw him have a water jug.
Okay. But you also told Roger Baker the day before that you knew that he had the sprayer and that you knew he was putting lye in it.
I didn't know there was lye in it till at the house.
You knew that he was putting lye into it because he was going to spray it in their eyes, didn't you?
I never saw him put lye in it.
When you said, because I asked him about it when he started spraying him, he said he put lye in it, it's because you were in the house when he was spraying them there, wouldn't you? Weren't you?
No, sir.
Detective McPhee said lye, L-Y-E, lye, question mark, and you said, yeah. Now, you knew that when he was up there and going to prying up windows, you knew that that's what you were there to do, was to rob that place.
I didn't know he was prying windows. It was too far away.
Detective McPhee, when he was talking to me about this, he said, okay, keep going, please. And you said it was dark in the house. He went up to some of the windows and tried to open them up. He tried the back door. It was locked.
Yes, sir. That's what he explained to me. That's why he said
he was going to break in. He just kept saying he needed money so we could break in and rob the place.
Objection. Objection. Misstating what the
Restate.
He just kept saying he needed money so we could break in and rob the place. I'm reading off the defendant's prepared transcript.
Okay, I'm reading off the one that was done by the court reporter that reads differently. I apologize.
He wanted to make sure it was empty before he busted out a window. So he went to the front door and he knocked on it. A porch light turned on. He had a crossbow in his right hand and a wand in his backpack.
yes, sir.
So when he walked up to the house and you walked up there with him, you knew that he intended to break into that house.
Not at the exact moment.
But that's what you told Detective McPhee.
I was trying to explain to him everything that happened and why it happened, and everything that my dad told me and what I thought I knew.
But you're not saying this is what your dad said. You're saying this because you were there.
If I got it wrong, I didn't mean to.
You were there on the patio.
I was not on the patio. My dad walked down off the patio, walked by.
Did you ever walk on the patio?
No. No, sir, not when he was first walking up to the house.
Okay. But at some point, you agree that you were posted up at the corner of this house, right?
I was following my dad. I wasn't put up as a lookout or anything like that.
Well, that's what your job was, wasn't it?
No, I don't know what my job was at that time. My father didn't give any kind of notice of what was going on. I knew that he was talking about robbing and from earlier times that we had spoken in the day, but we had agreed that we would discuss it in the morning what we were going to do.
Okay, so you said we would agree. And the reason you said that is because you knew that your father would listen to you.
I could reason with him, yes. He was usually more reasonable in the mornings.
He was usually more reasonable in the mornings.
Yes, sir.
Okay? Because the fact is that your dad listens to you from time to time, doesn't he?
Yes, sir. That was part of my goal of going with this trip, was
Okay.
for him to listen to me.
But with respect to what you knew, in the moments before the Faulkners died, you knew that he had a sprayer
Yes, sir.
that was filled with lye
Yeah. Yes, sir.
in a backpack, pumped up just as hard as he could get it,
But I never saw him pump it.
to the moment that as soon as he pushed that button, that caustic fluid would come rushing out of that wand. You knew that, didn't you?
I didn't know. I didn't see him pump it. I didn't know there was lye in it at the time when he was walking up to the house.
Well, it doesn't work without pumping it up, does it?
I never saw him pump it.
You knew that he had a crossbow.
Yes, sir, I did.
You knew that he had been riding down the road with you driving, and that you had seen Mr. Faulkner at the mailbox, and he told you that he wanted that truck.
That's what he explained to me, why he had chosen that house when we're inside the house.
So when he went up to that house in the dark with a crossbow and a sprayer
Yes, sir.
and started trying to pry windows open,
He told me that before we were inside the house that he had tried to get in through a window. Pry through a window.
okay, but it's not what he told you. You were right there.
I was not right there when he was
By
at the
your very
windows.
own words, you testified to this jury yesterday that you followed him through the woods.
Yes, sir.
You said you were having trouble keeping up with him.
Yes, sir.
Despite the fact that he's 5'7", smaller than you, 30 years your senior, you were having trouble keeping up with him.
Yes, sir, I was.
Okay? Now, yesterday you testified that your dad rang the doorbell and Mr. Faulkner came to the door. Is that right?
Yes, sir. He did. I could hear a male voice.
regar-
I could hear a male voice. Yes, sir.
Okay. And regardless of whether you rang the doorbell or knocked on the door at this point, the fact is the door was opened. Is that right?
This is the first time the doorbell was rang, right?
Well, let's assume it's the second.
I'm lost. Repeat your question, please.
Well, I guess let's go back to what you told Detective McPhee. Detective McPhee says, brought the sprayer and lye. Okay, all right. And so you knock on the door and the light came on. And you said, and the guy opens the door and asks him, can I help you?
Sir.
And my dad says, my truck's broken down, can I use your phone?
Yes, sir.
And he asked him a couple of times. The guy hadn't opened the door. He was asking him through the window.
Okay.
And the reason Jerome Faulkner didn't open the door is because, as we talked about yesterday, you were strangers to him.
He had opened the door. He had answered my dad that he would let him use the phone.
Okay? And so you're saying that he let your dad in, who was carrying a crossbow in one hand.
I don't think he saw
and
those
in fact,
things.
You don't think he did,
No.
but you saw them, didn't you?
When he started to walk in, yes.
You saw them. You saw them as you walked up to that house. Is that right?
I knew he had a crossbow, yes, sir.
Okay. And you knew that he intended to rob the Faulkners?
When he's walking through the door with a crossbow, yes.
You knew well before that, didn't you?
No, sir.
And you said, and the guy opened the door and let him in.
Did.
Now, Detective McPhee says, when you say you heard some screaming, do you know who was screaming? You said, it was a woman. And he said, okay. And Mr. Campbell, you say, and they kept saying, please, God help us, God help us, and over and over again. And I heard my dad screaming at them, you know, be quiet. And I heard a gunshot. And my dad came outside 5 minutes later, and he started yelling at me about why I didn't back him up. And that's basically the story that you recounted yesterday, is that right?
I believe so, yes, sir.
That your dad walked in there with his backpack sprayer, pumped up with lye, and a crossbow, and Mr. Faulkner welcomed him in the house,
No.
shut the door, and 5 minutes later is when you get brought in. Is that right?
I think Mr. Faulkner knew when he opened that door.
He didn't,
He did.
but you did.
I didn't know he was going to hurt those people.
When he came back out and got you, you said, and he grabbed me and he pulled me inside and he sat me, took me into the bedroom that they were in. And Detective McPhee said, all right, when you walk in, do you know which bedroom that was? You said, yes, the main, the bedroom on the left.
Yes, sir. Yes, sir.
When you walk in, it was the bedroom on the left.
Yes, sir.
And you saw Special Agent Matt Bivens testify here earlier with his diagram. That's exactly where that bedroom was, wasn't it?
Yes, sir.
It was the first door on the left.
Yes, sir.
And he put me against the wall, and he took the crossbow and reloaded it.
Yes, sir.
But why did he need to reload it, Detective McPhee asked you. Was it loaded when he went in the house? And you said yes.
Okay. It had to be loaded because of the arrow in a guy's chest.
It had to be loaded because that's what you saw as he was standing there walking in that door.
It was dark at the time.
You said
was.
the lights went on.
It probably was loaded. Father probably did load it.
Can you speak up?
Yes, sir. It probably. Yes, sir. It was loaded.
It was loaded.
Yes, sir.
Those porch lights went on. And you could see clearly what your father had in his hands.
Yes, sir.
And stretched over your shoulder was a camo bag with a spotting scope. Is that right?
No, the telescope. Yes, sir.
Okay. And an antique spear,
Yes, sir.
some electrical tape.
I didn't know what else was in the bag. I just took a quick look in it to see what I was carrying.
He said, and he put me against the wall, and he took the crossbow and reloaded it. We talked about that, and you said, and the man had an arrow sticking out of his chest, right here, because you were showing him where that arrow was sticking out of his chest.
Yes, sir.
Detective McPhee says, okay, when you went in the room, he had an arrow sticking out of his chest, and you said, mm-hmm. And Detective McPhee said, okay. You said he was clutching at it. His face was beat up, and he was lying on the floor. He had a wound on his leg. And you go on to say, and the woman was still screaming, and he took the crossbow and shot her.
Yes, sir.
So at the time that you were in that house, Jerome Faulkner had been shot with his crossbow. And you're telling the jury, as you said yesterday, and as you told Detective McPhee, that your father pushed the stirrup of that crossbow against the floor and put his foot in it and used both hands to pull that string back. Is that what you saw?
I don't remember him reloading it, no.
Well, he took one crossbow bolt and shot Jerome Faulkner Sr. in the chest.
Yes, sir.
Is that what you presume? Is that what you know?
Yes, sir.
Okay. And so the crossbow at that time was unloaded. Because you can only shoot one at a time, right?
Yes, sir.
And you're saying you're in the house, and she hadn't been shot yet, and he loaded it.
I know it says reload, but yeah. I didn't see him actually load the crossbow, but you have to load it to shoot another arrow.
But you're in this bedroom with her and your father.
I was.
And you're up against the wall. And the lights are on, right?
Yes, sir.
And this wasn't some mansion up on the hill, was it?
No, sir.
Just a simple home with two folks in it, and you could see very clearly through that bedroom what was happening.
Yes. Yes, sir.
And you said that he shot her. Where's the part where she gets the gun out of the top of the dresser and shoots you with it, or shoots your dad?
My dad said he had disarmed her when he ran in on her.
Your dad walked back out of the house and got you.
Yes, sir.
And Dora waited on the bed for you to shoot her, and for your dad to shoot her with a crossbow?
I don't know what my dad did to her.
Well, but she was not tied up.
No, sir.
And there was a struggle that you say lasted at least 5 minutes. Is that right?
That was a guess. That was a guess. Yes, sir.
But when you came back in, she was crying.
Yes, sir.
Not injured.
I don't know. I don't know.
Well, the injuries that Dora Faulkner sustained that led to her death was where her skull was bashed in by an antique spear, right? Or the butt of a crossbow.
Don't know.
Because pieces of that crossbow were stuck in her skull.
Oh.
So,
Yes, sir.
again, Eric, why didn't she pull out one of the many guns that were in that house and shoot you or your dad?
I don't know.
You said the spear was a break-apart spear, is that right?
Yeah. Yes, sir.
And that's the spear that you carried to the home
Yes, sir.
in this camo backpack.
Yes, sir.
Can I approach?
Yes.
Eric, I'm showing you what has previously been marked and admitted into evidence as State's Exhibit 497. Is this the shoulder bag that you walked up to the woods with? Is that right?
Yes, sir.
You walked up to the Faulkner's house, and the collapsible three-piece spear that you had, that you said was in here, it was sticking out of this bag. Is that right?
I guess so.
Okay. And when you put that bag on your shoulder, the shoulder strap was not like this, was it?
No, sir. It was just a normal bag.
All right, it was a normal bag with a black strap, right? And it did not have the bleaching from the lye, did it? Because that's what this is, isn't it?
Yes, sir, that is.
It is. And it's got that right there because you wore it into the house that way, right?
My dad took it from me, sir. I don't know how it got lye on it from him.
Have you ever seen that symbol before?
I haven't.
Okay, would it surprise you to know that that is a symbol for Texas Energy?
Yes.
Okay. Why we got this out? Do you recognize that?
I don't.
Isn't that a piece of the crossbow?
I don't know. That is.
That is, isn't it?
Yes, sir.
That's the back of the shoulder stock.
Yes, sir.
And this is the bottom of the shoulder stock, isn't it?
Yeah, yes, sir. That is the same plastic.
You said, so he went into your back, so Detective McPhee said, so he went into your backpack and he got the break-apart spear. And you said, mm-hmm. Said, okay. And he started trying to bash your skull in.
Yes, sir.
But that's not the debris that was found up in Miss Faulkner's skull, was it?
I was just telling you what my dad told me, what he did with that thing.
I'm not asking what your dad said because you've already told the jury you were right there when it happened.
I wasn't watching what my dad was doing. I was looking at a man that was on the ground dying.
Okay. You said just trying to, he was trying to cave her skull in. You didn't watch that?
No, that's how my dad said he was trying to do.
Detective McPhee said, okay, but he wasn't hollering anything, and you said, nope. After the wife went limp, he walked over to the husband and took a spear and stood over his head, grabbed it with both hands, and impaled it downward into his neck. Is that what you said?
That's what he explained to me.
But that's not what you told Detective McPhee.
It sounds like I said it in first person. I know that.
It does. And the reason why is because you were there.
I was not there when my dad was doing those things to those people. I was in the office and he explained all those things to me.
Detective McPhee said, okay, all right. After, well, obviously he was dead at this point, or at least very close to it. What occurred after that? And you said, we walked out of the room, and then we walked around the house. And Detective McPhee said, mm-hmm. And you said, walk back in, the guy was still gurgling, wheezing. And Detective McPhee said, right. And he said, and he took a plastic bag and put it over his head. Is that a fair and accurate statement?
My dad walked back in there. He complained about the guy not dying. He walked by me with a black bag.
But what black bag?
I don't know.
Okay. But you didn't tell Detective McPhee that's what your dad said, did you?
No, I didn't.
Because that's what you saw.
I tried to tell him everything I could.
Okay.
And there are some things I got in the wrong order. I know that.
So you got some things in the wrong order.
I tried to tell him everything I could.
Now,
Everything.
you testified, or you told Detective McPhee later, I was in the office going through things and he brought me a plate. And I didn't eat it. I took a bite and then, I don't know if it was just the smell or something, but I almost threw up. And I ran out of the house. I walked to the truck, the distance, and I got in. And I just sat there. After a while, I fell asleep. And I woke up to him, waking me up and telling me to come back to the house.
So,
Now, you testified yesterday to the jury that you pulled this Suburban up into a field at a power line easement. Is that right?
yes, sir.
And that you had a long walk and run through the woods to the Faulkner's house.
Yes, sir.
And you told Detective McPhee after your dad brought this plate to you and you couldn't eat and you left out, you took that long walk back to the Suburban.
No, sir.
Well, that's what you told Detective McPhee.
The Suburban wasn't out in the field. It was at the house.
So you had gone back and moved it.
No, sir. It was at the house after when we came back from Walmart.
I'm not talking about after you came back from Walmart. I'm talking about before.
That happened after we came back from Walmart.
You went to sleep in the Suburban after you came back from Walmart.
I don't know if I can call it sleep. I was sitting in there and I just was staring off. Not really even there in the best way I could explain it at the time. I didn't understand what it was or what else to call it.
You didn't tell the jury yesterday that you went to sleep, did you?
No, sir.
And you said in your statement to Detective McPhee, I walked to the truck the distance and I got in.
Yes, sir.
Now, this was another opportunity for you to leave, right?
Yes, sir, it was.
It was. It was another chance for you to leave and alert the authorities.
If I thought that I didn't think I could get away from my father. If I believed I could have.
You had a Suburban.
Yes, sir.
You had the advantage of surprise.
My dad didn't know what to do with me when we're at the house. He couldn't decide.
What do you mean you couldn't decide?
Just tell when I was in the office and he was looking at me, he was weighing my actions and things I didn't do, and I don't know everything that was in his mind.
Well, at the point that he slapped that .22 pistol in your hand and said, "Take this," you can assume that he wasn't planning on killing you anymore, right?
He put it in my pocket.
He put it in your pocket. He put it in your pocket. He gave you a gun. One
Yes, sir.
that he was loaded, that was loaded.
Yes, sir.
One that already had replaced the cartridge that fired the bullet into Jerome Faulkner's leg. So just in case 5 shots wasn't enough, you had now 6.
I'm not the type of person to shoot people.
But if you weren't the type of person to shoot people, you still had a Suburban, some gas, the keys.
Keys?
Yes, you had those things, right?
I don't know.
Well, you told Detective McPhee that you had them at the Faulkner's house.
Yes, sir. I was
And
not.
you had it at Walmart.
Yes, sir.
You were sitting in the parking lot and you saw your dad walk through the 2 sets of glass doors into a Walmart that was about to close.
I didn't see him walk through the glass doors. I remember sitting in the driver's seat and I was staring at the steering wheel.
You didn't
No.
You didn't drive away, did you?
I didn't drive away because I was scared my father was going to come back out and start shooting. And even if I did drive away, he would have killed somebody in there and taken their car.
Well, you weren't concerned about him killing the Faulkners, were you?
I didn't know he was going to kill the Faulkners.
You recounted to Detective McPhee about that gun, that .22 pistol, and what you did with it, didn't you?
I guess so. Yes, sir.
You said, "I ran 300 feet into the woods in between the highways and I just stopped. I sat there for about an hour. So I had the gun in my front jacket pocket my dad put there."
Yes, sir. Yes, sir.
And he asked you, "Do you know where the gun that he put in your," and you interrupted, he said, "Yep, it was the owner's." And Detective McPhee said, "The people that were in the back of the truck, okay?" And you said, "I took that gun and I lifted up a rock and I put it in there and then I smashed the rock on top of it. And I started making my way, started back walking towards the scene." But that's not exactly what you did, is it, Eric?
No, there was other items.
There were other items. And those items, just like the gun, you moved leaves out of the way. Is that right?
I don't remember any of the other items besides the gun.
Okay. You made a deliberate decision to conceal the other items, didn't you?
I don't remember anything else besides the gun.
Can I approach?
Yes, sir.
Mr. Campbell, I'm approaching you with what's previously been marked as State's Exhibit number 90. You take a look at that. And I'm showing you what's previously been marked as State's Exhibit number 98.
Yes, sir.
You see them, don't you?
Yes, sir.
And State's Exhibit 90 is a hole in which Senior Trooper Wade recovered a significant number of things that belonged to Dora Faulkner, right?
Yes, sir.
And State's Exhibit 98, that's Miss Dora Faulkner's pocketbook, right?
Yes, sir.
And it's under a log, right?
That's what it looks like. Yes, sir.
And it's got some leaves pushed up against it.
Yes, there's leaves in the picture. Yes, sir.
And it's concealed.
Yes, yes, sir.
And it was more than just the gun that you concealed up there, right?
I just remember the gun.
But you made deliberate decisions to do this, didn't you?
I don't know if I made deliberate decisions to hide those items. I don't remember them.
Well, those items were evidence, right?
Along with everything else in both vehicles, yes.
And you're saying you don't remember, but you told Detective Fee you remember, didn't you?
It's a gun.
With respect to the gun,
You know.
you told Detective McPhee said, do you remember what any of it was? And you said cards, just a pile of cards.
Doors.
He said, I didn't look. Well, what about anything else that you took from? Did you take anything else from the truck when you got out? He said, yes, there was stuff in the jacket. Was that pocketbook in your jacket?
I don't remember it being in the jacket.
He said, I buried that stuff with the gun. He said, there was, I don't know if there was litter with it, I just took everything that was in the jacket and I just threw it down on the ground.
Yes, sir.
But that's not what you did, is it, Eric?
From the pictures, no.
Okay. Not from the pictures, from your recollection, right?
I remember the gun.
You remember the gun. But you were making a deliberate decision to conceal evidence.
I don't remember it being anything deliberate.
Because when it came down to it, you could make a decision that was going to help save you.
Oh, like I said, my dad had just shot at people. I wasn't thinking of anything like deliberate.
Now, Detective McPhee, just like everybody else, was curious as to how this started. And you said he wanted to get out of Texas. He didn't like that state. And it started out as a camping trip, just staying once we got on our way. He started talking about money and stuff, and once again, you're letting Detective McPhee know, just like you let Roger Baker know, that long before you got to this patio, you knew what your father's intentions were.
I didn't know my father's intentions were at that house.
You said he started talking about money and stuff.
Yeah, he talked about money, talked about Holly, the kids, finding a job, living on the land.
Matter of fact, he talked about lots of things, didn't he?
Yes, sir. He had a tendency to ramble.
He had a tendency to ramble. He just talked.
That's what I thought it was, just talk.
Your dad's the kind of guy you can have margaritas with.
Yes, sir.
Now, how long did it take you to get from the Faulkner's residence to Walmart in Oxford? Do you remember?
I don't.
If you told Detective McPhee 20 to 30, would that surprise you?
Okay.
Okay. And you arrived just before midnight at Walmart, right?
Yes, sir.
Okay. And when you arrived at Walmart, the Faulkners were dead.
Yes, sir.
Now, one thing they didn't find in the wood line up there in West Virginia was the walkie-talkie, right?
No, sir.
They didn't. They didn't find it because you hid that a little bit better.
No, sir. I don't remember if I had a walkie-talkie or not.
Well, you and your dad were communicating with walkie-talkies, weren't you?
Not after the Faulkners. There was a walkie-talkie that was lost.
Okay. Well, in the Suburban, there was a manual for a Cobra walkie-talkie, right?
Yes, sir.
And there was a charger for a walkie-talkie, right?
Yes, sir.
And there was a walkie-talkie, right?
Yes, sir. That was in.
And as a matter of fact, the charger had two different bays for two walkie-talkies.
Yes, sir.
Because a walkie-talkie without another walkie-talkie, what's it good for, right?
Yes, sir.
And you were in the same car together before the robbery
Yes, sir.
and murder.
Yes, sir. Yes, sir.
And afterwards, your dad got in that red truck, right?
Yes, sir.
And he got in there with a walkie-talkie.
I don't know if he had it or not.
Well, that's how y'all were talking to each other as you went down the road, right?
The walkie-talkie was lost. If my dad had a walkie-talkie, he would have told me to do something when we were stopped by the cops.
Well, you've seen all this stuff here, right?
Yes, sir.
And you don't see two walkie-talkies, do you?
No, sir. There was only one.
There was only one.
Yes, sir.
Because sometime after the Faulkners, the other walkie-talkie disappeared.
Didn't know where it was, sir.
You knew where yours was, didn't you?
I didn't. I know it was sitting right there in the center console, but I don't remember seeing it there.
Right beside the driver's seat,
Yes, sir.
in front of the radio and the air conditioning.
Yes, sir. When I saw the picture of where it was, because I remember my father, we stopped at one of the mountain trails, and my father had wanted to find the walkie-talkie.
Well, you had two walkie-talkies. You had two walkie-talkies when you were in the Suburban before.
Yes, sir.
And the reason why you would have two walkie-talkies is if your dad got away or you got separated somehow, you had a way to communicate with each other. Is that right?
Yes, sir.
And you communicated via walkie-talkie because you did not want to use a cell phone, did you?
I don't know why my father got walkie-talkies, but we did buy them, yes, sir.
You wanted a walkie-talkie because you did not want a cell phone signal to go up and alert anybody else in the world who was looking for your father as to where the two of you might be.
Walkie-talkies can be used. You don't need to recharge them with minutes or anything. You just...
Now, you arrived in Granville County that day from Hillsborough, North Carolina. Is that right?
I believe so.
Okay. You spent a couple days in Hillsborough.
Yes, sir.
You went to the Walmart a couple times.
Yes, sir.
And you spent some time at a place called Huff Road, didn't you?
I don't recognize the name. I know there was a letter and evidence that said Huff Road.
There was. It was a letter of evidence that said Huff Road. Do you remember it?
Yes, sir. I remember seeing it.
You remember seeing it?
Yes, sir.
And it was taken out of the Suburban.
Okay. Yes, sir.
And you knew why you were at Huff Road, didn't you?
I don't know where Huff Road is.
Do you know why you were at Huff Road?
I don't know where Huff Road is, sir.
Well, you stayed there for 3 days, didn't you?
We camped at a different spot each night. Yes.
But you visited Huff Road, didn't you?
I don't know where Huff Road is.
Your dad gave you directions how to drive there, didn't he?
Yeah, I remember him telling me to go left or right. He was wanting, it's one of his objectives at the library. He wanted to find Holly.
He wanted to find Holly.
Yes, sir.
Why were you in Hillsborough to find Holly?
I wasn't particularly too curious when asking that. I knew she was most likely still in Texas.
You thought she was most likely still in Texas.
Yes, sir.
So why were you in Hillsborough looking for Holly?
I don't know. I didn't particularly care to ask my dad. He seemed like he was doing better.
You didn't have to ask your dad, did you? You knew.
I knew he wanted to find Holly, but...
And you knew why he might find Holly in Hillsborough, right?
No.
It's because John Hilson lives on Huff Road, doesn't he?
I guess it's the email said that John Hilson was her friend, but I don't know how good of friends.
Do you remember meeting him at your parents' wedding?
I don't.
Do you remember him coming to visit with you and spending a few days?
I don't remember him.
Do you remember your lawyer asking her about how few friends she had?
Yes, sir.
Okay. And that they regularly exchanged emails?
I guess so.
And you knew that when you were driving to Hillsborough that your dad was looking for Holly?
Yes, sir. It was one of the things that he would talk about.
The stack of passports you had in your vehicle, they came from John Hilson's house, didn't they?
I didn't know they came from his house until they were brought up here, and they said some deceased woman's passports.
But you know now, don't you?
Yes, sir, I do.
You know that they came from the inside inside John Wilson's house?
Yes, sir.
Now, yesterday, defendants 35 and 36, they were a recorded conversation between you and your brother Nick and your father at the Brazoria County Jail, right?
Yes, sir.
If I could retrieve defendants 35 and 36.
Yes, sir.
Can I have the note? Your Honor, if we could take a break just for a moment to allow me to get a couple links up.
Okay, ladies and gentlemen, we'll take our morning recess at this point. During our morning recess period, it is your duty not to talk among yourselves about this case. It's your duty not to talk to the parties, the witnesses, or the lawyers about anything at all. It's your further duty not to talk to anyone else, to allow anyone else to talk with you, to say anything in your presence about this case. If anyone communicates with you in any way, you let the sheriff know about it when you come in. Don't do any individual research or investigation of your own about any issue touching on this trial. Stay away from your smartphones. And do not form or express any opinion about this case during this time. With that, while everyone else will remain seated, I'm going to excuse the 17 of you and ask that you return and assemble in the jury room at 5 minutes after the hour of 11. Again, we go by that clock. You are excused.
And that was Eric Campbell testifying in his own defense. I'm joined by Deborah Bloom, who is the LawNewz trial analyst. What did you think of his testimony this morning?
I think that he is testifying incredibly well. I think he's being really respectful to the prosecutor. He's saying, yes, sir, no, sir, I don't recall. I believe what he's saying.
You know what, though? There are a lot of people in our chat room, and a lot of them think that he is putting on a complete act. Is that possible? Is that something that you've seen before? And how can anyone really tell whether he's being genuine or not?
Well, that's the issue, is that he could be putting on a complete act. We don't know. We don't know him from before this occurred. We don't know if this is his personality. Maybe he's acting meek and very fearful and afraid just as an act, or perhaps this is a genuine expression of his emotion. And he doesn't recall a lot of things. The prosecutor is trying to ask him questions that would show intent, that would show that he knows where certain things were, what address they were going to. And then the defendant is trying to say, no, I don't recall. So what he's trying to do, or what his words are showing, is that he was just the person that was following his father, and the prosecution is trying to show that he in fact knew what he was doing.
Right, but there's a lot of discrepancies in the story that he's telling now on the stand. This is something that the prosecutor pointed out, and what he told to the police, and the prosecutor's actually reading word for word what he told the police and saying, well, that's very different from what we heard before, so essentially trying to accuse him of perjury. How big of a deal is that?
Well, I think there are two ways that you could spin that. As his defense attorney, you would say, look, at the time this occurred, it was all very new. The prosecution would say, well, this is what was freshest in his mind at that time, so you should believe what he told the police when he gave this initial statement. But his defense attorney is going to say he had just gone through a very startling and traumatic experience. His father viciously murdered people. He knew that he was going to be on the hook for his father's actions just by being there, not because he wanted to participate or had any intention to commit any of these crimes. So he was very startled when he was speaking to the police. He wasn't in the proper state of mind. So now that he has the benefit of time and, you know, having been in a jail cell or wherever he's been, he's been able to think this through more clearly. So he's able to tell you more clearly now what occurred at that time. So both sides will take their spin on it.
Yeah, and you know, he's saying a lot of, I don't know, I don't remember, but that's, like I said, that's conflicting with some of the testimony that he gave to, or admissions that he gave to the police, where he did know exact details. Now he's saying that he's not so sure. And in fact, like, some of his answers are total opposite of what he told the police. Is that going to hurt him? And this is sort of the same question as before, but what I'm curious is, how much does his emotional delivery, let's say, impact the jury versus them wanting to hear him tell everything fact by fact in a very literal and accurate way? What's more powerful?
I think that it's really up to each individual jury to make that determination, and each individual juror is going to weigh it and say, you know, he's said something different to the police when this first occurred, and now we're hearing him testify and he's saying something different. But is that because he was in such a shocked state when he gave these statements to the police that he just couldn't remember everything, and now he's had time to reflect? Or are they going to go with what the prosecution is going to argue, is that he's now crafting a story that will make things better for him, and he's had the benefit of time, so he's had the benefit to think about what his answers are going to be, and that's why he's answering the way that he is, and he's saying, I don't recall, because that suits him. But the defense could spin it the other way.
Yeah, absolutely. And so when he's, you know, he's being very emotional, he's hanging his head and he's muttering a little bit, mumbling and giving very short answers. Do you think that's convincing, that's a convincing presentation? Or do you think that it's more likely that he's just playing the part?
Well, the number one thing that I tell my clients is that during cross-examination, if I was the one that called them on direct and they're being cross-examined, that they don't have to give very elaborate answers. Only if it's really going to help them to explain. It's always better to say yes or no, or to just give a very short answer. So he might be following his defense attorney's advice, or he might be genuinely not recalling things and he doesn't want to perjure himself. So I happen to think, we've been sitting here watching this for a while and we've been listening, and I think he sounds believable.
Certain admissions that he makes, which when you listen to him, you almost feel like he feels like he has to admit some things. There are some people that go up there and they'll just deny all day long. I find him more convincing when he admits things, but do they hurt him? For example, when they say, you know, you knew that he was bringing a spray bottle filled with lye into the house. He says, yes, sir, I know. Now, he doesn't admit that he knew. When he knew, that becomes a point of contention. But when he says that he knew that he was carrying a crossbow, that he knew he was going to rob the house, I mean, how much does that hurt him?
It definitely doesn't help him. I think that it would be foolish as an analyst to say that those are things that are to his benefit. You know, he was aware that his father had things that could severely injure people. Again, I don't think that he thought that his father was going to murder these people, because if you believe what he says, that he was the victim of his father's abuse his whole lifetime, he knows that his father is capable of abuse, but the father didn't kill him or the other loved ones that he abused. So this boy most likely really didn't think he's going to go in and kill these people.
Do you think it's a good strategy by the prosecutor to try to establish that Eric Campbell in some ways was leading this entire crime? Basically, he was ahead of his father driving in the car. He said that he could reason with his father. Sometimes his father listened to him. So it seems like they're trying to almost make Eric Campbell have a much larger role than what we had initially thought. Is that effective?
I don't think that that would be effective here, and that's not necessarily my takeaway in what they're trying to do.
What do you think they're trying to do?
I think that they're trying to show that he understood what was going on. It's not that I think they're trying to say you were the leader of this crime, you were the one that took all of the deliberate steps and planned them out, but you understood what was going on, and you understood exactly what was happening. And yes, it was only over a very short period of time, but you saw that these people were being brutally murdered and you did nothing about it.
But also trying to show that he had influence over his father, so he could have potentially stopped it. How does the defense counteract that, and is Eric Campbell's testimony enough to show that he couldn't in fact influence his father?
Well, I think that the presentation of this young man is someone that's very humble, meek, respectful, someone that's not going to get very excited. You know, I've had clients that are very animated, and when they do testify, which again is a very hard decision, they're very animated during their cross and their direct examination. So this man is sitting there very quietly. He's showing signs of someone who perhaps has been abused, but you know, it's hard to say because this is a murder trial. His life is on the line. So I think that the defense strategy is just to have him explain that I had no control over my father, and my father is a vicious man, and even if I could at times exert some kind of power over him to make him stop his terrible thoughts and terrible crimes that he commit, I couldn't always do that.
What's more important here, establishing that Eric Campbell had the intent to commit the crimes, or just establishing that he aided his father in doing so?
I think both.
Because what do you think, though, will weigh more heavily towards an actual conviction?
I think that the intent, because then all of the jurors are able to say he thought this through and he understood what he was doing, so we can hold him accountable for this. Whereas the aiding his father, I think then that your own individual experiences and human nature and feeling empathy for another human being would step in, and the jurors might not be as likely to convict.
But it's a lot harder to establish that intent, that mens rea, as you're saying, than it is to just establish that he assisted him, because he's basically admitting to assisting him with a lot of things.
Right, well, that's why I think the prosecution is channeling a lot of their questions the way they are, to show that this was a deliberate act, that there was a plan in place, that he was aware of the plan. So those things would go towards establishing intent.
You know, I was surprised when he said that you knew that he brought in this bottle filled with lye that he was going to spray into their faces potentially. You knew that he was carrying a crossbow. You knew that he was going to break into the house. I was surprised that the prosecutor then didn't follow that up with a question that said, didn't you then know that somebody could get killed or seriously injured?
Well, the prosecution could ask that question, and then his answer would be no, and then you lose the right to argue that in summation when you say, you know, somebody that goes in with all of those things, including a bow and arrow, you know that they are going in to commit a crime and potentially could kill someone. So sometimes you have to follow the rule. Don't ask a question you don't know the answer to.
Yeah, and so what did you think when Eric Campbell started showing some tears? Was that something that moved you, or did you think it was timed correctly? Did you think it was natural? Did you think it was an act? What was your take on that?
You know, I think that every person is different, and it's really hard. We're not physically in the courtroom, so it's one thing to be watching it live the way that we are, but sometimes you need to physically be there to really see the person, to really get a glimpse of their movements. But I think that these are genuine signs of emotion, and this must be extremely emotional for him. He's had to walk the jury through his entire childhood and young adulthood as somebody who really has a horrific life.
Yeah, and you know, a lot of our bloggers were saying, and rightfully so, sometimes when a defendant takes a stand like this and you're listening to the defense's case about him and his circumstance, in those moments, really the victims get lost. And so it's important to remind everybody that 2 innocent people were killed in a very horrific way. And of course, though, that comes out in other sections of the trial. But I want to thank you so much for being with me. I really enjoyed your insight. And we're going to toss right now back to a replay from today of Eric Campbell taking the stand on cross-examination in his own death penalty murder trial.
So yesterday, when you were kind of acting befuddled about this white Suburban, the truth of the matter is you knew that he was entirely without resources, didn't you?
While he was camping, he wanted to stay in the state park. I mean, your resources have to be brought with you.
All right. Well, Sergeant Baker said, hold up, hold up. The stolen vehicle is the least of your worries right now. I don't care about the stolen vehicle. Where did he get that vehicle? He said, he told me he got it from Huntsville. Sergeant Baker said, Huntsville? He went down, and I'm sure you told you it was stolen. He said, once we had left. But you knew from the time you saw it, it was stolen.
No, sir, I've never seen a stolen vehicle before.
Right, but your dad was up there dependent upon you for food.
Yes, sir.
Communication.
Yes, sir.
Money. Your dad was not going to use a credit card up there, was he?
I don't know. I wouldn't think so, no.
Well, you wouldn't think so because he did not want to have a credit card transaction for anybody to know where he was.
Yeah, that makes sense, yes, sir.
And you're well aware of that.
Yes, sir.
He didn't even want to have a cell phone.
Yeah, he was paranoid.
Well, he was paranoid, but he was thinking that if I have a cell phone, I'm going to give away my location. Is that right? And he told you that.
I guess so, yes, sir.
And because of that, you continue to aid him by being his pipeline for communication for all kinds of messages. Is that right?
I didn't see him after I dropped him off in the forest. Next time I saw him was at that field next to the airfield.
Okay. And the time you saw him after that was at your brother's house?
Yes, sir.
And y'all were in the Nissan?
My dad left with me in the Nissan.
Okay. And you had gotten everything on that list that he'd asked you to get, right?
That and food stuff and other things. Yes, sir.
Okay. And you went and got the Suburban because you wanted to have a vehicle that if things turned out a certain way, you could ditch it. Wasn't yours, was it?
I don't know what was going through my dad's mind when he picked the Suburban.
I'm not asking you what's going through your dad's mind. I'm asking you what's going through your mind.
I didn't know it was stolen at the time.
And that was Eric Campbell today being cross-examined. I'm here with Beth Karras. You know, what do you think about this decision by the prosecution to go after the death penalty, and how influential is his testimony in counteracting that type of a harsh penalty?
You know, I don't think he's going to walk away from this, no way, but actually his testimony may mitigate and may save his life. It's such a heinous crime, what they did, that I understand why the prosecution went after the death penalty, but having a death qualified jury helps to ensure a conviction, because people who say they can impose the death penalty under certain circumstances, you know, tend to be a little more pro-prosecution. That's kind of an argument defense lawyers will make frequently regarding death-eligible juries. So they're probably going to get a conviction. It's horrendous what this crime spree was, especially what involved just the Faulkners.
Right, but you know, like historically, when they have cases like this, let's say with the felony murder rule, I don't think I've ever seen a case where people who have assisted have actually qualified for the death penalty. It's usually the killer.
Well,
because to make that leap, you know what I'm saying? To leap from, you didn't actually do the killings, you'll be responsible for them, and you'll be responsible for the way that they were done.
Yeah, okay, well, it does happen. It is an argument that the defense will make saying, look, he didn't pull the trigger, he didn't stab, he didn't strangle, whatever. And that's a successful argument sometimes, but it doesn't prevent people from getting on death row.
Right.
As long as you are a participant in the crime and it had the same state of mind and all. But this is something this jury will be grappling with, because they're going to weigh this testimony. Look, he's got the most to lose here. I don't know what corroboration there is for his testimony. I don't know if the defense intends to call anyone to say, yes, I was a family friend or relative. I saw the abuse this young man went through as an adolescent, as a teen. You know, yes, I saw the meth lab that, you know, the father was running, and he was making people in the family participate in it. I don't know if it's just his word.
Well, it seems like the prosecution's strategy because they don't have anybody to corroborate or discredit him, is to basically use his own words against him. And so they're reading the police statements of what he told the police, and then they're saying, well, that's not what you're saying today.
Right.
And he's saying, oh, well, I don't remember, I'm not perfect, maybe I didn't get it wrong. It's kind of like this sappy. Is that a believable excuse for perjury, for a perjury claim?
Well, you know, he's had time sitting in a jail cell to perfect his story, to work with his lawyer. I'm not saying the lawyers are supporting perjury, but they work with him to help shape his testimony. And we see people who sit in jail cells change their story. We saw Jodi Arias come up with three scenarios ultimately. So he may have developed this over time. He should have been truthful at the beginning. Of course, his father was alive at the time, and who knew what if he was really fearful of his father, even when he was talking to the police. But it is an argument that the state can make that this is a recent fabrication. He's tailored his testimony now to be most favorable to him.
Yeah, but when you're trained as a prosecutor, I mean, basically you're trained first and foremost to undermine people by using their words against them, by showing that inconsistency. So when you have someone here who's a very sympathetic person on the stand, who's young, who was under, well, potentially, his claim is he was under the influence of his father, and that's not working. That strategy's not working. Where do you go from there as a prosecutor?
Well, I mean, I was a prosecutor for 8 years, and you know, we were trained to ferret out the truth. However you do it. You know, I didn't always assume that everybody talking to me was tailoring their testimony, or that everybody who testified for the defense wasn't being truthful. But you know, you do have to be familiar with every statement they've made, and challenge them to try to find out what the real story is.
Great. Well, thank you so much. You know, Campbell is back on the stands right now being cross-examined by the prosecution, so we're going to get right back to the courtroom.
Yes.
Now, going back about 1 minute into that recording, if you could tell me who's speaking now.
Okay, go to Sharp then. Give it to Sharp.
Who said we need a bond reduction?
It didn't sound like me, or it sounded like a person that was talking, not talking into the receiver.
Okay, go to Sharp then. Please do. What's interesting is you have the same attorney that I had. You got a court-appointed attorney.
Now,
that's my brother. That's my brother.
when he said, what's interesting is you have the same attorney that I had back in the day.
Yes,
That
sir.
was your brother, right?
Yes, sir.
And then you said you've got a court-appointed attorney now.
That's what I said.
I don't know. Let's go back and listen for it. Just
Okay, go to Sharp then. Please do. What's interesting is you have the same attorney that I had. You got a court-appointed attorney now. I know this.
aren't those two different voices?
About the court-appointed attorney, I don't know. I don't know if my brother moved closer to the phone or.
Well, let's let it play a little further and see if you can.
Is that good or bad? Yeah.
So when that person said Nick knows the guy, that's you, isn't it?
Yes, sometimes when we talk to my dad, we'd put our heads together and listen with the phone between us the best we could.
Now, Mr. Campbell, I'm going to play a portion of this recording 17 minutes into the recording.
Okay.
First off, show me on time. I'm going to try to talk to him beforehand. Sherry has a letter that I'm going to give to him. Go ahead. Whenever you want to talk. No?
Is that your voice?
I can't tell.
Did you say in that recording, I've already gone over that with Sherry also, what to say and everything. The main thing to say was the first off, show up there on time. I'm going to try and talk to him beforehand. Sherry has the letter and I'm going to give it to him. Go ahead. I know you want to talk. You said that, didn't you?
I don't know. We both went to the courthouse that day, and we met Holly there.
Anything else you want to cover? Now, at a point 20 minutes and say 15 seconds or 10 seconds into that recording, I would like you to tell me whose voice this is.
Tomorrow. Okay? If you can, talk to Holly. Say, hey, you need to get Daddy out because he's we're concerned while you're leaving him in here, and the more he's in here, the harder he's going to fight. You need to talk to him and negotiate what things
Was that your voice?
I couldn't tell.
Please make sure she doesn't feel threatened or anything. We don't need that.
When that person said, yeah, was that your voice?
I couldn't tell.
You guys don't need it. And she'll jump on that boat in a heartbeat. Please read all my letters for me. It's so important. I write and rewrite those letters. Send it 3015. Check them out every day.
Is that your voice, Mr. Campbell?
I couldn't tell.
Well, that person said send them to 3015. I check the mail every day.
The mail at that time, if I remember correctly, the house wasn't getting any mail.
Well, you were living there, right?
During the time, yeah, part of the time my dad was in jail, yes.
And the mail was coming to the house for you.
There was a point after, near the end, when my father was about to get out, that I was able to go to the post office and get the mail returning.
But at that point, you were checking the mail every day.
Mm-hmm.
That's what you told your dad, right?
Yes, sir, when I get home from work.
Is the mail getting delivered now? Is there anything specific in the mail that is of concern?
Now, you said no, I go through it all, didn't you?
I couldn't tell the difference in voices, but I did collect the mail and bring it in the house, and
Your brother said it's her address and I wouldn't send it to, and you interrupted and you said she changed, she doesn't get mail anymore.
play those voices again. I wasn't
happy
able.
to.
I wasn't able to tell.
So starting it back where we began.
Just the last little bit, the last 5 seconds you just played.
If you can, talk to Holly, say, hey, you need to get Daddy out because he's, we're concerned while you're leaving in here, and the more he's in here, the harder he's going to fight. You need to talk to him and negotiate where things are doing, okay? Okay, but please make sure she doesn't feel threatened or anything. We don't need that. You guys don't need it. And she'll jump on that boat in a heartbeat. Please read all my letters for me. It's so important. I write and rewrite those letters. Send it 3015. Check them out every day. Is the mail getting delivered now? Is there anything specific in the mail that is of concern? I don't put it all there. She changed she doesn't get mail anymore. She'll get it.
Now, with respect to the voices that we heard,
I could tell a slight difference.
you can.
Yeah, when they're speaking right against each other.
You can tell the voice of your father clearly, right?
Yes, very.
And you can tell your voice when you say send them to 3015 and check the mail every day.
Yes, that most likely. I mean, I'm sure that was me.
And you can tell your voice when you say no, I go through it all.
Yes, sir.
And you can tell your brother's voice when you say it's her address and I wouldn't send it to. And you interrupt him. You say she changed, she doesn't get mail anymore. And he says she can still get it though legally.
Still getting. What do you mean?
But with respect to it, you recognize your voice, don't you?
at certain parts I do when we're.
Now, yesterday you testified about another meeting between you and your brother and your father at the Brazoria County Jail.
Yes,
right?
sir.
And that was on October 30th of 2014. Is that correct?
Yeah, that's yes, sir.
And you visited with him,
Yes, sir.
and you knew that that conversation was going to be recorded,
Yes, sir.
as all the conversations are recorded.
Yes, sir.
And you testified that it fairly and accurately represented the conversation between you.
Yeah, yes, sir.
Okay. Your Honor, permission to publish State's Exhibit 35 with respect to, for impeachment purposes.
Yes.
This call is subject to recording and monitoring.
Hey, what's the number to get me? Did you bring a pen? You guys are both bring pens here. Huh? Please. Okay, she gives me the money or not. If not, she go fuck herself, you know? Real. She gives me the money or she go fuck herself. She really doesn't have the money though. That's all I needed to know.
Is that you speaking?
Um,
When you said she really doesn't have the money, though, do you recognize your voice?
I guess.
You talked to Sherry, right?
Yes, sir. We both talked to her.
Well, you talked to Sherry, and you told your dad she didn't have any money, right?
I can't tell the difference, but
I need to
if you
go
want me to
back
say
and
yes, I
you know,
will.
shit. Yeah, well, I told her all the facts and maybe one. So,
Now, was that you saying, yeah, well, I told her some, I told her all the facts, the basic ones, just so? Did you recognize your voice then?
I don't know. Do you have a part of my brother's voice that you know for sure on that, so I could hear it?
I'm gonna do some gossip with that shit, you know? Who cares? Yeah, I know.
Do you recognize your voice then?
I don't know. Play a part in my brother's speaking.
Better than nothing. I know, yeah, I agree. But she said that she'll call Aunt June and see if that, but the thing is, though, is she told me that with the charge that you have, that she doesn't know if Aunt June will really help or not. She's fooling around on me, blah, blah, blah. Yeah. Okay. Well, if that was the case, you guys understand when I call, I just want her to call. You know, if it works, it works. If it doesn't, we just keep working our plan, okay? Yeah. Did you find out, not yet.
Do you recognize your voice then?
I don't, but I don't know the difference between. I couldn't play a part that you know my brother is speaking.
We did, didn't we?
What?
I did earlier when your brother said, what's funny is that you've got the same court-appointed lawyer I did back in the day.
Yes, I do remember that.
And that his voice was distinct from yours.
when they're right next to each other, yes.
But your dad had told you to be looking for Holly, right?
That's what he says on the CD.
I'm not asking what he says on the CD. You were there, Eric.
Yes, if I was there, if me and my brother were both there, then yes, he would have told.
He said, again, did you find Holly? And on October 30th, while visiting him in the Brazoria County Jail, you said, not yet. Is that a fair and accurate statement?
I would guess so. I mean, I don't think I even told her when I told him about when I ran into her at the house. I just.
People, leave up the letter. I'm not going to give a damn thing. I really don't think so, but yeah, we will.
Was that your voice, Mr. Campbell?
Play it just a little bit behind that when I can hear mine and then that voice.
I'll be happy to back it up a little bit.
Leave up the letter. I'm not going to give a damn thing. I really don't think so, but yeah, we will.
Did you want me to back it up a little further than that?
Please do what I ask you to do. Don't worry, if it doesn't. We just keep working our plan, okay? Did you try to find out? Not yet. But big one. Leave up the letter. I'm not going to give a damn thing. I really don't think so, but yeah, we will. Just please do what I ask you to do. Because I know more things than you guys do. I know more than you. Please, just do what I ask. And you guys do what you think is best to do. Huh?
Was that your voice, Mr. Campbell, when you said, we'll find her after tonight?
I never actively looked for her.
That's not what you said. Your dad's asked you, again, did you find Holly? And you said, not yet.
I know from the testifying of Holly's security officer that my brother apparently went to a hospital looking for her, but
Okay. And you knew your brother went to a hospital looking for her, didn't you?
I was surprised when he said that.
But you said, we'll find her after tonight. Well, your dad couldn't find her, could he?
No.
He was in jail.
No. And sometimes you have to agree with him just to get him off the subject.
You could say whatever you wanted to him in the entire world, right?
I didn't want him to start beating himself in front of me from something I must have said.
He was behind plexiglass.
Beating himself, I'm sorry. Just...
She's going off becomes disability. Oh, okay, yeah, that's fine.
That was my brother talking about the disability benefit, if I remember.
Okay. Would you be surprised that the transcriptionist thought it was Eric?
I don't know.
And about 7 minutes and 25 seconds into the recording, your dad got upset.
It's angle 10. Listen, guys, I've got 10 more days in here. I said, Dad, you understand? Chill, Dad. We're trying as best we can. The really thing is, though, all your stuff at your house, it's not worth much. All your table saw, everything, $600 each. And I'm fine, then.
Ms. Campbell, do you recognize your voice?
I can't tell the difference between. I know my brother was selling stuff on eBay.
You told your dad, chill, Dad, for real. We're trying as best as we can. Really. The thing is, though, all your stuff at your house is not worth much. All your table saw, everything is $600 a piece. Is that what you told your dad?
I don't know. I know it's on the tape. I can't tell you who's speaking.
Well, yesterday, when you were talking to the jury and your lawyer was leading you through your direct examination, you testified as to this
that my brother?
being your brother's voice.
Yes,
Didn't
sir.
you?
Yes, sir.
But here, as we hear it play today, you're not certain.
On one of the video, on the second video that my attorney played, I remember hearing my brother's voice apart from the other one, and it was a little, like it was almost, in one of the instances, it was kind of croaky a little bit, and I could tell the difference.
But today you can't tell a difference, can you?
I didn't mean to speak in an absolute. I was just trying to.
But you spoke in
Explain.
absolute yesterday.
I believed. Trying to tell you what it was.
Now, with respect to your visits to the Brazoria County Jail, you made several of them, didn't you?
Visiting the county jail?
Yes.
I guess.
You first visited on 10/14/2014, is that right?
It's probably right if what it says.
That's right.
Yes, sir.
You went with your brother that day.
If
No, excuse me, you went by yourself. And then on 10/16, you went back with your brother.
okay.
Is that right?
I can't remember the exact date, but if it says that, that's right.
Because they keep a log of who comes in, is that right?
Yes, sir.
And when you came in, you had to give them your driver's license.
Yes, sir.
And your driver's license is TX 281-37533. Is that what you recall?
My driver's license number?
Yes.
Okay.
So you went back with your brother on 10/16, and then you went back with your brother on 10/23. Is that right?
Yes, sir.
And then you went back again with your brother on October 30th. The conversation that you played for the jury yesterday. You went back with your brother again on November 3rd. Is that correct?
Yes, sir.
And when you went by yourself on November 7th,
Yes, sir.
you went again on November 10th. Is that correct?
Yes, sir.
You went again with your brother on November 12th. Is that correct?
Yes, sir.
You went again with your brother on November 20th. Is that right?
Yes, sir.
And then you went by yourself again on November 23rd. You went again on November 24th. Is that right?
Yes, sir.
And you had two visits that day because you went in and visited with him by yourself, and then your brother got there and y'all visited again. Is that right?
Yes, sir.
It was the day before Thanksgiving.
That doesn't really help clarify, but yes, sir. If it's what it says, that's what happened.
And you went again and you saw your dad on November 26th. Excuse me, that was the day before Thanksgiving. With your brother.
Yes, sir.
And each time you went and visited with your dad, you visited with him for about 25 or 30 minutes.
Okay. Yes, sir.
And you talked with your dad,
Yes, sir.
laughed and joked.
It was. He tried to make it light sometimes. He was usually upset whenever he saw us.
But the recordings that you played for the jury yesterday, they aren't representative of how most of your meetings with your dad were at the Brazoria County Jail, were they?
I don't know.
Well, Eric, you were at those meetings, right?
Yes, sir. The ones I was. Yes, sir.
Okay. And so the audio recording, it captured everything that happened between you and your dad.
Yes, sir.
What do you remember about the meetings?
Our dad usually telling us, that we weren't doing enough for him, that we kept procrastinating. Just usual stuff like that. How terrible it was. He needed more money on his books. Sometimes we weren't answering his phone calls.
You weren't answering his phone calls because it was $15 a call, right?
Yes, sometimes it was that $15 a call was an excuse not to answer the phone.
But you went twice a week for several weeks, right?
Yes, sir.
You went twice a week, which was the maximum amount that you could go.
Yes, sir.
And you visited him with 30 minutes at a time. Is that right?
Yes, sir.
And most of those conversations were pleasant, weren't they?
I don't know.
I wasn't there.
I understand. I was.
You were there, right?
Yes, sir.
That's what you testified to.
I told you the things that I remember him talking about, the usual things at the visits.
But the two conversations that were played for the jury yesterday were not representative of how most of that went, right?
I don't know.
Now, we spent a lot of time yesterday. You spent a lot of time talking about your childhood.
Yes, sir.
And one of the things that you testified about was your dad taking your Adderall. Is that right?
Yes, sir.
Now, your dad took you fairly often to Pearland Pediatrics, didn't he?
Yes, sir, he did.
He did. And on or about September 19th of 2006, your dad took you in because he was concerned about how your Adderall prescription was affecting you.
Yeah, sometimes we'd go in there and he wanted to get it increased.
What did you say?
Sometimes when we'd go, sometimes he talked about how I needed more Adderall, increase the dosage, I believe.
Well, on September 19th of 2006, the chief complaint was, Dad feels dose needs to be decreased due to personality changes, would like to go back to 20 milligrams.
That was 2007, I would have been 14. I still would have been in junior high.
Okay.
I think I would have been junior high.
And the narrative on that record, underneath that, would it surprise you to say, says, doing well in 8th grade, no conduct problems, want to decrease dose to 20 milligrams, dad impatient, deny person. side effects or personality changes. Dad just wants the lowest dose that works.
Okay.
You visited Pearland Pediatrics a total of 21 times in 8 years. Is that right?
I have no idea how many times, but yes, that's probably what it says.
And you went there as a teenager.
Yes, sir.
You drove yourself.
Yes, sir.
And yet, in the 21 times that you went to your pediatrician, you never disclosed any of the things that you were telling the jury about yesterday.
No, sir, I did not.
You were there by yourself.
Yes, sir, I was.
You had physician privilege. Your doctor, you trusted him.
It was, yeah, yes, sir.
You had a fairly significant relationship with your physicians, didn't you?
If I had told the physician, she would have discontinued the Adderall, and my dad would have been angry.
But you had an opportunity to tell someone about
Yes,
what
sir,
you
I
told
did.
the jury about yesterday.
Yes, sir, I did.
And you didn't.
No.
As a matter of fact, at one point, you visited a neurologist, didn't you?
When? When?
With respect to the time you said your dad hit you in the head with the butt of a gun, did anyone ever find anything wrong with you?
I don't know. It's maybe 4 or 5.
Now, earlier I asked you about kickboxing,
Yes, sir.
and as a teenager, you participated in kickboxing, didn't you?
I saw my brother enjoyed it, and my dad.
And so you thought you'd do it too, right?
I'd usually go out there alone and just play around.
And on August 26th of 2010, you went to the doctor because you'd injured your foot kickboxing.
August? What year?
Of 2010 in August.
I guess, yeah.
Excuse me?
I guess so, yes.
Okay. When did you go to report your broken hand?
I never did.
Never did.
No, sir.
Your dad carried you to the doctor 21 times and you never went for your broken hand.
No.
You never reported that to your physician.
No. My dad, when I came home, when I came downstairs that morning afterwards, he took my hand and looked at it and squeezed a little bit, and he said that it wasn't broken, it was only fractured. And that was it.
That's what your dad said.
That was the end of it.
You testified yesterday you broke your hand.
Yes, sir. A break and a fracture are the same thing.
Right. Yes. Eric, I'm handing you what has been marked for identification purposes and previously testified and admitted into evidence, Defendant's Exhibit 25. A picture of your father and Holly Campbell, Defendant's Exhibit 26. And Defendant's Exhibit 27. Defendant's Exhibit 28. And Defendant's Exhibit 29. Can you take a moment and look over them?
Yes, sir. So,
if you could take each of these pictures and hold them up to the jury and point out where the date is and what the date is for each one of those pictures.
this is 12/23/2009. 6/30/2009. 8/19/2009. 8/18/2009.
Mr. Campbell, yesterday you testified about having to stay home from school and watch your step-siblings.
Yes, sir.
Matter of fact, you were talking about when the third one came, you were kind of burnt out. The third one, is that what you said?
Yes, sir.
Okay. But those pictures with you and your stepbrother and your stepsister are all between June and August of 2009.
Yes, sir.
And you were out of school, right?
2009. 16. I don't know if I was homeschooled or not at that time.
Well, it was summer vacation, wasn't it?
August, December, June. I guess so.
Yes.
It was 1 December, 2 Junes, 2 Augusts.
Eric, you testified yesterday about being placed in DSS custody in Texas.
I vaguely remember it, yes.
Right. But you didn't testify about disclosing the assaults and all the things that you talked about yesterday, did you?
At the DSS or?
Did you ever tell anybody at DSS about your dad hitting you?
I don't know. I don't remember. They said, my attorneys told me I went to DSS twice, and I only remember once, and that was when, I think that was when my dad was drugged up on the toilet. I only remember a couple bits about it.
But you went into foster care
Yes, sir.
for 3 weeks.
Roundabout, yes, sir.
Right. And there was a record of that, right?
Okay, yeah, there would be a record.
But the record is devoid of you ever talking about or telling anyone about your father hitting you.
Yeah. I don't know.
As a matter of fact, with respect to the record, the worker said, worker explained to Eric that he was returning home with his father. He was very excited about this. He stated he was happy to be going home.
Yes, sir. How old was I?
Well, that was on May 3rd of 2001.
I was I was 8 or 9.
So it was after you were 4.
Yes, sir.
It was after you were 5 years of age.
Yes, sir.
After you were 6. So 8 years old.
Yes, sir.
And you were 8 years old, and you were very excited. You were happy to be going home.
I don't know what to say.
Yesterday, Eric, you testified in a lot of detail about what happened at the Faulkner's house.
Yes, sir.
And Mr. Campbell, you testified about your father bringing you into the house.
Yes, sir.
And that Mr. Faulkner had a crossbow bolt sticking out of his chest. Did you say that?
Yes, sir.
And that Miss Faulkner was in her bedroom crying.
Yes, sir.
Is that a fair representation of what you told the jury yesterday?
Yes.
And that your father reloaded the crossbow and shot her in the side with a crossbow.
Yes, sir.
That's what you told the jury.
Yes, sir. Right. Yes. Yes.
And that after he shot her with the crossbow, he was frustrated about her not dying quick enough, and so he took the antique spear and he bashed her skull in.
No, he said that about Jerome when we were in the office.
He said that he took the spear and bashed in Jerome.
No, that he had tried to impale him.
Okay. But at the point that you were inside the house and could see everything clearly that was happening,
Clearly. Okay. Yes, sir.
you testified that he took the spear and he struck Dora Faulkner in the head to kill her. Is that right?
No. I didn't see him do that.
You were in the room.
I understand. I was in the room.
Okay. After she died, you said that he went over to Jerome Faulkner and placed a bag. Actually, you said he took the spear and he stabbed Jerome Faulkner in the neck.
Yeah, I think I said it.
And he then put a plastic bag over his head because he was still breathing, right? To put him out of his misery.
That's what the transcript says, yes, sir.
Okay. And that's what you told Roger Baker.
Yes, sir.
And that's what you told Doug McPhee,
Yes, sir.
that you saw this,
I know I told them. I know I told them I saw it.
that you were there.
I was not in the room while my dad was doing those things.
Well, I'm talking about the parts where you were in the room, Mr.
Yes, sir.
Campbell.
Yes, sir.
Talking about the things where you were in the room. And you testified yesterday that you were in the room when your dad shot Dora Faulkner with a crossbow bolt.
I was.
And that crossbow bolt went in through her arm and into the side of her chest. That's what you saw, right?
Arm?
Mr. Campbell, you said she was on the bed crying, and your dad shot her with a crossbow. Is that right?
Yes.
And then thereafter, he struck her with an antique spear.
I don't know what he struck her with.
Well, you were in the room, right?
For a small part of the time, yes.
Okay. And then he went outside, or he went into the next room, and you said he stabbed Jerome Faulkner with the antique spear.
Yes, sir.
And you told Roger Baker that.
Yes, sir.
And you told Detective McPhee that.
Yes, sir, I did.
And you told this jury that.
Yes, sir.
And then you said that your dad took a plastic bag and put it on Jerome Faulkner's head.
I know I said that. I did not see him do that.
Okay, but that's what he did, right?
Even when we were moving him, I didn't see the bag.
Well, you testified earlier today that you were in the bedroom with your father and Dora Faulkner and Jerome Faulkner. Is that what you testified to?
Yes, sir.
And that's where you were. You were there in that room.
So it was.
And so your father wouldn't have walked out of the room to put a plastic bag on Jerome Faulkner's head.
I wasn't in the room when he did that. I saw him walk by when I was in the living room.
But you were in that room. You weren't in the living room with Jerome Faulkner.
I was in that. What room are you talking about?
You testified earlier that they were both in the bedroom.
Yes, sir.
And he put a plastic bag over his head.
I did not see that happen.
Approach.
Yes.
Mr. Faulkner, I'm approaching you with what is State's Exhibit 500. It's the Ranger crossbow that your dad had. Is that right?
Yes, sir.
It's the Ranger crossbow that had Jerome Faulkner's DNA on the foot stirrup here that is obviously bent. Right?
Yes.
So how in the world did this crossbow fire a bolt into Dora Faulkner?
I do not know.
I don't have any other questions this time, Your Honor.
Thank you, Your Honor. Mr. Campbell, are you exactly sure of the order of which your father caused the injuries to the Faulkner?
I am not.
Now, the district attorney asked you quite a bit about an interview that you had with Roger Baker on January 1st, 2015. Do you remember that interview?
Very vaguely. I knew I was interviewed after the arrest.
And that was immediately after you were, well, when exactly did that interview happen? Was that right after you were arrested in West Virginia, or was it the next day?
It was right after.
And I think you testified on cross that this was after you'd seen your father kill the Faulkners as well as shoot 2 police officers in West Virginia. Is that right?
Yes, sir.
I object to the leading, Your Honor.
Be careful about that, please.
Yes, sir. I'm just trying to establish where we were. I'm handing the State Defense Exhibit 38. Upon approach.
Yes.
Now, Mr. Campbell, I'm handing you what's been marked as Defense Exhibit 38. Is that a photo? What's that a photo of? Or who's in that photo?
That's myself.
And is it an accurate photo of the physical condition you were in, at least on your face, when you were interviewed by Detective Baker in West Virginia?
Partway, at some point I wasn't able to see out of either eyes, and one of my eyes is open.
So at some point you lost the ability to see out of one of your eyes during that interview with Mr. Baker, or Detective Baker?
Just about. I don't think it was swollen as too much in that first interview, but in the second one, I couldn't read the paper, one of the papers that they gave to me to sign.
And the injuries to your face, were they obtained before? I mean, did those happen before you were interviewed by Detective Baker?
Yes, sir.
And
after.
And after. Would this picture help illustrate your testimony?
Yes, sir.
Your Honor, this time I would move Defense 38 into evidence.
You object? No object. No play.
Your Honor, I would ask that the deputy be allowed to show this
Yes.
to the jury. If you remember, during that interview with Detective Baker, what was your emotional state?
Shocked and very, I was very afraid.
Now, at the beginning of the interview, the detective gave you a Miranda warning. He told you had a right to remain silent and asked if you would be willing to voluntarily answer his questions. Did you agree to do that, to answer his question?
If it's what it says on the transcript, then yes, I did say that.
So do you don't actually remember whether you got those warnings or not, but if it's in the transcript.
I almost remember nothing of the interview.
You remember almost nothing of that interview. At any point during that interview, did you know of, did you refuse to answer his questions or try to terminate the interview?
No, I was trying to answer him.
Yes. Welcome back to LawNewz Network. I'm your host, Beth Karras. We've been listening to the cross-examination and redirect of Eric Campbell. He's winding down his testimony. I am joined in studio by Michael Bryan, a former colleague of mine from Court TV. He's a correspondent at the time for several years with me.
Hi, Beth.
I think court may have begun again, but let's just talk for a couple of minutes. Where we were listening to the cross-examination by the prosecutor, what was he doing with his cross?
You know, he's trying to shoot down the defense that this kid is so mealy-mouthed, so mousy, so without free will, that he would do anything his dad says. Well, you know, you got to punch holes in that defense or you're going down. And let's face it, the kid is pulling it off in terms of general presence. He is a mouse.
I mean, compared to the allegations in this case, look at him. He looks like a college student, and he's so meek I can barely hear him
I know.
On the witness stand. But he was there. He was visiting his father a lot in the jail. Nobody was forcing him to go to the jail, helped bail his father out, and this is when his father was locked up for the domestic violence on his stepmother, and then they went on their crime spree. So
I mean, the jury's got to believe that this kid has no free will, that even when his dad is in jail on unrelated charges, he still will do anything he says.
Right,
That's a stretch, maybe, you know?
That's right. And he's waiting outside while his father's inside the Faulkner home, viciously killing them. Well, not quite, wasn't quite killed, and he's inside when that killing happens too, but he doesn't do anything.
But I'm not in the room. See, I'm not in the room.
So, in any event, we're not eyeballing the jury, so we don't know how the jury is reacting to this. But maybe this is all a ploy simply to save his life. I have a hard time believing that he's walking away from the host of crimes he's charged with here. There's larceny, there's theft of an auto, there's cruelty to animals, besides the 2 first-degree murders. There are a lot of identity theft. I said theft of the auto.
Animal cruelty?
Animal cruelty.
I mean, you know, for the defense, if he stays alive, that's a win. I mean, it really is. This is a jury that's going to want to nail somebody, and Dad's not in the picture anymore. So it makes it tough on this kid.
So, I mean, it's an abuse excuse, a term we saw popularized when the Menendez brothers were in trial, right? And it might work to an extent, and that extent, it could be saving his life. Not that he'll ever be a free man, but could save his life.
Right.
So are we back? Oh, let me listen, I can't really hear anything. Are we back? Yeah, he's back on the stand. Let's go back into the courtroom, and we'll talk some more at the lunch break. And by the way, at 1:30, we will be bringing you the sentencing hearing live of Dalia DiPolito in Palm Beach County. And also during the lunch break, I hope to speak to one of O.J. Simpson's attorneys from his Vegas trial, Gabe Grosso. We'll talk to him about his reaction to O.J. Simpson's parole. And my guest, Michael Bryant, he interviewed O.J. 3 days before the verdict in that Vegas case, so we can talk about that as well. So let's go and listen to a little bit more of
because I didn't
Eric
want
Campbell.
to see that.
And those weren't the only 2 times you were interviewed by the police, was it?
No, sir.
Do you recall being interviewed by Detective Deeds and Detective Bowles on January 6, 2015?
Yes, sir.
Do you remember if they gave you Miranda warnings or if you agreed to talk to them?
I remember the interview better.
You remember that interview better than the earlier ones?
Yes, sir. Better.
And did you answer all their questions?
Yes, sir.
Did you ever terminate the interview or refuse to talk to them?
No, not at all.
Do you remember being interviewed by the FBI?
Yes, sir.
Did you answer all their questions?
Yes, sir.
Did you ever refuse to talk to them or tell them, you know, I'm not talking to you anymore?
No, I did not.
Now, the state asked you about your dad buying a lye and a sprayer at Home Depot. When your dad bought those items, what did you think he was going to use them for?
Thought he was getting all the supplies together to make his his methamphetamine.
And did you later learn that he had a different purpose?
Yeah, I did.
And how did you learn that he had a different purpose?
When he was inside the house taking off clothes because he said that he was burning up. And he had lye all over him.
And what did he tell you after that?
He said it was it would have made a good threat, but it made an even better weapon until it exploded on me.
Now, on this trip, did your dad talk at any point about robbing people or stealing things?
Yeah, he did. Yes, sir.
And I know you've testified extensively about some of the acts of violence you've seen your father commit and things that he's done to you. Had you ever seen your dad rob anyone before?
No, sir, I have not.
Were you expecting, I mean, was that something that you'd ever heard about him doing, or you'd ever seen him break into someone's home and steal money from them?
No, I've never seen that before.
Have you ever seen him shoot anyone or use a weapon like these against someone?
No. No, sir.
And in all those interviews that you gave with the different police officers, did you ever tell anyone that you wanted your dad to do this?
No.
Did you ever tell anyone that you actively shot the Faulkners or stabbed them?
No, I did not.
And is that your testimony today as well?
Yes, sir, it is.
I have no further questions. Thank you, Mr. Campbell.
Thank you, Proper State.
You were involved in a car wreck in West Virginia.
Yes, sir, I was.
I don't have any other questions.
No, sir. Oh, I'm sorry. Further proof?
Anything further?
Oh, no, nothing further.
Yeah, this Campbell calls Lee Hagan. I do swear.
Sir, would you state your name and spell your last name, please?
Lee D. Hagan, Ph.D. The first name is L-E-I-G-H. The last name H-A-G-A-N.
And where do you work? Where's your office?
Well, my office is in Chesterfield, Virginia, but I work all over regionally on the East Coast.
What is your profession? What do you do for a living?
I'm a solo practitioner, which means I work for myself. I'm not employed by a hospital or agency, and I practice clinical and forensic psychology.
And first of all, tell the jury what a forensic psychologist does.
Well, first of all, it's not what you see on TV, because we can't take commercial breaks and that sort of thing, and that's all drama. What the forensic psychologist does is comes into a case, a matter in controversy, usually in court, although not always in court, when the issue has to do with human behavior as relates to a legal question. So the psychologist may evaluate an individual, or in some cases actually doesn't evaluate the person but reviews records, and then offers opinions that may help other people decide the legal outcome of the case.
When were you first licensed?
In 1982.
And when were you first licensed as a clinical psychologist in Virginia?
In Virginia in the same year. My first license was in Georgia, but then the same year in Virginia.
And what type of practice do you have?
For 30 years, I have practiced on my own independently. My office is right there in Chesterfield. Before that, I was with the VA hospital and a mental health center.
And tell us a little bit about your education.
Well, I have an undergraduate degree in psychology and a master's degree in counseling from University of Virginia, excuse me. And I have a doctorate in psychology from University of Missouri at Columbia.
Did you do any postdoctoral training?
Yes, almost all of my postdoctoral training is in the field of forensic psychology, staying on top of the scientific literature, developments in the field, changes in law to the extent that that impacts my practice.
You hold any faculty positions?
I hold an adjunct faculty position in the Department of Psychiatry and Behavioral Science at Eastern Virginia Medical School. I'm not a teacher in the classroom, but I have on occasion been invited to address the residents there who are in training in psychiatry and behavioral science.
Do you have any advanced certifications?
I do. I have basic and advanced certification in conducting forensic psychological evaluations. And I'm also a diplomate of the American Board of Forensic Psychology. A diplomate is someone who has earned a diploma. Another way to express that is I'm board certified in forensic psychology.
And do you provide continuing education for other professionals in this area?
I do, for people in my field, and I have presented for attorneys by invitation to defense attorneys, prosecutors, and judges at what are called bench bar conferences.
Have you published in peer-reviewed articles?
I have. No, peer review means that the manuscript that I submitted for publication has been, that it's met two tests. One, that the work that I conducted was scientifically proper. There wasn't any cutting of corners or any of that sort of thing. And second, that the article that I wanted to publish had sufficient merit to warrant publication in a journal. Now, in my adjunct faculty job, I'm not required to publish, so I do it on my own initiative when I think it would bring value to the field.
And have you given professional presentations or CLEs with respect to the standards of practice and proper methods and procedures of psychologists should follow?
I have, CLE means continuing legal education. That's when the audience is attorneys, and I have probably given 80 such presentations, presented papers, or published articles.
Approximately how many times have you testified as a forensic psychologist?
Over the course of my career, maybe 420 times.
And in how many capital cases have you been appointed?
I believe it's 128, 129.
Who hires you in these cases? Which side?
Well, in my capital case practice, 60% of the time I'm appointed on motion of the defense attorney, 40% of the time on the motion of the prosecutor or the attorney general.
And have you qualified as an expert in clinical and forensic psychology in other states in capital cases?
I have, in Florida, Texas, Virginia, Pennsylvania. Those are the ones of which I can recall.
Here at this time, I tender Dr. Hagan as a witness who is qualified to give an opinion in the field of forensic psychology.
No, sir.
Dr. Hagan, tell me a little bit, how did you get involved in this particular case?
Well, I first got involved, but it wasn't in this particular case. It was, thank you very much, sir. It was in the West Virginia matter when Eric Campbell was first in custody there. His attorney representation was by the West Virginia Public Defender's Office. The public defender there, Mr. Joe Nagy, called me and asked me if I would evaluate Mr. Campbell in connection with the matter in West Virginia.
Tell me a little bit about your response to that.
Well, based on the very little that I knew, and knowing that that Mr. Campbell had just recently been taken into custody, and the offense conduct as alleged was very recent, I thought it important to get out there and capture the interview information as quickly as possible so there wouldn't be further deterioration in memory as a result of passage of time or those other things that we know compromise an individual's recall. So that, from a scientific standpoint, that was my interest, capturing the data as cleanly as possible. The second factor that prompted my getting to West Virginia quickly was Mr. Nagy was concerned about his client's mental state and suicide risks.
Dr. Hagan, when did you go to West Virginia? Do you remember?
It was February of February 2nd of 2015.
And what did you do when you went to West Virginia?
Well, I made my usual advance arrangements with the jail, made sure I could take my computer in, checked on security issues. I have my own security concerns when I go into a jail. Frankly, I don't want anything to happen to me. So I checked with jail security to see if Mr. Campbell had any write-ups for any rule violations or violent behavior in jail, and I made certain that we had what's called a contact visitation room. In other words, it's not through the plexiglass by phone. We're across the table from each other. I provided my credentials and took care of all those procedural elements. And then when I met Mr. Campbell in contact visitation, we had conversation, interview for, I think, 5 hours or so, a little over 5 hours.
Now, after you interviewed Mr. Campbell, what did you do as far as not what you did that moment, but what was your follow-up involvement in that particular matter?
Well, I spoke with Mr. Nagy actually in the jail parking lot. It was snowing, I recall, and gave him my point of view on what I had learned from Mr. Campbell, and asked if he required anything further of me or if he required a report.
And did you hear again from Mr. Nagy or from any of from Mr. Rogers, who also worked with him on the case?
Yes, well, actually, I initiated the follow-up and asked the same question. Is there anything else you need of me? Do you require a report?
And did they ever ask you for a report or any follow-up as far as the West Virginia matter was involved?
No.
When did you get involved in this case again, or get involved in evaluating Mr. Campbell again?
Well, it was much later. It might have been 2016 when the Capitol Public Defender's Office in North Carolina asked me if I was available to provide them the work that I had developed in the West Virginia case.
And did you provide that information?
Well, not right away, because I had to make certain that information that I had collected for one purpose Mr. Nagy's engagement in West Virginia, that I had proper authority and informed consent to turn around and use that information for another purpose. So I told the North Carolina PD's office how to get in touch with Mr. Nagy so they could work that out to take care of informed consent and release authorization and make the communications proper.
Did that take some time?
It took a long time, yes.
And after that part was completed, Mr. Nagy agreed to sign the release. Were you reappointed to get involved in Mr. Campbell's case?
Well, yes, but there was an intervening step, and that was that I conveyed all of my information to the North Carolina public defenders. They had to read through it. They had to make their own decision process. And then they got in touch with me to ask if I would be available to consult further in the North Carolina case.
And ultimately, did you agree to get involved?
Yes.
And was that relatively recently or within the last year?
Oh, yes. Yes, that's right.
So tell us a little bit about going back to West Virginia. What were your initial impressions February 2nd of 2015 of Mr. Campbell when you got there?
My impressions of Mr. Campbell?
Yes.
Well, during the course of the interview, which was multiple hours, I had two concerns. One was about the nature of the offense and the conduct involved in the offense behavior, and the other concern was about his history and what he had related to me about his history and how that impacted his mental state in the present moment. Because I heard some very, very deeply concerning things from him about his own history.
Did he, while you were talking to him, claim that he had any sort of mental disorder or mental disease or anything like that?
No, no. He never did that. And well, I have more to say on that, but you haven't asked me.
Okay. Well, did he use any sort of psychological terms or to explain or describe his behavior?
None.
Talk a little bit about psychological considerations, how you approach a case, in other words, how you evaluate a case.
Well, in any case, I try to read as much as I can before I see the person. Sometimes that's not possible because it's an emerging situation that is rapidly developing, or the record hasn't been developed yet and the information just isn't available. But I want to read what I can, learn what I can before I go see the person. Not just for my protection, but because I need to know what to ask and what not to ask so that I don't taint, that is, contaminate an individual's statement to me.
When you saw Mr. Campbell originally, was any of that information, any background information available to you?
The information that Mr. Nagy had given me by phone and the nature of the charges, but none of the deep history, say going back to Texas, for example, that hadn't been developed.
Had you, based on your conversation with Mr. Campbell, developed any sort of what you might call hypotheses or sort of considerations as to what might be going on?
I did.
And what were those?
Well, one was that Mr. Campbell's conduct arose out of antisocial behavior, callous indifference and disregard, and that he would just as soon lie to me as tell me the truth. You have to have that in mind when you're dealing with someone who's charged with something criminally. So that was one hypothesis, and then the other hypothesis was that the story, that there was external corroboration, even pre-existing corroboration, that supported Mr. Campbell's narrative about the pathological dynamic in his relationship with his father, his abuse history, and so forth. So I wanted to look fairly at both sides of the coin, because my job is not to be the mouthpiece for the person who hired me. My job and my reputation is based on me getting the best scientific information I can to accurately inform people so they can make decisions about how to do their job. The outcome of the case is not my job. My job is to accurately inform folks as best I am able.
Now, did you have the information you needed after interviewing Mr. Campbell, or sufficient information to complete your sort of your study or your analysis of the case?
Yes, well, I did, but that was only after the North Carolina Public Defender's Office engaged me and then started sending me records going back to Mr. Campbell's early years, all the way up to the time of these killings.
Now, Dr. Hagen, we've talked a little bit about Mr. Campbell specifically and your hypotheses. You've heard a lot of talk here about, or you've heard some talk about Mr. Campbell's background and his relationship with his father. And I want to ask you some questions, not specific to him, but in general. Talk to us a little bit about brain development and childhood development and why that's important.
Well, and this is very important in understanding how people form patterns in relationships, especially with parents or caregivers. And this is true of all members of the human species. When born, children are absolutely helpless. They can't feed themselves or see after their own security or protection, warmth, any of that, hydration. They can't do any of that. So they're fully dependent on caregivers. And there is this process referred to as the circle of security, in which the caregiver has a responsibility to the vulnerable child to do three things. First, provide a secure environment to keep the child safe. This isn't limited to putting child safety locks on the kitchen cabinets. It's all aspects of child safety and security. Second, the caregiver has a responsibility to foster the child's healthy exploration of their world and to find a place for themselves in the world where they can be a satisfied and independent individual. And third, the caregiver's responsibility is to show joy and delight upon the youngster's return to the caregiver. This is based on research over 50 years. It is well settled. It is not in dispute at all in the scientific literature. Now, where the wheels fall off the cart is if the caregiver fails in any one of those three areas of responsibility. When that happens, when there is not a secure, safe, healthy environment, when there is not a healthy fostering of independence, when there is not a showing of joy and delight when the youngster comes back to the caregiver, a pathological or insecure or defective attachment becomes crystallized, that it becomes the pattern for that youngster in understanding not just that relationship, but how to have other kinds of relationships. And the youngster forms a template about whether the world is a safe place, how to make themselves safe, and learning how to interact with the caregiver to try to get that caregiver to take care of them. This template is pretty well crystallized by age 4. It might take a little longer, but by age 4, those patterns are ingrained in the neural pathways of the brain. And this is tremendously important because when an infant is born, there aren't patterns in the brain to process information. And this is why the brain develops so quickly in very young children, because they have to develop patterns so they too can find their way to navigate safely through life challenges, including such simple things as don't stick a fork in the electric outlet, but also to learn of the human beings in the youngster's environment. Who is a safe person? Who's going to take care of them? And who is a dangerous person? Who do they need to avoid? So the brain has to develop these patterns. The patterns become fairly crystallized and set in place and end up repeating themselves over the course of the individual's lifespan. This is why when mental health professionals are conducting an evaluation,
At this point, I'm not sure that he's responding to the question.
But let him talk.
This is why when people in my field, or even probation officers, are trying to do an evaluation of a person, they always begin with the early history. Who were your parents? What could you tell me? And it's not just to fill out space on a form, is because these are critical issues in shaping how the person sees their world, how they look to others to provide safety and security, and how they try to make themselves safe. And it helps explain patterns of relationships later in life, in elementary school, middle school, high school years, and so forth.
Can childhood trauma impact behavior later in life?
There's no question about that. Trauma is a highly stressful, frightening, sometimes terrifying event. And when the individual experiences that, it uses its own natural brain mechanisms to deal with the trauma. Neurotransmitters, these are little chemical communicators between nerve cells in the brain, get jacked up with cortisol or other highly arousing neurotransmitters. When that, and that's designed to protect the person, to kind of give them tunnel vision so they can focus on this crisis in that moment. But with the tunnel vision, people tend to lose the broader view. So they may make immediate judgments based on this very narrow tunnel vision, and the judgments may end up being poor as a result. But the more of those highly arousing kind of fear-driven neurotransmitters that flood the brain, the more judgment gets impaired. And people who experience trauma once, particularly at a vulnerable age, are more susceptible. That is, they have a lower threshold for trauma down the road when other crises surface.
Is there, when the trauma is caused by a caregiver, say, well, let me ask you this. Talk about the impact of childhood trauma that results from an abusive relationship with a parent.
Well, the research solidly supports that trauma perpetrated by parent, caregiver, or somebody within the family becomes more ingrained and is more disruptive than, say, trauma that may happen in the community. For example, being in a car accident and being T-boned, or being assaulted at a football game behind the bleachers. When it happens within the family, it has a much more severe and lasting impact, in part because, and loop back around to what I said before, the caregiver's #1 requirement is to provide a safe and secure environment. And when that is breached, it undoes the individual's sense of trust and safety more generally than if they were attacked by a stranger.
Are there sort of common features that psychologists look for when they sort of consider the possibility of an abusive relationship or family violence and things like that?
Yes.
Tell us a little bit about those.
Well, one, you can look at the record. You can see if the government has been
Welcome back to the LawNewz Network. I'm your host, Beth Karras. We're going to break from the Eric Campbell trial just for a few minutes, but if you want to continue watching the trial of forensic psychologist Dr. Lee Hagen, who evaluated Eric Campbell, you can do that on our dedicated feed. But right now, the LawNewz Network is going to break and have a chat with O.J. Simpson's lawyer from Las Vegas, Gabe Grasso. He's his former lawyer. He was one of 2 attorneys who handled the Las Vegas robbery, kidnapping, burglary trial that is basically over with that parole hearing yesterday. Well, we'll see if it's over. Anyway, Gabriel Grasso is joining me, not from Las Vegas. He's actually in Dodge City, Kansas. I'm not sure why he's in Dodge City, Kansas, but he's been flying around the country, I think handling a lot of federal cases outside of Nevada, but he did have an opportunity to see the parole hearing. So, Gabe, can you see me? Can you hear me? There you are.
Good morning, Beth. I don't know. I can't see you, but I can hear you.
Okay.
Anyway, yeah, I'm in Dodge City because one of the side effects, I guess, of all the marijuana legalization in the West, meaning, you know, Oregon, Washington, California, Nevada, is that all the sort of quote unquote illegal trafficking is moving to the Midwest. So there's a lot of activity here with transporting and things like that, and clients seek me out, and that's why I'm out in Dodge City.
Well, enjoy Kansas. I know you just got out of court and you're in a law office there, taking a few minutes to talk to us, so thank you. I also want to tell you that I'm joined in the studio by Michael Bryant, who was a correspondent with me at Court TV, but by the time of your trial, representing O.J. Simpson in Las Vegas, he was doing something else, but he did interview O.J. Simpson 3 days before the verdict came in, and we'll bring that into the conversation. So you watched the parole hearing yesterday. What was your reaction when O.J. was answering questions of the commissioners?
Well, you know, one of the parole hearings are not rocket science. Parole hearings are pretty straightforward. I've handled a few in the past, and there is a golden rule to parole hearings, and that is remorse. Please, Mr. Defendant, Mr. Inmate, show remorse. The parole commissioners don't want to hear about your case. They don't want to hear about how innocent you were. They don't want to hear about what a big misunderstanding these last 9 years have been. They don't want to hear about anyway. If I was advising O.J., that parole hearing would have been much shorter, and it would have been much, probably less exciting for the TV audience. But the most important thing is you have to just fess up to what happened and say, you know, ladies and gentlemen of the parole commissioners, let me just say that I was guilty of the crime I was convicted of. I accept that fact. I committed a crime. I've had 9 years to think about it. I'm a changed person. That won't happen again. And please let me out on parole. That's it. Don't go into, I mean, when OJ started talking, and I started, it was just, you know, a cringe factor was I was watching it, and OJ, and look, this isn't the first time I've heard OJ with that story. That was his story all along. And not that the story is wrong or he's not telling the truth or whatever. The bottom line is, though, that's not the right place for it. The parole hearing's not the right place for it.
So what were you thinking? Were you thinking that these commissioners might actually deny him parole?
You know, I think in this case, I think there's been some talk about the celebrity factor, the OJ factor, always hurting OJ. I think maybe the OJ factor in this case helped OJ, because had this been a normal parole hearing, I can tell you, I've handled a few, and my clients would sit there and say whether they thought they were guilty or not, because, you know, there's a lot of people who are in prison, and obviously we've seen the stats. There's innocent people in prison, but when you go to a parole hearing, it's not about how innocent you are, because if you walk in there and say, I didn't do anything and I don't even know why I'm here, you're not going to get parole. And I really thought that OJ had bought himself another year or two in prison after that speech, with the fact that it was just a big misunderstanding and we were all friends and I don't even know what happened. So yeah, I was worried. I was worried for him.
Yeah, I actually thought at one point he probably did buy himself a little more time, but at the end he came around to saying, but it is all my fault, I take responsibility. So he got it out eventually, but right. I thought, at one point he certainly wasn't helping himself. Meanwhile, the testimony at trial from those who, his friends who committed the crimes with him but cooperated with the prosecution for non-jail sentences, they said something very different from what he told the parole board yesterday. But I understand they weren't litigating the case yesterday. He just simply needed to take responsibility. Let me ask you this. I remember during the pendency of your case, during that year before it went to trial, or 11 months before it went to, no, it was about a year before it went to trial. It happened September 2007 and went to trial in September 2008, right? Right. That he violated bail conditions because he had contact with one of the co-defendants. So, I mean, I'm just wondering if that's a sort of a precursor of things to come. You think he may violate one of these parole conditions? Because he really has to behave himself.
He does, and they're going to be, I just as a preface to my answer, I definitely got the feeling during this parole hearing that these parole commissioners just wanted OJ out of their hair. That no matter what he said, he was going to get paroled. I got that feeling on the other side, and so eventually that's what happened. But I think that doesn't affect the fact that when he's on parole, he's going to have most likely what's going to happen is he's going to transfer through the interstate compact to Florida. And Florida's, he's going to have a Florida parole officer, not a Nevada parole officer. And the Florida parole officer is going to be reporting back to Nevada, but they're going to have their own special rules in Florida, which are probably line up with Nevada rules about 95%. And so I think OJ is going to really have to walk the straight and narrow, and that's what's going to be difficult for him, because it's not just about OJ. It's not just about that he's some kind of guy who can't control himself or whatever, or is out there wanting to commit another offense. It's just that sometimes he surrounds himself with people that don't have his best interest in mind. People who want to make a buck off of OJ, people who want to, become famous themselves because they're next to OJ. And in those situations, he could find himself in another quote-unquote misunderstanding, and that could affect his parole.
That's right. There could be people who will be looking to violate him, looking to tempt him so that he will violate. So I mentioned that Michael Bryant is joining me here in studio. Do you have a question for Gabe?
Yeah, I do, Gabe, and good to talk to you again. It's been, a while. I'm curious if before OJ was released on the scene for this trial, if he was admonished by you guys not to talk to the press in any way, be friendly, be cordial, but certainly don't give any interviews. Was that instruction given to him at all?
Yes, it was. I mean, not only was the instruction given to him, but when Yale Galanter was in control of the OJ situation, the trial, that year or so that we were his attorneys, he did not give any interviews or really was not in the public eye. There were a lot of interview requests. You could see him walking in and out of court, etc. But we made sure we controlled that, because one of the most important things, although that's pretty popular nowadays, even with the people in the White House, is your client has to keep his mouth shut, and it's a very important fact, and he did keep his mouth shut while he was our client.
Well, I just think it was, he's a very gregarious guy, as you know. He likes to talk, and that's probably going to get him in as much trouble on parole as it has in the past. He seems to want to talk no matter what. So when I spoke to him at that church during the course of the trial, I kept it purposely very clean. I wasn't trying to retry a prior case that he was involved in. I certainly wasn't trying to get his take on the current case. It was more about to get his emotional stance on things, how he felt about the process, how he was doing in Las Vegas. He was at church where his friend Randall Cunningham was the pastor, the former NFL quarterback. So it was a pretty casual conversation, in part because of my respect for the process and not wanting to be a story rather than just kind of expose people to him when he's not in court, which is what I think I was able to do. But my point, I guess, is that he kind of ignored you to some degree, and I know how frustrating that must be. And as you look forward toward his parole period, you've got to be wondering, you know, whether he's just going to at some point be OJ.
That's the problem. I mean, I can only wish him the best, and it's not that I had a falling out with OJ in any way or anything like that. He moved on to other attorneys, to appellate lawyers, et cetera, and more power to him. I wish him the best, but I know that sometimes things get out of his control. I think part of this entire Las Vegas caper situation was somewhat out of his control. I mean, he just sort of was led around, by the nose by certain people. Not that he didn't have any of his own culpability, but this was something that was set up by Riccio, and Riccio wanted, if you remember, Riccio wanted to video it at first. He wanted to see if he could get a video camera in on this thing because he wanted to make a big, deal out of it and try to sell it to some TV network. I mean, that was in that from the beginning. So, it's OJ's fault for falling into all that and going along with it. But yeah, that is a problem. I mean, he tends to be like that, and I hope that he's honest about what he said in his parole hearing, that he's away from the alcohol and all that stuff, because that's another problem.
I have another question for you, Gabe, but what you just said brings me to yet another one. I was a little taken aback when he said at the hearing that he's never really had any substance abuse or alcohol problems. Maybe he's never been an alcoholic, but we know he had anger management problems, and he flies into a range, and he took a course in prison about dealing with violence, which he hopes will help him on the outside. But he also says he's never held a weapon to anyone. Now, I know he was acquitted of murder in California, but he was found liable in a civil case, and maybe he thought that the commissioners just wanted to hear from him in the context of the Nevada case, and he's denying, and he didn't, no one ever said he held a gun, so he didn't brandish a weapon in the hotel himself. But that really, didn't sit well with a lot of people when he said, I've never held a weapon to anyone, because he can't really make that claim.
It's one of those cringeworthy moments in the parole hearing when he's talking, because whenever OJ talks about anything, most people will refer back to the California situation, to the 1995 trial, and when OJ says things like, even when I think I made a comment because I was being asked by another news station whether OJ, if I thought OJ knew there were guns involved in this Las Vegas robbery, and I frankly, I mean, I still to this day, I fully believe that OJ, before and during this caper, did not know that there were guns in people's waistbands. I think he found out afterwards. I mean, if you go back on the record and watch my cross-examination of McClinton, who was one of the guys who carried a gun, when they got back to the Palms after the Palace Station and after they picked up the property at the Palace Station and got back to the Palms to sort of divvy it up or whatever, OJ was next to McClinton in the back of an SUV looking at this stuff, at the Montana prints and things like that, and he asked McClinton, hey, did you guys have a gun? And McClinton told him, yeah, we did. McClinton agreed with that on cross-examination, that was the first question OJ asked him after the whole thing. So that came out during the trial. So and so when I make the comment as his lawyer at the time that OJ's not a gun guy, he would have never brought a gun, you know, it brings up, well, he's a knife guy. You know, like people would immediately, I got that response. You know, like people were saying, well, yeah, he may not be a gun guy, but he's a knife guy. So everything you say about O.J. is permeated by this 1995 situation. It's hard, and so the more O.J. talks, for example, at his parole board hearing, the more he brings that into it, like saying, I've never held a weapon, I've never done anything wrong to anybody. That whole parole board is thinking in their mind, well, what about Nicole? I guarantee you that's what they're thinking.
Right.
So that's why it's better not, whether he was acquitted or not, that's why it's better just not to talk.
Right, that's right. Well, just one last question, and then I'll let you go because we're going to get back to the Eric Campbell trial. If this were not a high-profile person, or specifically not O.J., what would the sentence have been under these facts?
First of all, what I always say about that is there's a couple of answers, but first of all, it's a normal person, a regular person, let's say, a regular Joe on the street, would not have been charged with 13 felonies arising out of this case. The prosecutor would have looked at it and would have said, wait a minute, do these guys know each other? You know, Fromog, Bruce and Beardsley knew O.J. You know, there would be a lot of sort of machinations going on before there is even charges filed, where if the person would hire a defense attorney, the defense attorney would go talk to the prosecutor and say, wait a minute, it wasn't even a robbery. So the chances of this happening this way would have been very, very small. He may have been charged with a couple of things, a normal person. The sentence would have been nowhere near what it was. What I will say about that is we have to be a little bit circumspect, a little bit careful about saying, well, he was only sentenced to that much time because he's O.J. I believe that has a lot to do with it. But there's also the issue, as any defense attorney will tell you, and as you guys know, you know, there's a lot of people who are offered probation before trial, and then they go to trial and lose, and they get 20 years. So that happens. So I don't want to downplay that whole sort of American tradition of whacking people who go to trial and lose. So that happens. That may not have anything to do with O.J.
That used to trouble me as a prosecutor. I thought, geez, it doesn't seem fair that I'm offering such a light sentence and they're simply exercising their right to go to trial. But I never had such a disparity like probation in 20 years. It might be 4.5 to 9 or 6 to 12 after trial. So anyway, we have to wrap it up now. Gabe Grasso, thank you so much for joining us and sharing your thoughts post-parole hearing for O.J. Simpson. Good luck in Dodge City, and I hope you get out of Dodge soon.
I'm getting out of Dodge in about 5 minutes.
Okay. Safe travels back to Nevada.
Thanks, Beth. See you next time.
Okay. Take care. So we'll go back to the Eric Campbell trial in just a few minutes. Well, maybe we should go back now because Dr. Hagen is still on the stand, I see, and when they break for lunch, we'll be able to continue our discussion.
I'm glad you got the get out of Dodge line in there. That was good. Okay.
All right, we'll go back to Eric Campbell now. Dr. Hagen's on the stand.
In addition to just the records about Eric, are you provided information about the actual case, the facts of the case from the investigation?
That's correct.
Tell us a little bit about what kinds of things you were provided about what we call discovery material.
Well, there was the autopsy report and photos of Mr. and Ms. Faulkner. There was additional FBI information from Agent Castillo. There was also the Brazoria, Texas assault photos of Holly as the victim of the assault in Texas. Police reports and supplemental reports, the fire marshal report, the first responders, the people who were there first on the scene, their reports and statements. Then there were the indictments. There was a letter from about a conversation with the Sheriff Wilkins, and a letter regarding Eric Campbell's car ride. That is while he's being transported. Photos of the victim's vehicle. And then there was the suicide report regarding Eric's father while he was incarcerated pre-trial. I had the transcripts of Holly Campbell's 911 call back in Texas that had led to Ed being locked up pre-trial, driver's license information for Ed and Eric, and the Virgilina fire reports and statements.
Ladies and gentlemen, we're going to take our lunch and recess at this point. During our lunch and recess period, it is your duty not to talk among yourselves about this case. Duty not to talk to the parties, the witnesses, or the lawyers about anything at all. Further, duty not to talk to anyone else, allow anyone else to talk to you, to say anything in your presence about this case. If anyone communicates with you in any way, you need to let the sheriff know about it when you come in. Don't do any individual research or investigation on your own about any issue touching on this trial. Stay away from your smartphones and do not form or express any opinion about this case during this time. With that, ladies and gentlemen, while everyone else will remain seated, I will excuse the 17 of you and ask that you return and assemble in the jury room at 2:30 this afternoon. That's your excuse.
Welcome back to LawNewz Network. I think they were going to a sidebar, but it is the lunch hour. Typically, they break at 1 o'clock Eastern, and we're 1 minute to 1 o'clock here on the East Coast. So this trial is taking place in Granville County, North Carolina. I'm looking at the courtroom. Hang on. They're taking a wide shot, and there is some colloquy going on. So I think court is still in session. They're back in session. So I jumped the gun saying it was the lunch break. Let's go back into the courtroom.
Make sure flag jurors ask from the floor. May I record that?
Yes, sir, Your Honor. Dr. Hagan testified, I believe, that when he was going through the all of the things that he had been provided that he based his opinion on, he stated that he had a West Virginia investigator interviews of family members from the public defender's office there. I do not know that we have any of that information that we have been provided as the basis for his underlying report. I've looked through, and I could be mistaken, but I don't believe that we have any interview, specifically in our interview with Sherry Barnes, the aunt, by Steve Bostick, with the West Virginia PD investigator. Now, if I have that, I would be, perhaps I've overlooked it. And I would just say, Judge, that that is a violation of 15A 905. We have been asking and asking for the underlying data and what this expert based his opinion upon. In fact, 15A 905C2 says that we are to be provided the expert's opinion and the underlying basis for that opinion. If he based his opinion on what Sherry Barnes or anybody else told a West Virginia public defender investigator, we're entitled to that. And we were entitled to it back in May. The defense made an inquiry of the state earlier this week as to whether we had turned over everything, even email correspondence with Dr. Wolf, and the state has done that. We have not been given the same courtesy unless I have missed it.
Yes, Your Honor. On April 25th, 2017, I filed a certificate of reciprocal discovery, number 5, and in it, I provided the state a copy of this after it was filed. And in it, it says that I provided the state with a disc labeled 008361. When I labeled discs, I labeled them as an additional base stamps page with an audio recording of an interview conducted by a West Virginia private investigator referenced in the report of Dr. Hagan, which Dr. Hagan was discussing. I don't have a specific memory of that, but I don't normally file things like this unless I provide that information.
Well, I will certainly look over lunch.
Okay, please do. See if I can get together and see if this is wrong. Yes, sir. Anything further reference?
No, sir.
Anything reference?
No, sir.
Chair can recess at 2:30. Anyone stand?
Welcome back, everyone. I'm Beth Karras, your host for the next half hour or so, joined here in studio with attorney Michael Bryant, defense attorney?
You know, occasionally, but more often plaintiff's side.
Okay.
Yeah.
But also former reporter with me at, I remember when you started at Court TV.
Yes, I remember the days.
I trained you
yes,
on the Court TV
did.
ways, yes. That was nice. I don't remember which trial it was.
It was somewhere in Ohio. I do remember
was
that.
It Toledo?
There was a minister.
Father
Priest.
Father
the
Robinson.
Priest,
He
that's
died
right.
in prison, but he was convicted of murdering a nun 25 years earlier on Easter weekend. It was Holy Saturday, using a letter opener
in the what's
sacristy,
that room? The sacristy,
right.
thank you.
And he put an altar cloth over
Toledo.
In Toledo.
Yeah.
He stabbed her in the shape of an inverted cross.
Yeah.
Anointed
Your recall
her,
for these
anointed her
details
with her own blood.
frightens me.
Anointed her with her own blood, with the letter opener on her forehead, and then covered her in an altar cloth. Had pulled her pants down, but there wasn't a sexual assault. It was a horrible case. He wasn't arrested for like 2.5 decades. All right. So what we just heard, this colloquy, this argument in the courtroom, had to do with the prosecutor needing to prepare to cross-examine Dr. Hagen.
Right, right. I mean, my motto used to be a surprise a day. That was kind of when I did, that was the goal, but not an inappropriate or improper surprise. In this case, there may or may not be some report that this expert has prepared that has not been given to the opposition. And if you don't have that, you can't properly prepare. The law says you have to disclose that. So she's going to look at lunch and see if she maybe got that.
She said she needs to know what he's basing his opinion on, beyond what he testified to orally. So we see this a lot.
Of course.
You commented when he first took the stand about like his body language.
Yeah, it's so easy to spot a hired gun, an expert, because they've been trained, and even more so when you're a psychologist and you understand the dynamic of that contact, that connection. So he hears the question over here, and then he's bam, right at the jury. Yes, you know, we need to do this, and this is my job. And I mean, he connects with them immediately.
Right, which, I mean, I guess.
It's true of every witness. Every witness should do that.
Right, works with, you know, what do you think about using expert witnesses? I mean, the rule for using an expert, at least the New York law, the New York case law says it's got to be somebody who has knowledge beyond the ken, they use the word ken, K-E-N, the ken of the average citizen. In other words, it's some kind of expertise that we're not expected to know.
What the layperson doesn't know, yes.
What the layperson doesn't know. But then each side can get someone to basically say what they want.
Yep. Yep, and it comes down to, as we know, the battle of the experts, and you know, sometimes it detracts from the facts and from the evidence that's being presented, but it's powerful stuff. And if the jury likes expert A better than expert B, sometimes they ignore the evidence, sometimes they ignore other testimony. That's just a fact.
I don't know, some of them can be so slick, they're like snake oil salesmen. Dr. Hagen really
he's
evaluated.
He's a folksy boy, he's a good boy.
He's good.
And these
Dr.
are
Hagen.
North Carolina jurors. He's from the hood, sort of, Virginia. And so he speaks
West
their
Virginia.
Language. Yes. Right. So, they're going to be receptive to him, I would think.
So what do you think about how Eric, from what you've seen of Eric Campbell, how he did on the stand? He's trying to save his life.
Of course. And I think either he's a tremendous actor or he is truly a whipped puppy dog that the defense is trying to portray. I mean, he looks so familiar to me. I finally figured this out. Not to be disrespectful to the process, but he looks like Where's Waldo? If you put the striped red and white shirt on the kid, and he could hide out somewhere. He just looks so mundane and just so harmless. And that's what the defense is obviously selling.
Yeah, they dressed him up. They put a tie on him. They put these spectacles on him. I don't know if those are prescription glasses or not, but he wasn't wearing glasses, in his mugshot. Well, his face is all beat up. Did we hear the explanation for that? I think he said his father had beaten him.
Yeah, and that, of course, that would be the only reason for the defense to even throw that in there, because if it was a police abuse issue, I mean, you're going sideways. What's that got to do with anything? So obviously they're trying to suggest that this kid has good reason to be afraid. Look what his dad did to him.
Well, he did look pretty bad in the case. Now, the case is supposed to go into next week. So that says to me that maybe the defense is going to call, if not other family members, some corroboration for the abuse. Wouldn't you want to hear something beyond just his words?
Of course, of course. Anything, if you believe him at all, anything you can pile on in terms of corroboration from family members or others who had intimate experiences with his abuse, alleged abuse, that's going to help. It's going to help the jury.
You know, listening to the abuse he says he suffered makes me think about a case I covered when you were at Court TV, and it was tried in Alamogordo, New Mexico. That was a change of venue. And the defendant was 16 years old at the time, not 23, 24 like Eric Campbell. And he killed his father, stepmother, and stepsister. Shot him and put him in the manure pile in July of 2005, where they decomposed very fast, so badly that the jurors didn't even see a lot of the photos because they were way too inflammatory. But I'm talking about Cody Posey. Not analogous here because he killed his father, but he did, basically his life of abuse made him snap. He wasn't going to take anymore, and he killed everybody. Do you remember the case?
I vaguely remember that because of the manure pile, sort of a memorable, I don't know if he did that.
It was on Sam Donaldson's ranch. Sam Donaldson found the crime scene.
Was that purposeful? Did he put him in the manure
knowing
that?
With a backhoe, one by one, in the backhoe.
But knowing that it would help them decompose, did he think it through to that degree? I can't remember.
He was hiding them, and I don't know if he had any other place to hide them.
Just
it's a great big manure pile.
Okay. You know, this is, like any of these cases, it's a matter of degree, right? You know, the jury has to believe the premise, first of all, that this abuse has led to these behaviors that are just plain wrong, criminal. But how far along that spectrum will they go? You know, at one point will they say, look, he might have been abused, but he's not going to continue to see his father when he's in jail. He's not going to do everything that his father tells him to do out of fear. The reasonable person in the jury has their own point on that sliding scale at which they'll say, forget it. I'm not buying it. He's abused, but he's not going to do this because he's abused.
Right. I mean, what I see as the limit for jurors, I'm not there. I didn't see jury selection. I can't eyeball these jurors because I used to read a lot from body language or when they might take notes or something, but that's it. And you cannot. Anyone who tells you, well, I'm sure the jury is thinking this or that, doesn't know what they're talking about. Right? Don't ever pay attention to anyone who tells you what they say the jury is thinking, because you don't know. But I would imagine that a limit for them would be, don't give him death. Just give him life, spare his life. But he can't walk away from this.
I can't imagine a walk. No, I can't imagine that. But you're right. It's a jury. How many times have you been surprised by something you thought would go one way and it didn't?
And just to finish the story with Cody Posey, the jury convicted him. It wasn't a death case. But he was found, these were 3 murders, boom, 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 shot in the head, everybody close in time. And one was first degree, that was the father. Second degree was the stepmother. And, no, I'm sorry, manslaughter was the father because he was the abuser. Second degree was the mother, she abused him too. But first degree was his 13-year-old stepsister, who really didn't have anything to do with anything except she used to rat him out at school if he talked to anyone or smiled, and then he'd get beat up at home. So he said. Anyway, and then the judge had the option of sentencing him as an adult or a juvenile and gave him juvenile time, and he got out at the age of 21.
So that makes my point on that whole spectrum, because that's the spectrum applied in reality. There's 3 deaths. The jury found at each level.
3 types of homicide.
Exactly.
And he got a juvenile sentence.
Yeah, that was a gift.
Yep. He stood in front of that judge and said, I'd like to become a lawyer someday and help people like me who were abused. He didn't become a lawyer, but he's in Albuquerque. The last I heard, he was working in for an optometrist or something. Had a girlfriend, has his own apartment. So that's the last I heard.
Wow.
I've been trying to track him down. Anyway, let's review. Let's go back to some highlights from earlier today on the cross-examination. Well, actually, the cross-examination started yesterday with EC30. Can we go back and play the beginning of the cross-examination? Because we know what he said on direct. Let's see how the prosecutor was handling him.
Mr. Campbell, you've spoken to the authorities several times about this matter, is that correct?
Yes, sir.
And you spoke to them on January 1st, 2015.
Yes, sir.
You talked to them just after you were taken into custody, is that right?
Yes, sir.
And you were taken to Greenbrier County Sheriff's Department and you were read your rights.
Yes, sir.
And you were told that you had the right to remain silent?
Yes, sir.
And you were told that you had the right to an attorney?
Yes, sir.
And you were told that anything that you could be used against, anything that you said would be used against you in a court of law?
Yes, sir.
And you waived those rights, is that correct?
Waived them?
You waived them?
Yes, sir.
And you knew that when you waived them, that you understood absolutely what you were doing.
Yes, sir.
Okay, and you said at that time you were going to tell the officers what happened. Is that right?
Yes, sir.
And today, when you began your testimony, you stated that you told them everything that happened. Is that right? You told the jury that you were going to tell them that today. Is that right?
I told them everything that I could.
You told them everything that you could. What could you not tell them at that point?
I told them everything that I was able to.
Okay, so you're saying that at that time you made a complete and total disclosure to the law enforcement authorities in West Virginia.
Yes, sir.
But you told the jury that you were going to tell them everything, that you were going to tell them everything today. Is that right? The truth, the whole truth,
yes,
and
sir.
nothing but the truth?
Yes, sir.
Okay. Do you remember that conversation that you had with the authorities in West Virginia?
Not particularly, no.
All right. It was recorded, is that right?
I understand it was recorded, sir.
And you've seen a transcript of it?
Yes, sir.
Okay. Did you, you told them about that evening there in the Cornwall community, didn't you? Is that right?
Yes, sir.
You told them that you saw Mr. Faulkner checking his mail, is that right?
Yes, sir.
And that at that point you turned around to go investigate further, is that correct?
It was the house across the street.
All right. The house across the street that you were talking about camping at earlier, is that right?
Yes, sir.
You said your dad grabbed a sprayer.
Yes, sir.
And it was a backpack sprayer with a hose and a nozzle and a pump on top. Is that right?
Yes, sir.
And as a matter of fact, it's the same sprayer that's sitting here in evidence right now?
Yes, sir. That's what my dad had.
It's the same sprayer that you bought at Home Depot?
Yes, sir.
It's the same sprayer that you and your father filled with drain cleaner and water. Is that right?
No, sir.
Is it not filled with drain cleaner and water?
I didn't know it was filled with drain cleaner.
You said he sprayed it in the guy's eyes.
Yes, sir.
He grabbed a sprayer and a crossbow. He told me to come with him. Is that what you told him?
He had a backpack and a crossbow.
He went through the forest, which wound up at the back of this guy's property, and he walked around the side of the house, and he told me to stay there at the corner. He went to the guy's door and knocked.
Yes, sir.
The guy answered the door, and he took the sprayer, ran into the house, sprayed him in the eyes, and I didn't see the rest of it. He came back outside and grabbed me. He pulled me inside. We were both in the bedroom. They were both screaming for help. Do you remember telling Sergeant Baker that in West Virginia?
Yeah. Yes, sir.
And when you were asked who was screaming, you said the wife was. And when you were asked, and the man, and you said, yeah. And then he stabbed him. Is that what you said?
I don't know. My dad had a weapon in his hands when he was hitting them.
When you asked if he stabbed them, you said yes. And then you said, where did he stab them? Did he shoot them or stab them? And you said, crossbow. He shot them with a crossbow.
Yes, sir.
But that's not how you said it earlier, is it?
He shot them with a crossbow.
Well, but you said earlier you said he shot him with a crossbow, then he stabbed him. Is that right?
I saw my father's back as he was hitting them.
You said earlier that when you walked into the house, there was a man sitting there, or laying there with a crossbow bolt sticking out of his chest. And you said to yourself, that doesn't belong there. Is that what you said earlier?
My dad dragged me inside the house, and yes, that is what I said.
Okay. But when you told Roger Baker what happened, you said you saw him shoot
I saw him shoot.
the man with a crossbow. Is that right?
I didn't see him shoot the man with the crossbow. I know he shot Dora.
When you got in the house, your dad's already sprayed them with whatever's in the sprayer, and you said, then he stabbed them. Is that right?
I don't know.
Would it help to look at the copy of the transcript? Would that refresh your recollection?
I believe it is what you are reading it as.
Well, I mean, it's not what I said, it's what you said, isn't it?
If I got the order wrong, I'm sorry.
This was the day after it happened, is that right? And this is at a time when it is fresh in your memory, is that correct?
Fresh. I don't know.
Did you hear the question?
Yes, sir.
Okay, so you can understand the question, right?
Fresh. I didn't want to remember any of it.
All right.
If I got it in the wrong order, I didn't mean to.
Well, you
if I got the wrong person, I didn't mean to.
You just recounted it for the jury, didn't you?
Yes,
so
sir.
when you recounted it for the jury, did you tell the jury everything that happened?
Yes, sir.
Welcome back to LawNewz Network. We're on a lunch break in the Eric Campbell case. Eric Campbell has completed his testimony. He was on direct examination yesterday, a little bit of cross. His cross finished today, and when court broke for lunch, a forensic psychologist who evaluated Eric Campbell is on the stand. And this is a case that really cries out for a psychologist to help evaluate Eric Campbell's testimony and just like who he is. And I'm joined by Michael Bryant, an attorney, sometimes defense attorney, often a plaintiff's attorney, former colleague from Court TV, in studio here. But this is a case where you have to have a psychologist explain.
Well, of course,
his behavior.
and we've seen some of the prosecution attempt to rebut this defense of abuse by showing family photos from 2009. Here, it's just a happy family. Come on, this is not long-standing, lifelong abuse here. I don't know how far that goes because we're talking he's 23, 24 now. That would have been his early teens, mid-teens. I don't know. It's something. I don't know if it's effective.
Yeah, well, they're putting. I guess that kind of stuff, though, can come in mitigation if he's convicted of first degree and there is another phase to this, right?
Of course.
This is absolutely relevant for the case in chief also, but the door's wide open in mitigation if it gets to another phase,
Yeah,
right?
Right, yeah, and that will certainly help. And they may be just laying the foundation for that now.
But I assume this jury will have lesser included, so maybe they'll have something, either second degree or whatever they call the lesser degree to the top count here to consider if they believe that he was standing there, not necessarily doing nothing, but he didn't actually inflict any of the fatal injuries. If what he's saying about his father is true, though, what a monster. I didn't hear the testimony yesterday because we were all fixated on O.J. Simpson's parole hearing, but I had read that the reason they took the two bodies with them, I mean, they burned the house, got rid of a lot of
forensic evidence. They threw the bodies in the family truck.
Yeah, in the truck. According to Eric Campbell, from what I read, is because the father wanted to take Mr. Faulkner's face, sort of make a mask out of it and put it over his own.
That's not strange. No, I mean that's out of a bad movie. I mean, really.
I don't know.
Is that Eric Campbell just winging it because who's going to contradict him, or is it even worse, the truth?
Is it the truth?
Yeah.
Horrific. What a thought. Anyway, again, I read that. I hadn't heard that part of his testimony because I was doing OJ all day yesterday. By the way, since we have a few minutes before I have to leave, what did OJ tell you when you interviewed him 3 days before the verdict?
Nothing. No, I mean, I was doing the live trial through The Legal Edge, which was my company, and it was just at basically, Court TV was ending. And so, you know how it is when you're hanging out in the hallways there in the court, you get chummy, you get friendly with people. quite often it's not the defendant, but with OJ, that's a different story. So he told me he was going to be at church on the weekend. We're just chatting. I'm like, what's going on this weekend? I knew he had connections in Vegas. And he said, well, I'm going to go to church. And I said, oh, really? Which one do you go to? You know, and before long, he tells me which session he's going to. I didn't believe that. So I went the one before. And sure enough, he was still sitting in the church getting ready to leave. And as he comes out, I just approached him in the lobby. Hey, how you doing? And he kind of gave me the, oh, you got me kind of look. But not like he didn't expect it, you know, almost like he was glad. And so we just chatted for a few minutes outside on camera. And I was asking him how he was doing, and some of the specifics about, you know, he has a couple of songs that he likes to whistle and sing. You know, the Scarecrow song, If Only I Had a Brain. Remember, they made so much of that every time he was in court. And so we just chatted about that. We chatted about his religious convictions, how important that is now. How he said how tough it was to hear some of the things he had to hear in court. And, you know, it wasn't like I was going to say, oh, yeah, by the way, remember back in '94, that little thing happened? I wasn't going to do that. Yeah. And I also wasn't going to jeopardize the process by creating an issue that would jeopardize the trial. That would have been wrong. And so we just kind of had that kind of more broad conversation about how he felt things. He was friendly, happy. I really felt like he had no clue, really, how things were going. And he learned soon enough.
On the day of deliberations, though, jurors had notes. They had a note about his co-defendant, C.J. Stewart, which I don't remember the note, but it indicated that they were convicting. And so if they were convicting,
if he was going down,
Stewart,
then OJ had to go down.
So when
too.
they had the verdict, OJ had been at dinner, and I think he just took his time coming back to the courthouse because it was his last free day.
Yep.
Until October 1st or soon after that this year.
Yeah, so it was fascinating, and it was OJ, as we've come to know him, just a chatty, social guy. As I like to say, he's the friendliest killer I've ever met. So, yeah.
Oh, a lot of killers are charismatic.
Yeah, well, that can be part of their weaponry.
Ted Bundy.
Yeah.
I've had a few conversations with him too, but anyway, we're about to put OJ to rest. Although I'm afraid until he's absolutely off parole or until he leaves this world, he will always in some way be a part, in the news.
It's the gift that keeps on giving to journalists, yes, unfortunately.
Well, we're going to go back and review some more of the Eric Campbell case, and by the time we come back, I'll be out of the anchor chair and Aaron Campbell will be here, so I want to thank you all for joining me today, and I'll be back next Friday. We're now going to go back to some more cross-examination of Eric Campbell, and this is EC 31.
So he said, this is what it feels like to see what I see, and he grabbed a spear and he speared the guy.
That was what my dad told me. He had told me after, when we came to the office, that he had tried to impale the guy with the spear.
Well, you told Roger Baker that's what you saw.
I was trying my best to tell them everything.
You said I'm sorry, I missed that part. Apparently, a woman had gotten a gun, and he had gotten a gun in his hand also.
Yes. He said that he had disarmed her, and he said that she had almost shot him.
Because when you went to the front door of the Faulkner's house, they were armed, weren't they?
They were not. I don't know. I don't think so, though. My dad didn't say that.
They both had guns.
He said he got the gun from the dresser.
He got the gun from the dresser, which is not in, it's in the bedroom, isn't it?
I believe so.
You said he got it out of the dresser and he shot the guy in the leg.
Yeah. My dad shot the guy in the leg.
Did he stab the guy with the spear that you had in your bag?
He said that he stabbed him, yes.
Well, did you see it?
I didn't see him stab him.
But you had the spear in your bag.
Yes, sir, I did.
So how did he get the spear out of your bag to stab them if you didn't see it?
He had jerked the bag off me and told me to go in the living room.
But you were outside, remember?
He had pulled me inside.
But you were outside for 5 minutes or more. Is that what you said?
I don't know how long I was outside.
You were outside with the shoulder bag. And where was the spear?
It was inside there with the telescope and the water jug.
So you're outside with the telescope and the spear and the water jug, and he's inside with a crossbow. Is that right? He went to the door with a crossbow and bolts
Yes,
and
sir.
sprayers. Is that right?
Yes, sir.
A crossbow that he had to manually load. Is that right?
That's the type it was, yes, sir.
It was a crossbow that had a shoulder stock. Is that right?
Yes, sir.
And you fired it by putting it against your shoulder and releasing the trigger. Is that right?
Yes, sir. A trigger released it, yes, sir.
You and your dad had both practiced with it along the way. Is that right?
We had stopped there because we wanted to find some deer and practice with it.
And you loaded it by putting the foot stirrup on the ground and pulling the string back with both hands until it cocked. Is that correct?
Yes, sir.
And it took a considerable amount of strength, didn't it?
I believe so.
You said he shot the guy in the leg. He started screaming for his wife. He told the guy to give me the money or I'm going to shoot your wife. The guy said no. My dad picked gun up and pointed it at his leg and fires a bullet. He screams, "Where's the money at?" The guy still wouldn't answer him. He asked the wife doesn't answer him. He takes the spear. He starts beating him with it.
Sir, I got it. I know that's what it says.
Well, that's what it says because that's what you told Sergeant Baker. Is that right?
I tried to get everything in the right order, and I probably did not.
Okay.
I know I did not.
But most importantly, you got everything in the right order this time because you were actually in the house when this was happening. Is that right?
No, it's not right.
Well, how did you know everything was happening if you were outside at the corner of the house?
Because my dad explained everything to me when I was in the office.
All right, but
He
you didn't tell
recounted
them that, did you? You recounted it in the first person, didn't you?
Because I tried to tell them everything that happened.
You said he starts beating the man first. The man's on the ground bleeding. He reloads the crossbow, points it at the wife, and fires a bolt in her side.
Yes, sir.
Now, there are two people, is that right?
Yes, sir.
And there were guns in this house?
Yes, sir.
The Faulkners had guns, right?
Yes, sir.
And you had walked up to a strange house?
My dad had walked up to a strange house.
Well, you were with him,
and
weren't
I followed him.
You followed him.
Yes, sir. I didn't know that he was going to do that to those people.
And you were strange to them, is that right?
Yes, sir.
They didn't know who you were. The detective said he was still alive after getting stabbed in the neck, and you said he was breathing. You said, I was staring at the man, and she's crying on the bed, and he grabs the bag. The detective said, grabs what? He said, grabs the bag. He wraps it around his, not to prolong his suffering. Is that what happened?
He explained to me that the guy wasn't dying. Well, I don't remember a bag.
You didn't say explain to Roger Baker, did you? You weren't talking about that. You were talking as if you saw this in the first person. Is that right?
I know I was.
So did you not tell Roger Baker the truth?
No. Saying that, even though I said it in the first person, did not. The order was wrong.
What order was wrong?
The way things happened. I told them things that my dad had told me.
So at that time, even though you told him like you were in the first person, you say you were relying on your dad's account of things?
No, I wasn't lying. I was trying to tell them everything I could.
Welcome back to the LawNewz Network, everybody. I'm Aaron Keller. I'll be with you for the afternoon hours here as we stand by for the sentencing of Dalia DiPolito. She's the Florida woman who was ultimately convicted after her third trial on charges she was hiring an undercover police officer to be a hitman to basically kill her husband, who she was many thousands of times sure, she said in hidden camera video, she wanted dead. So an interesting case there because it took 3 trials to get to the conviction. The first was a conviction, but it was overturned on appeal because of a legal issue. The second case, which the state flew through very, very quickly, ended in a hung jury, and many observers said that the state really wasn't trying that hard in the second case. The third case ultimately ended in a conviction after Dalia DiPolito's lover, Mohammed Shahade, testified that he had heard her discuss wanting to kill her husband multiple times, and he even was forced to admit that he had heard her saying that he wanted to poison her. So we're standing by for the sentencing of Dalia DiPolito in Florida. When we talk about sentencing, what's the judge going to look at?
You know, it's that weighing of the aggravating versus mitigating factors. And, you know, as we understand the defendant's position, her biggest mitigating factor, she has a young child, 16-month-old child, needs mom. I don't know if that child needs a crazy mom as much as a real good mom, but that's going to be one of the arguments, if not the key argument, made to get the lowest sentence possible. I think she wants to get 2 years, which is about half of the normal minimum, although she could get up to 30.
So we've got the judge on the bench. We're about ready to go into the courtroom. I think we've got the feed up, so let's go straight to the courtroom in Palm Beach County, Florida. While, well, it's going to take us just a second longer, but we're about to go there. The judge is taking the bench in Florida, so it'll be interesting to see where sentencing goes for Dalia DiPolito, again convicted after her third trial on charges she hired an undercover police officer to try to kill her husband.
Weather here, and if we get any kind of power surge, I don't know whether you're going to drop off or not. So that's the only caveat.
One issue with Mr. Claypool, very easier for me to explain to him. He's been going through some medical procedures, so I apologize for him not being here. He can only be on the phone for about 30 minutes because he has to go back to the hospital. So he's asking if he could go out of order and say a few words at the beginning before the state, so we can go back.
I have no, Mr. Williams, any problem with that? Ms. Lori? No, I have no problem with that. We can start with Mr. Claypool if you wish, and then he'll have to let me know when he wants to drop off the phone, and hopefully, and then he'll have to let me know when he wants to drop off the phone, and hopefully I'll know how to do that because I didn't make the call. My judicial assistant set it up. So do you want to start with that? Or at what point do you want to do that, Mr. Claypool?
You know, I could do that now with the court's permission. I do thank you for the accommodation by phone and for allowing me to go first. I've got a medical follow-up for an ultrasound at about 2:15 your time. So I just have a few comments I wanted to be able to make, and then I'll defer to my esteemed co-counsel and Mr. Williams. Thank you.
Okay, go ahead, Mr. Claypool.
Great. Yeah. Yes, Your Honor. What I'd like to ask the court to do is, first of all, take into consideration that Dalia DiPolito is a human being. I know this case has been highly charged. The emotions have run high in this case in South Florida for, 7 or 8 years. And what I'm hoping that the court will not do is allow emotions in the sentencing hearing to eclipse the fact and the human aspect of the case. So that's the first thing I'd like to ask the court to consider, because I know at the first sentencing hearing it got into almost like a personal affront on Dalia DiPolito. But at the end of the day, this case is over. She's a human being as well. Second point I wanted to make, I wanted to articulate 2 or 3 mitigating factors that I would ask Your Honor to take into consideration. During both the second retrial and the third retrial, especially the third retrial, there was clear, unequivocal evidence, in my estimation, of destructive evidence by the Boynton Beach Police Department, especially the Chili's tape, the 45-minute encounter. Why is that important in the sentencing hearing? Because I think we established in both trials that this investigation was compromised. Now, while the state might get up and say, well, that's not relevant, we had other evidence to eclipse the lack of evidence, Your Honor actually gave an instruction, a jury instruction, which I believe was proper at the last trial, that indicated that an adverse inference can be drawn from that if the jury believes there was a destruction of evidence. So I'm asking the court to at least take that into consideration as well, that this investigation, in our opinion, it was established in both trials, was compromised to the lack of preservation of critical evidence. Third point I want to make is that I know Mr. Williams made a point in his brief that they had all the jurors in this case on board, including the alternates, and that this is pretty much a slam dunk. And I'd like to respectfully remind the court that in the second retrial, as a mitigating factor, we've gone down this road before, but we had a hung jury, and we actually had those alternates in our camp, and that was a vote of 5-3 for an acquittal on behalf of Dalia DiPolito. And I think that is a factor that should be considered as mitigating, because this isn't a monster that the state is portraying. This isn't a close your eyes, slam dunk case, as borne out by the hung jury in the second retrial. So that jury did struggle with whether Ms. DiPolito was culpable for this crime. So I hope that the court would consider that as well. And a couple of the last points. I know we've talked about this a lot, but I do feel like the unequivocal evidence of both retrials of the Cops TV show filming during this investigation, that many witnesses testified that clearly compromised the integrity of the investigation, that people end up acting differently because their camera's filming. And I would just ask the court, or Your Honor, to have it in his heart to consider that fact as well. And that leads me to one other quick point, which is, there was a lot of talk made in the state brief about how Ms. DiPolito, she was determined to have her husband Mike killed, and she was destined to do this. And the fact of the matter is this, Your Honor, I think we've established in both the second and third retrial that the majority, I think almost all of the phone calls initiated in this undercover investigation were done by either Mr. Shahade or Willie John. And I believe that the handful of phone calls that Ms. DiPolito initiated to either Mohammed Shahade or Willie John were return phone calls. Some people might think that's not important, but I'm asking the court to consider that as a mitigating factor in sentencing Ms. DiPolito, because it's always been my opinion in this case that absent the involvement and the initiating and the instigating of the phone calls by undercover law enforcement, that this crime would have never been committed. And the court in the last retrial did allow the evidence of this alleged evidence of the Riviera Beach scenario, that Ms. DiPolito allegedly was trying to talk to somebody else. Well, ironically, that was 5 or 6 months before this undercover operation took place. So the fact that nothing happened at all by Ms. DiPolito to try to do anything to have Mike DiPolito killed during that 5 to 6 month interim time period, I think should be considered as a mitigating factor alone. At the end of the day, Your Honor, I really believe the evidence in this case showed both second and third retrial that absent law enforcement involvement in initiating and escalating this undercover operation, that this crime would have never been committed. And I ask the court to consider that as a mitigating factor. And the last point I wanted to make, Ron, I told you I tried to be brief, is I would like the court to consider the evidence in both the second and third retrial that at the time that the Boynton Beach PD did intervene, Ms. DiPolito was in a vulnerable state of mind. Again, and I made it clear in both trials, I never preach to anybody that Dahlia DiPolito is a choir girl, or we weren't asking anybody to feel sorry for her, or that she's a superb person in the community. I've never said that. But one fact that I think was clear both the second and third retrial was that at the point that Mohammed Shahadi reached out to the Boynton Beach PD, he never wavered in his testimony that Dahlia DiPolito was in a vulnerable state of mind. She said, either I want to die or Mike wants to die. And I think that fact should be considered as a mitigating factor. We're not trying to make an excuse for what happened here, but I think the state of mind of Dahlia DiPolito at the time should be considered as a mitigating factor. And the last point that I forgot to make is the issue that Mr. Williams went into in his brief about all the text messages between Mike Stanley and Dahlia DiPolito. The court admitted a lot of those text messages in the third retrial. And the only point I want to make about those, Your Honor, is Dahlia DiPolito was not on trial for harassing her husband and trying to make his life miserable. And certainly we're not condoning those text messages, but there was nothing in those slew of text messages that indicated that Dahlia had wanted to have her husband killed. And I do think that's an important fact, or a mitigating factor that I would ask that Your Honor take into consideration in the sentencing of Dahlia DiPolito. With that said, Your Honor, I do appreciate your time and allowing me to speak to this issue. Thank you.
All right, Mr. Claypool, is it appropriate now to disconnect you from the phone, or do you want to continue to listen?
I'd like to continue to listen for about 15, 20 minutes, Your Honor. Thank you very much.
Okay. I'm going to have some kind of signal which doesn't interrupt me, at least doesn't interrupt what's going on, to let me know when you're going to hang up.
Sure.
So just give me a quick word when you've reached that point. All right.
You bet.
Okay. A couple of preliminaries before we get started. Let me deal with probably the only things that the parties will agree on in this entire sentencing hearing. First is I've been told, I want to confirm that the jail credit that Ms. DiPolito would be due with respect to any sentence would be 163 days. Is that correct?
Actually, yes.
163. Mr. Williams, is that correct? I think you guys stipulated it was 163.
I'll be making arguments later to why she should be getting credit for house arrest.
I understand. I'm not foreclosing any argument. What I'm saying, gun club days are 163. Okay.
Yes, sure.
All right. Okay. One other thing I want to do before we get started. Has the state prepared the score sheet? I'm assuming you have.
Actually,
I'm required to sign it at some point. And the question I'm going to ask, so you're ready for it, has the defense reviewed the score sheet, and do you believe the score sheet to be accurate as prepared by the state?
I haven't received a new score sheet from them. The one from 2011 I have, and it's not quite accurate. They have the primary offense, solicitation with first-degree murder with a firearm. With the firearm is not her conviction, is solicitation to commit first-degree murder. It's not really a charge for.
I don't think it. Yeah, I don't think
it doesn't
really
change your scoring, but
yeah, it shouldn't, because it doesn't matter. There's no such crime.
Correct, but there is no finding of fact on the jury that the firearm was involved.
Yeah, it's only significant for 1020 life, which doesn't apply here. So you're printing a new score sheet?
Yes, sir.
Ms. Laurie? Okay, well, when you get it printed, we can proceed, but I want to make sure there's no disagreement about the score sheet. Just a couple more preliminary comments before we get started, just so I understand where we're at. The score sheet, as I understand it, reflects a score of 48 months. Is that correct?
That's correct.
All right. And in terms of, I usually ask what are the parties asking for right up front. I already know because you filed sentencing memoranda. My understanding is state is seeking 30 years. My understanding is that the defense is seeking 2 years. That's from reading with the downward departure. That's from my reading of the sentencing memoranda. Am I correct?
I believe we're at 2 years followed by probation.
Okay. But in terms of DOC, you're proposing 2 years. State is seeking 30. Is that correct? Okay. All right, I'm going to let the state begin. So, Mr. Williams, I understand what you're asking for. I'm going to give you the opportunity to tell me why. And if there's any witnesses you want to call, just let me know.
Just want to call a witness after. I just wanted to go through, take us back to who we're sentencing today. Give you guys some of our own words.
Yes, is that the score sheet? Yes. Did you show it to Mr. Rosenfeld?
This is correct.
Okay.
Judge, you heard most of this throughout the trial already.
Yeah, I'm pretty sure I'm familiar with the evidence.
I highlighted a few things in the text messages between her and Mike Stanley. So July 25th, 7 o'clock at night, she texts him, "Soulmates is what we are. We are meant to be together. You know I have baby names picked out. I want your child." July 27th, she texts him, "Don't forget to use the 305 courthouse number when you call me. Remember, we went to the courthouse on Friday and met with your paralegal, Sergio, and gave him that letter." Yes, I should probably know what the letter says, what Mr. Stanley says. She said just that he wanted the administrative probation so he would travel with work. She says, "Tell him you met with the judge on Friday and you'll let him know what's going on at the end of the week. FYI, the judge is calling, but don't mention his name." He texts, "You went to the court to meet Sergio Thursday, I believe. Anyway, I'm okay to call." She says, "Kay, just tell it looks good and you'll call him at the end of the week." Still the same day. She texts him, "Laugh out loud. He just told me thanks, baby," referring to the fact that she's going to get him on administrative probation so she can violate his probation. She says, "Do you think you can call the Treasury and see about freezing his account? Have them lock up his case. The sooner this shit gets fucked up, the better. What can be done to get him to violate probation? Did he ever mention to you our house?" She continues on July 27th. "The sooner he gets jammed up, the sooner we can be in Paradise Island, baby. I thought of a way to get him to sign the house over to me." He says, "Laugh out loud, so did I. Richard recommends it, but phony attorneys pretend to be." She says, "He was freaking out the other day when he found out his friend already owned our house. So much he thought we should put the house in my name." She says, "Exactly, I was just getting to that." She says, "Let's figure out tonight what to say exactly for tomorrow. Make the call." Still on July 27th, she says, "I need the house, which we'll take care of tomorrow. Next, we need to figure out his account." She texts, "We need to figure out how to wire that money out of his account or get the Treasury to freeze it. If he has nothing left, he has no power." He texts, "Missing a probation appointment and drugs in his car. That's him." She says, "We need to strategize the drugs." She says, "Baby, we need to make this happen with his arrest by this weekend. I need to be with you. Hate being away from you." She texts, He has some here at the house too, but I want to put X pills and coke in the car and Xanax." She says, "He doesn't sell. No good. I told you we need drugs in the car and it will put him away for a while." Same day, July 27th, she texts, "We need to figure that one out. This plan can't fail. We need to get him locked up. Or we need to plant it in the house and have probation find it." Same day, she texts, "We need to figure out a detective with a Bloomington PD you can call or his PO. We need to get this to work. I want to be with you so bad. I can't take this. I need to be with you, baby." She texts, "For sure. Like I said, the drugs have to be in the car or house. I want you in me. I'm so horny for you. My life is blob without you. It has been for a long time." She texts, same day, "Baby, we need to pull this off by this weekend. I hate my life without you." Same day, "I love you. Together we can do anything. We just need to be smart. I need to make sure he does serious time." Same day, "Think about what the plan is tomorrow. Research tonight and we'll talk in the AM. Sweet dreams, angel. You're my true and only love." Same day, "We are going to make great parents and we'll have a nanny full time so we can still have fun and party and travel together." Now we're on July 28th. "Were you able to come up with any ideas?" Mr. Stanley texts, "I looked online. Best would be a felony in the first or second degree, a lot of years. tell him he bought a brand new Porsche with drug money and where to find the steroids.
Judge, I'm going to object to these being considered in sentencing. These are uncharged crimes. She was never prosecuted for these. She was prosecuted for soliciting Y.D. Jean to have her husband killed and convicted for that crime. Why aren't there a lot of these?
It's evidence in the case.
What?
It's evidence in the case.
Yes, Your Honor. Why you allowed me for a limited purpose to establish context. Like I said, the state did not put forth substantial evidence of these. The imminent voyage rule, she wasn't prosecuted.
Okay. There's an opinion out of the 4th PCA that actually interpreting Norville, which says this evidence can be considered at sentencing. It was part of the evidence at trial. Any of the evidence presented at trial is part of the record and can be considered. So I'm going to overrule the objection.
Your Honor, Brian Claypool on a telephone call. At this time, I wanted to inform you that I'm going to be terminating my end of the phone call, so I don't want to interrupt Mr. Williams.
Okay, Mr. Williams, give me 1 second as I hang up this phone. Okay, Mr. Claypool, we're going to hang up the phone.
Okay, thank you very much for your time, Your Honor.
Judge, still on July 29th. The PO has to be able to get him on something. This is such bullshit. Tell him you were tired of him selling drugs and arguing with his wife in the neighborhood. Tell him I've seen him kick her and she always looks scared. She says, tell him where to find the steroids but to play it off. Tell him he paid cash for the house and cars with drug money. Same day she says, I'm dying here, baby. Let me know when you call. I'm freaking out. July 30th. He's going to shower. I'll text you when he gets out. She then says, hey, he's out. Remember, use the spook number. And then she says, we're going to switch title to me tomorrow. So he was spooking involved about the title. Now they get her to agree based on what the lawyer tells them. So July 30th, she texts, I'm starting to feel like we're getting close to our goal. What do you think? July 31st, the day she meets with Muhammad again, when all plans starts really rolling. We've accomplished one huge goal this week, and that's the house. I just need you to help me figure out the rest for the next week. Still July 31st, it's 2/16, so it's before she met with Muhammad. Did the transfer, but he said, because we're married, I can't sell it without his signature, even though it's in my name. Mr. Stanley text, sorry, fuck. Kind of what we talked about this AM, marital assets, may benefit somehow. He then texts again, divorce him while he's locked up, judge will sign with you. She says, I want my life with you right now. We'd be getting our party weekend started. He says, yes, we would. Need to clean up more mess, baby. Life is waiting. She then says, I'm ready to spend the rest of my life smiling with you and making you smile. We're soulmates. We need you forever. August 1st. So this is after she's already met with Mr. Kanade at the local gas station. So it's 6 o'clock in the evening on August 1st. This is when the scam text starts. Hey, thanks for the service. My confidence is so much better, and I think I may start seeing somebody very serious. I talk to girls so much better now. And then she texts, no problem. I'm glad the role playing is helping. Good luck and stay in touch. Mr. Stanley texts, thank you. I feel more comfortable expressing myself. These are all clips that I'm going to play for you that are her words about her intent, what she wanted done. To Mr. DeBellino.
She tried to lie to Officer Robert, the Detective Robert, and say that her husband was cheating her, and he was selling drugs.
Where does this come from? Is this the statement?
He testified to this in trial.
Yeah, I believe I heard this. This was the statement. It was used for impeachment purposes.
Sure, he can argue that and argue what he testified to and introducing new evidence that wasn't presented in trial. It's different than Mr. Williams saying Mr. Shihadi testified to.
Well, it wasn't. This was not played at trial because it was used for impeachment purposes.
This wasn't introduced. This actual video.
Just wait again. Just summarize what he said. I trust me. I know the evidence in this case.
August 1st, 2009, 4:15 p.m.
Your Honor, for appellate purposes, that I'm just renew my objection that this video was obtained in violation of the wiretap statute.
Mr. Rosenfeld, there is no need to make those objections at this time during sentencing. All of that is preserved.
Overruled? I think.
Overruled and admonished. I don't need to hear redundant objections I've heard 1,000 times. This is a sentencing. The other objection was well taken. It wasn't evidence, but I don't need new objections to evidence that I've already ruled on.
Judge, this is the part where she describes exactly why she's killing Mr. Dippolito.
Okay, I'll explain to you now. Your response also you want to only when you have a minute. Bye. August 1st, 2009, 4:15 p.m.
Like, it's about, like, his fucking friends and all that other shit. Like, the thing is, it's like, okay, with his wife, like, she didn't have anything. They were, like, renting. So, like, divorcing her, it didn't matter. Like, me going and fucking filing for divorce, like, I'll come after my fucking ass. period.
Okay, well, I'm trying to say is
And all his friends, like he ran into another guy today at Target that was like organized crime or whatever, also on probation. Like he keeps running into all these fucking people instead of saying, you know, like he knows a lot of people.
all I'm saying, this guy, you know,
Yes.
Other guy, the other one, is the one, because he wanted to help with some sort of...
although when you walk to the niggas that had nothing to do with it, and I told you to stay away from
I didn't give them anything.
I told
What are you talking about?
No, Larry, although when you walked into the clothes store, I told you.
I didn't give them any money.
Well, they told me that you told them that you were going to give them my Range Rover or something like that.
No, that was bullshit. That guy still calls me, but I told him I
Yo,
I'm out
they're
of town.
trouble, yo.
No, I
I'm telling you, they do it. They're going to get you in trouble.
They don't even know about this. They don't know about this. They don't know about the other guy, the other one, is the one, because he wanted to...
Okay, after he killed whatever, your mom and all of them, not gonna, like, his mom is not gonna get suspicious of you or anything like
Why
that.
me? Like, you know what fucking
Didn't you
killing
say
somebody
that?
is? Yeah, but killing somebody, come on. I mean, that's fucking, you know, nobody's gonna be able to point a finger at me. But I need him to say, like, remember you asked me who's his enemy, who's this, who's that?
Yeah, I was trying to tell them.
Alright, there's this guy.
Straight after this, seriously, don't, trust me, he's known for that.
That we ran into, this weird guy that lives in our house.
Check.
And so that's...
You know, if he has 100,000, like, not whatever, just give me 20, but cash, but, you know.
Right, no, of course, I'm not gonna write you a check. I know that. But yeah, everyone's gonna think it's related to that fucking bullshit, because I'm gonna tell them, I'm gonna say, you know, like, bullshit. I'm just gonna tell them, like, these guys went in, like, he's been fucking into guys. I'm gonna tell them about the guy at Target that we ran into, this weird guy that lives in our fucking neighborhood too, that's fucking probation for something else. I'm gonna throw all their fucking names in and I don't care. I'm just...
Yeah, shit happens.
I know, but...
Give him the 8, you know what I'm saying, and then you give him the...
That doesn't look fucking weird.
No, because I'll grab it for him. I'll grab it for him. Yeah, don't worry, it's straight. He just needs the price of the gun, that's what he does everything except for
You're
that.
sure everything else is okay?
Yeah.
You're sure?
Yo, what more sure can you want? You're planning a murder. Come on, stop,
I don't
yo.
feel like a nigger either. I'm fucking giving him, you know what I mean?
No.
Alright.
Alright.
Okay. Will you smile?
No, it's not easy to smile about, yo. It's not easy to smile about. It's fuck that shit. I've been through divorces and problems, and I can't believe I'm even doing
Who
this.
the hell told you never to fucking get married?
Yeah, shit happens.
I know, in fact, I ended up in the same boat as you. You're right, we are a lot alike.
Alright.
Okay. So let's get to it.
Let's stay not in contact next day or two. Let's not stay in contact next day or two. Like, don't call me, like, just...
No, but you're saying for sure by fucking Wednesday, right?
It has to be by then.
Okay.
So...
Alright, good.
Alright?
Okay.
That should be me. Alright.
Later, bye.
To get this
this car, I gotta get rid of this car, I gotta get this phone, I gotta get rid of this phone.
Right.
You know what I mean? There's a lot more I have to do.
I know. Like I told you, like I can't keep coming out of, like I come out of pocket a lot for like a lot of other things.
That's fine.
You know what I mean? Like I can't get into it, like
No,
or whatever.
that's all right. Go ahead. Because I don't want.
No, I'm not gonna. You know, I'm a lot tougher than what I look. I know you're like, oh, what a cute little girl, whatever. You know, but I'm not.
You are. You're
No.
beautiful.
Thank you, but I'm not. I just need to make sure everything's gonna take care of.
All right. Okay. So.
I don't know if that's public for you or if that's
what's he doing?
On Wednesday, he's leaving.
He's leaving on Wednesday?
Leaving Wednesday.
What time is he leaving?
Between 8:15 and 8:30 in the morning.
Okay.
That's why I wanted to know, like, do you want to come to my house Wednesday, or do you just want to, you know what I mean? I don't know what kind of scenes you do, whatever. He's going to be going to the bank on Wednesday. I don't know if, you know, yeah, I don't know if that's public for you, or if that's
what's he doing?
He has to pull out money for his business partner.
Oh, he's not gonna, okay, so he doesn't have any money at the house now?
He's like hard cash. He's going and pulling out the money because he has to make it look like it's coming from an account from his business partner.
Okay.
His business account.
How much money?
He said he was pulling out, I think around
Am I even better?
That's what I was telling you. He's going into the bank on Wednesday and he's pulling out money. Like, I know what bank he's going to.
What bank is he going to?
In Boca. Are you familiar with Boca?
Okay, fine.
I know exactly what bank he's going, and I know what time he's going to be there. If he'll be there early, if he'll be there when the bank opens.
All right, what's the name of the bank he's going to?
So, the bank that he's going to, he's going to Bank of America.
In Boca? You know where exactly that is?
Yeah, I know exactly where, what time, everything.
Okay.
So I don't know if, you know, the problem with this, though, is that from where the bank is to where the partner's office is, it's literally, like, next door to each other.
Okay.
Like, he's going to have to get back in the car to go there. I know where the office is at and everything like that. Like, I can show you where everything's at.
His office, his apartment?
Yeah.
All right.
But now I don't know if that's, like, too public for you, or...
Well, I mean, I could do it like that, but it is public. I'll get the money. But the thing about it is that it's hard to get away. If it's in Boca, how close is it from, like, I-95 or something?
You're closer to the turnpike.
The bank is? Bank of America, what road is it on?
441.
441, close to that, turnpike's good too. Because, I need somewhere to get out fast.
Right.
Okay. Turnpike, what road is it on?
It's on Glazes 441.
Where is it, 441? Bank of America?
Bank of America, they're in a shopping center.
Where's his partner's office at?
This is 441. This is Glaze. 441 is here, the bank is here, and then the next building over on 441 is where the partner's office is.
Okay, so the partner's office is actually on 441, so not great.
Exactly.
What's the name, like, the business?
It's in a building, like I can get you the building number and everything like that. I know where everything's at, but like the exact...
First floor, second floor, one like that. Okay, all right, he won't make it to the building. And he's leaving the house by 8:30, he's going to go get $10,000.
Yeah.
All right.
At that bank there, he's leaving our house and then going to Boca and getting it. That's why I thought that like...
What kind of car does he drive?
He'll probably be in that Tahoe right there.
What, it's his now?
Yeah.
All right, okay.
He'll probably be in that Tahoe, and he has a Porsche, but I'm pretty sure he's going to be in that Tahoe.
Okay.
And he just had surgery, so, I'm pretty sure he'll be in the Tahoe.
So I take his money. From the kid. All right.
So I was thinking I just thought that would benefit you because obviously, like, you know what I mean?
No, either or. The thing is, it's more risky doing it in public like that, but I don't mind. I just got,
That he'll have it for sure because the friend texted him, the partner texted him, when are you coming?
Okay.
And then from there, I know where he's going right after that. But he won't have the money anymore. He's going from the bank to there, and then that's it. You're not going to catch him anymore with money.
Okay. Well, here's what I'm going to do. If I don't do it now, because, the thing is, I don't want to get greedy, but, the fact is, when you have $10,000 on it, I'm interested.
Exactly.
It's only going to make it look like, he has more reason to be wild because of that amount of money.
Right.
Right. And they're probably going to suspect the partner, because the only partner knows he's going to get it.
Exactly.
All right. So what I'm going to do is that, I'm going to try to change my plans a little bit and then try to, do it with the whole bank thing. You know, if I can't come through with it by Wednesday, then it's going to have to be at the house. You know what I mean? But I'm more interested in that additional $10,000 I can get from them. You know what I mean? Because, you know, that's not going to come out of your pocket.
So what do you need then? Do you want to go ahead and drive by that area and like scout it out, or what are you trying to do?
Right now?
Yeah.
Watch where she's looking and listen to what she says. Because she testified about emotional dismissal and so she's not threatened her with the gun and shield.
I object to that coming in judge testimony for motion to dismiss hearing.
Over. He's just asking me to pay attention. Over.
He's just smoking every time. I'm not letting him smoke in the truck.
No, I think I'll find out. As long as I know where the bank is, as long as I know what car's going to drive, I know I'm going to have people following from the house to the bank. All right? And then he's going to be on.
Because you know he's going to have it. That's what I'm saying to you. It's like,
All right.
you know, you got him at the house, it's like, you know, it's like, but,
Right,
I mean,
right.
I have nice shit at my house, but still, like, if you go and you know what I
Doesn't keep
mean?
any, like, you know, large amount of money at the house?
No.
Okay. All right. Okay.
So you're better. I mean, nobody knows. Everybody, when you come to my house, you think, you know what I mean? There's a lot of money there. There's a lot of stuff there, whatever.
Yeah.
But in reality, you know,
All right.
the only thing would be, you know, if you like leave with the fucking Porsche or something. Is what I'm trying to say.
Yeah.
That's, you know.
Yeah, I hear you. All right. Not to have an option to change your mind, even if you change your mind. I'm talking to him.
There's no changing. No, there's no like. I'm determined already. I'm positive, like 5,000% sure. Like I was stressing when you told me you were gonna come up here, and then I'm like looking at the time. I'm like, what the fuck? He's not coming. He's not this. You know, it's like all this stuff or whatever. Like no, when I say I'm gonna do something, I'm gonna do it. Like as soon as he told me I was gonna need the money from you, I went. I grabbed it right away. Like we were good to go. Like with me, you're not gonna have a problem. You're not gonna have an issue. You know what I mean? Nothing of nothing. I just.
Do you have any money on your?
Are you not going to consider any evidence, like the defendant's phone calls from jail that evening, or the defendant when she went to the back of the police car or run into?
I just want to hear the evidence that was presented at trial. Obviously, I've heard a lot of things that were not presented at trial, but frankly, I know this case pretty well, so I appreciate just sticking to the evidence that was presented at trial.
Well, why can't I present statements of the defendant that the court has not heard yet?
Because those haven't been authenticated. I don't know what arguments there might be. The courts have allowed us, and after Norville, you've got to be very careful about what you permit in the sentencing hearing. The appellate courts have allowed us clearly to consider all of the matters which occurred at trial and circumstances relating to the trial. I'm just not comfortable going outside of that. Mr. Williams, trust me, I know this case. I've presided over it twice, and I've conducted numerous hearings in the case. I know the case.
Nothing. I mean, we
Well,
and
now you know that I advise you of your rights, right?
yes, you have.
Okay. The game's over with. Okay? There's no more games with you and I. Now we're going to get down to serious business. I want to know if you know this guy. Come here. Bring this guy in here. Get over here. Get over here. You know who this guy is?
No.
You never seen him before?
I've never seen him before. Ever.
Do you know her?
Put your head up and look at him.
Put your head up.
I've never seen him.
What were you doing coming out of her house? Get him out of here. You're going to jail today for solicitation of murder. You're under arrest. That's an undercover police officer. We filmed everything that you did, recorded everything that you did. You're going to jail for solicitation of first-degree murder of your husband.
I didn't do anything.
Did you hear what I just told you?
I heard that you said that. I didn't.
Everything, listen to me. Everything has been recorded. You were photographed in the convertible when you sat in his car in the front of CVS. What do you want to do? What do you want to do here?
I didn't do anything.
Listen to me.
I didn't do anything.
You're going to jail.
I didn't do anything. Please, I didn't do anything.
Tell me you didn't do anything.
I didn't do anything.
You're going to jail today. As soon as I'm done, they're going to come in here and handcuff you and take you to the Palm Beach County Jail, book you for solicitation of first-degree murder on your husband. Your husband is well and alive.
Thank God.
Oh, yeah, thank God.
Can I see him?
No, he doesn't want to see you.
I'm so wanted to see him.
He doesn't want to see you. You better quit your playing. Listen to me. I want you to quit your acting and get this over with.
I'm not.
Yes, you are. Okay. You know what? You need a real good attorney. You need a real good attorney because we're going to show them the film where you say you're 5,000% sure you want him dead. You think I made that up? You think I made that up? It's exactly what's going to happen. I'm going to talk with you. When I leave this room, no other officer will ever talk to you again. The next time we see you is when you're in trial. Now, you can make it right here, or you're going to trial, and you're going to do life in prison. You want to cooperate with us?
I believe this card was also redacted at trial.
I've seen through this part, so I mean, I'm going to overrule it. Are we going any further with this, Mr. Wayne? Okay, I mean, you can stop it. I mean, I've seen all of that. Stanley, I've seen everything. I don't. Correct, but I've seen that entire interview. I saw the interview that didn't come in. I mean, let's be realistic here. Lori?
Good afternoon, Judge. How are you?
Good.
The state will call Mike DiPolito to the stand.
Okay, Mr. DiPolito. You face the clerk, please. You may proceed.
Thank you. Good afternoon, sir. How are you?
Good.
You can introduce yourself to the court and spell your last name for the record, please.
Mike DiPolito, DiPPolito.
And are you the ex-husband of Dahlia DiPolito?
Yes.
How did the two of you meet? Actually, let me back up for a second. You're here today at her sentencing. Prior to the sentencing, were you given by your lawyer a copy of the sentencing recommendation or memorandum filed by the defense?
Yes.
And so do you want to address the court and address a few things that are contained within that?
Yeah, it said we met in New York.
All right, let me ask you questions from there, okay? How'd you meet the defendant?
I called an escort. She was an escort.
Okay. And it says that you met in New York. Where did you actually meet?
Palm Beach County.
It doesn't say that. Meeting in New York.
You can argue when you get back up that it doesn't say what's being said. I'm just going to hear from the victim at this time. So,
before you were married to her, how long after meeting her did you marry her?
I believe I met her in October. We were married in February, I believe. So October, November, so a couple months.
Before you were married, had you told her about your criminal history and having been to state prison?
Yes.
And did she know that you were on probation?
Yes.
Okay. When you guys got together, did you try to change her?
No.
All right, there's some discussion that you, or mentioned that you required or had her get breast implants. When were those scheduled?
She moved in with me from California, and probably within the first week or so, she had already had that scheduled.
Okay. Did you pay for those?
No.
So were those done at your direction or her own?
I didn't know she was doing it till she told me she was doing it.
I don't want to embarrass you, but I need to ask you some questions. What was your sex life like with the defendant?
I thought it was great.
Okay. Like,
Yeah.
would you equate it to most young couples who are in love with each other?
Listen, when I met her, it was very exciting. We got along really well. Our sex life was amazing, and that was part of the whole reason, you know, I was so into her and I thought she was into me.
Okay. There is mention that you forced her into sex. Did you ever force her to have sex with you?
Absolutely not.
Okay. When, as we know in the facts that you've testified to and we've heard in this trial, your money started going missing. When you would question her about that money, during that time period, you testified in the trial that you became, started to kind of become agitated of where the money was. Did you begin to lose interest in her sexually at that time?
I had so much going on, it was like left and right, and I couldn't keep up with the nonsense going on, and she tried to throw some sex at me, and I just sometimes wasn't interested.
Okay.
Because I couldn't, and I could tell what she was doing, and I just, no.
Okay. As part of your probation, were you consistently randomly tested for drugs?
Yes.
To your understanding, did that include steroids?
I don't know. I just would pee in a cup and they'd test me.
What was your marriage like? What did you think of your marriage before all this happened?
In the beginning, it was great. Like I said, I just said a minute ago, it was exciting. We just met. I didn't meet her in the best circumstance, but we both decided we were going to move on from that, so we did. And I called, so I own part of how I met her. Like, I don't say it, you know, but point being, we were moving on from that. I had a successful business. In the beginning, we were excited. Everything was going great. I got to meet her family. We're going there every other day. I read in that thing that I never went there. I read all this nonsense in that pretrial thing that it just didn't make sense. Like, her grandfather was a sick old man. I took the guy to a suite to see a baseball game. We rolled him in a wheelchair.
Okay. Let me ask you a question about that. There's mention in there that it basically implies that you wouldn't let her go anywhere or do anything, and she used to be with her family a lot. Did you all do things with her family?
Every other day, we would do something. We're going to do this. Let's go. My mom's cooking. Let's go do this. Let's whatever. And honestly, that's part of what attracted me to her. It wasn't anything. It was the fact that she had a family that she was so close with, and I'm involved with them that fast. It was part of what attracted me to the whole situation.
Did her mom live close to you guys?
Like 2 minutes. Okay. Yeah.
And you mentioned you took her family, including her grandfather who was ill, to a baseball game?
Her grandfather didn't speak English. Really, really nice old man, probably the nicest old man I've ever met. And I would sit with him, and he couldn't understand me, and I didn't speak Spanish, but we would laugh and get along, and he would watch baseball. So I don't know if I asked Dahlia or her sister, but I asked him, have you ever been to a baseball game? He says, no. So I'm like, oh, perfect. So we rented a suite. There was like 15 of us there. So we took the old man because the guy's sick. He was like, you know, I don't think he was dying then, but he wasn't doing real well. So I went out of my way because I wanted to. I liked this guy. He was, I'm telling you, a really nice old man. And we took him to the game. And like I read in that thing, it was like, I'm a scoundrel. Nobody liked me, and I didn't like the family. But I don't know. That just doesn't make any sense. Yeah.
Did you ever abuse her?
No.
Ever lay a hand on her?
Excuse me?
Did you ever hit her?
No.
After she was arrested, do you recall her calling you from the Palm Beach County Jail?
Yes.
Have you previously, on several occasions, reviewed that recording?
I mean, I've listened to it a few times.
Does it accurately and fairly represent the conversation that you had with her from the county jail?
Yeah.
Okay. Your Honor, at this time, I would ask to publish that to the court.
I object, Judge. It's before the jury.
Judge, I understand that, but he can authenticate it.
There's no
true. Well, hold on, this is more of a victim statement, so I'm going to let this in. So it'll be state one over objection. Again, I think I've heard this also, but.
Hello? Hey, it's me. Yeah, what's up?
Nothing, Mike. Can you please come here?
Hey, listen, I don't want to fight with you. Honestly, I can't help you. Don't you understand what just happened?
What they're saying is not true.
How is that possible?
Like, I'm sitting here. It's not true. It's not possible. You wouldn't even give me 2 minutes to talk to you, but it's not possible. What they're saying is not true.
How in the hell did I hear it and see it?
Like, I heard what you heard. It's not true. I heard what you heard and I saw what you saw. Everything they showed you, they showed me.
And how is it not? How are you telling me that?
I am giving you my word that it's not true.
Daddy, I couldn't help it if I wanted to.
Like, please, I need an attorney. Can you please help me? That's not true.
Your brother was here and I spoke to him and he's going to go talk to your mom. I called them for you already, right? So everybody knows where you're at. I took care of it.
I know that. I need your help, okay? This is not true.
I understand it too. Like, how do you explain what I saw and heard?
Like, I am limited on my phone call. You know more than anybody. It's not true. Just give me time so I can talk to you.
What did it say? I saw it. I heard it.
I saw what you saw and I heard what you heard.
Okay, what the fuck? You said you wanted to have me killed. I heard that.
It's not true. That is not true.
Not true.
How can you believe that?
I heard your voice.
How can you believe it?
That isn't the point. I heard you say it.
It's not. I heard what you heard and it's not.
What did I hear then? I heard you say.
I heard the tape. Okay, I heard the tape and I saw pictures and I saw the whole 9 yards. I saw all of it.
So why would you meet a fucking black guy in a parking lot? Explain that.
I'm sitting here on the phone. I will tell you when I see you in person. Please.
I can't come there anyway. I'm not allowed there.
That's not true. Who said that? They tell me that on purpose. That's not true.
I don't know what you could tell me. Even if, let's pretend, I said, oh, it's all better. I can't, they're charging your ass. Don't you get it?
Like, I didn't do anything. Please.
I don't know what to say to you. I can't help you. It's out of my hands.
You're not even trying.
What am I supposed to do?
You're supposed to get me an attorney, please, so I can talk to you.
You know, one thing after another. You can't explain this one. You know? Come on, man.
You think.
What do you mean these days? You met a guy in a parking lot.
Okay, you needed me yesterday. I took you right before Waterville because of your face, because of this, because of that. Every time you need me, I am here for you. Every single time, and there's no denying that.
So why would you meet a guy in a parking lot and hand him $1,200 and say, yes, I want to
give anybody $1,200. Period. Where they got that from, I have no idea. I never gave anybody money. I never paid anybody money. I never anything. Nothing of nothing of nothing, and you have my word. Nothing.
I saw you with this guy in this truck or whatever the fuck it was. I saw it. I heard your voice clearly. Well, I don't understand.
Did not say those things. Period.
So how did they get your voice on that tape recorder?
I'm limited with my time, please. Okay, can you please help my mom? Please.
What can I do?
You can get me on, please.
Is she going to call me?
No, why would she call you? Call my mom.
I did call her already. I spoke to her, and she didn't believe anything I said, and I didn't say anything bad. I let her know.
You didn't want to help her. I already talked to my mom. You didn't offer to help her. You just said, okay, well, you know, whatever.
You gotta be kidding me, man. Look, guys, I heard you say that shit. Okay?
I'm telling you right now, okay?
You can't fix it. You don't listen to me. You need to get your lawyer. Your mom's gonna get you. I spoke to your brother. And you need to just fucking handle it. Because, Kelly, listen, if I go screaming to the judge, whatever, and say, oh, it's okay, they're charging your ass.
It doesn't matter, period.
You can hire 5 fucking lawyers. They're charging your ass. They have your voice, your face, everything on tape. You're in a lot of fucking trouble. I'm trying to help you. How? Because I'm trying to get your head fucking, get off the bullshit and understand what's going on here.
What bullshit would that be?
I'm saying, how are you going to sit there and tell me that? How are you going to tell me that you didn't say it, you didn't do it? When I saw you say it and I saw you do it.
Do you have any idea how I was when they told me what supposedly happened to you, how I got it, and how I was, and how everything?
Right, and you wanted me fucking 500 or 5,000% dead.
That's not true.
You're absolutely
That's
sure,
not
right?
true. I heard what you heard, and that's not true.
And what did you hear then?
I heard the 5,000% sure. I heard, what else did I hear? I heard the whole thing. Everything you heard, I heard. And not once.
What are you disputing about it?
I never wanted to get period. I never paid anybody. I never gave any money. I never anything. I didn't fucking do anything. Is what I'm trying to tell you.
Why were you exposed to a video camera and a fucking tape recorder? Why?
Can you meet me in person so I can talk to you?
No.
Why?
Explain that to me right now.
Why?
Why the fuck should I?
Because you know me. Okay, whenever you need me, I am there for you, period. You know that. Or am I not? You couldn't even get off the couch the other day, and I came, and I brought you dinner, and I this, and I that, and I always make sure you're always taken care of. You're always everything. I never, ever in my wildest dreams ever walked up for you, ever.
Well, you said it.
No, I did not say anything, period. I didn't say anything.
I heard you.
I didn't say anything. I heard what you heard. I didn't say anything.
What the fuck? I heard you say it. How did you not hear it? I mean, how did you not hear it? I heard you. I saw you. You know? I saw it. I heard it. I don't understand what you're arguing with me about. And what else is safety hypocrisy? What did they do? My money?
No, it's the papers. What are you talking about?
The keys they found in your purse. Was that my money tied you right now?
No, they're just regular papers.
No, they were safety deposit keys. I know what the fuck they look like.
Right, and it's not papers. That's it.
Well, listen. I don't know how you're going to actually have the nerve to sit here and lie to me now. I don't understand. Like, I fucking heard you say it, Dahlia. I saw your fucking mouth do it. Okay? I can't help you even if I wanted to. Do you get it?
Why don't you want to?
It's out of my fucking hand.
You're not even trying. It's different if you're trying. You're not even trying.
What can I possibly do for you? I don't get it. What can I do?
You're not even trying.
Trying what? I'm fucking sitting here like a dumbass.
Okay, they're getting ready to take me again.
Daddy, listen, I'm going to give you some advice, and you need to listen. You're going to be lying around in there for a little while, a couple days. You need to just try and fucking relax and fucking just go with it. And keep to yourself and don't say a lot.
I love you. Everybody treated me awful, and I couldn't do anything to you. You've done me. Everyone has been awful to me.
I can't help you. There's nothing I can do to help you. You know?
Hello?
Yeah. You know? Know what I'll do? You know what I'll do for you? Seriously?
What?
You sign my house back over to me. I'll help you, Mom, immensely. Give me my house back. That's it.
That's it, what?
I'll help you. So I don't have to go through the fucking legal fucking bullshit I have to go through already.
What does that mean?
It means sign my property back to me that you stole, basically.
That's what you're thinking, and I didn't steal anything.
All right, so listen. I'll have the papers sent over to you somehow. you'll sign them over to me, and then I will help your mother. Okay?
I'm not signing anything.
I know you wouldn't sign anything. I knew that wasn't going to happen, so I can't help you.
That's what you're thinking about. I'm sitting here watching. You're thinking about.
Yeah, you start having me killed.
That's not
You're a
true.
fucking liar. You're a fucking liar.
What did your mom say?
She's not saying shit. She's sitting there. What's my mom saying?
And what?
Check it out. My mom, your mom, fucking everybody else's mom, they're all out of it. You know where you're sitting right now? That's the fucking reality. I can't fix it. I just offered to help you, and again, you have the balls to say no to me. Okay? But I can't help you.
How do I believe you're going to help me if I do that?
Because you know why? Because I'm the only fucking person on the phone that's ever done what they said they were going to do. Me. Okay?
How do I believe that?
Don't say shit. I just said I'd help you. Okay? You just basically said fuck you to me, which is hilarious considering your situation and considering what the fuck just happened today. Have your mom call me. I'll talk to her about it. I told you what I do. I'll fix it. I'll help you. You gotta fucking do the right thing. All right?
The gun and fingerprinted now.
All right.
Okay, when did you get your house signed back over to you?
I had to wait till there was the first trial at the end. Her lawyer threw it in my face, acted like he was giving me something.
So 2 years, basically, almost 2 years after the fact. Okay. When you first took part in signing that over to her, did you do so based on believing the phone calls you'd received were from a true lawyer?
Yes.
Did you realize you were being frauded at that time?
At that time, no.
And when you filed for, or when the divorce was taking place, did she contest that divorce, to your understanding?
Yeah, I had to fight her for like 3 years. It cost me $50,000 in lawyer's fees just to finally have him give me my house, because she was fighting me for my house. Yeah.
That's all the questions I specifically have for you. If you want to address Judge Kelly and something specific you'd like to say to him.
Listen, I've been doing this for, I guess we've been here 8 years, and I'll be honest, if I could hit a button and make this disappear, I would, but I realize that's not life. My main thing is, you know, since this has happened, you know, they've done nothing but blame me, the police department, everybody in the world, except say, okay, I did it, whatever. You know, I'm a guy that's been to prison, I got in trouble, I know what it's about. And I said I did it, and I went away. I mean, maybe that's why it means a little more to me, but the point is, you know, and not only just my feelings, you know, on national television, I'm a wife beater. I wanted to be on TV, like it's just, it's so crazy. And then people will say, yeah, and you're really lucky you're alive. And I'm like, I guess, because I can't get to that, because I got to deal with this nonsense for 9 years of constant, you know, I didn't do anything, it wasn't me. Everybody talking about how good of a person she is. I mean, it's just ridiculous. And, you know, honestly, I'm not here to badmouth this girl, but I'm just talking factual. How I feel about it, I'll be honest, I can't even answer it. I'm so just like, I can't even figure it out. When I read that thing, that, what's it called, the pre-trial, whatever today, they're just, everything in it's a lie. I can't even believe they turned it into you. Like, I couldn't even believe it. Like, I read it today, an hour before I came here, and I was like, kind of at a loss for words. I was like, wow, I can't even believe they turned this into the judge. You know, I get the sense everybody gets what I'm saying. This is just like, I'm sitting here today, and this is like, this isn't even real. Like, we're still sitting here acting like this girl didn't do this. Like, they're acting like that. It's amazing. It just blows me away. Like, I can't even believe it. But, you know, it affected my life. My mom's half a nut job over this. Probably cost me a few $100,000. I've lost business over this. I almost was thrown in jail from her trying to violate my probation, which somehow, like magic, I made my way out, you know. The girl tried killing me probably 3 or 4 times, handed me an iced tea with antifreeze in it, smiled at me, you know. So, I mean, but it's, whatever. I guess that's it. Like, I don't know how to really critique this. To say I'm not happy, I guess, would be, you know, if it would have went another way and she would have owned it, what can I say, right? You know, I guess, but.
Fair to sum it up by saying that your life will probably never be the same.
I don't even know. It's just, like I said, it just spins around like a fan. You just can't get away from it. But that's all. I don't want to over talk it. Sorry.
Yeah. Okay, Mr. Rosenfeld, any questions for Mr. DiPolito?
Mr. DiPolito, I do apologize. I did write New York in the sentencing memorandum. That was supposed to be Florida, so you are correct. I apologize for that. Misstatement of fact. It was a mistake. Just a few questions for you. You previously testified, and this is back on February 18th, 2011, 6 years ago, that you didn't care if she got locked up, you didn't care if she went to Vegas. You remember saying that?
Yeah, if she paid me back the money she stole.
All right.
And we've asked about that, and they numerously laugh at me. Because they're not going to pay shit back.
Well, you do realize that.
So, you know.
All right, just a couple things. You also said that the money was, just to clarify, paid back in restitution and the house was paid. I don't care if they sent Dahlia on a trip to Vegas and let her go. That was your exact quote, to make sure I'm not misquoting you.
5 years ago, I guess.
Sure, I don't want to misquote you here. And with her, if she fixed my mess, they could let her go. I'm fine with that. You're aware of that?
I don't recall.
All right, and if I showed you a copy of your deposition, would that refresh your recollection? Sure. May I approach, Your Honor?
Yes.
Sure. Fixing your mess, say would eventually being paid back. My house is mine, always mine. Listen, but if you would have paid interest, yeah, I must have said it. Yeah. Okay.
All right, you speak about the money and not getting that, so let's go through a few things. Were you aware from the state attorney's office and Ms. Parker prior to the first trial that Mr. Salnick tried to resolve this case over and over again, and the state's position was no offer? Well, he's saying that she's been doing nothing to fix this, and he's dragged her through the mud for 8 years now.
Well, the objection is relevance. You think it's relevant? It's interesting. Every time a state attorney brings up an offer, defense always argues you shouldn't consider it, and when the defense argues it, it's okay. But what's the relevance of it?
The relevance is he's saying that she dragged him through the mud for 8 years, which is a complete misconception.
I'm going to overrule the objection. Go ahead.
So are you aware that she tried over and over again to resolve this case through Mr. Salnick, and Ms. Parker repeatedly came back and said, our offer is no offer?
It was never about paying me back, so.
You just read a deposition where you said it was about...
I said, not the prosecutor.
Correct, but
I can't solve their problem.
I understand that, but you do understand...
They never offered me money, hence her. So get it clear.
No, you understand that Mr. Salnick went to Liz Parker, addressed what could be done, the house, the money, and they said no offer.
They offered nothing, so hence nothing happened. And I'm standing here 9 years later.
Okay, but it's a yes or no question, Mr. DiPolito. Are you aware...
What's the question? Because you're not making any sense.
Judge, can I ask him a question, or is he going to go in argumentative back and forth?
Everyone just take a step back. Mr. DiPolito, just listen to his question, address the question as best you can.
Well, let me... One second, Judge. You realize that she said, Ms. Parker, to Mr. Salnick, that even if she paid you back, in addition to paying Mr. DiPolito back the money that she stole from him, relinquishing her rights to the house and granting him a divorce, she'd bring the information to the state, but there was still no offer in this case. You understand that?
You listen, like what I want and what they're going to do and what they offered, none of it happened. So I don't understand the... No, I'm just saying, like, nothing developed because nothing was done.
Okay.
So I don't know how that didn't or did happen. But I know that we're here 9 years later. So...
So you're aware she got no offer, and are you also aware that After the second trial, I went to Miss Parker, now your attorney, and asked what it would take to resolve the case. She said paying you back.
Okay.
You're aware of that?
Yeah.
And are you aware that I went to the state attorney's office?
Again, I'm not objecting to relevance. It's improper to sit here and argue what plea offers took place or didn't take place. This victim is on the stand to give his statement to the court. It's completely improper to sit here and argue and ask.
Mr. Rosenfeld, I'm going to sustain the.
They're saying that.
You can make that argument. I'm going to sustain the objection of relevancy as to this witness's testimony. He's the victim in the case. He's here to state his position, how it's affected him. You can argue all you like, although, as I said, it's a paradox, because usually when a state does it, defense is objecting about you shouldn't get into negotiations one way or the other. You can argue that all you want. He wasn't personally involved in any of that.
No, I understand. The reason why I'm bringing it up, Your Honor, is he's testifying on direct, and I just don't, and no fault to Mr. DiPolito, I don't know what he does or does not know, that he's sitting here 8 years later and he hasn't been paid back, and we have tried.
You had a check waiting for me? Is that what you're telling me? You have a check for me?
Look, we're moving on from this topic. I'm sustaining the objection. This isn't helping me, so sustained.
All right. And one other thing, this doesn't have to do with plea negotiations, Judge, but were you aware that initially, prior to the first trial, from 2009 to 2011, I assume you're aware there was divorce proceedings going on?
I don't understand your timeline, honestly.
All right. 2009 to 2011, before trial.
Before she got charged, before she was charged with
She
anything?
was arrested before.
Okay, after she was arrested, okay. Yes.
That before trial, Mr. Salnick, with no promises, no strings attached, sent an email to your then attorney saying she wants to give you the house back, she's not getting anything for it, no strings attached, no promises, anything.
Yeah, that was before sentencing. Yeah, so it would look good.
And you're aware that there was a quit claim deed sent to you on June 10th, to your attorney, June 10th, 2011, by Mr. Salnick, signed by Ms. DiPolito, giving you the house back for nothing. No promises, anything.
I got the house back when we were doing this that day. Salnick threw it in my face. Yeah, cost me 50 grand and a divorce too. So you could have just gave it to me.
You realize he sent it. He actually sent this to your attorney.
But I had it thrown in my face here. So I don't know if he sent it to me or didn't. That's how I received it. So.
And would you like to see an email from Mr. Salnick to?
If you say you sent it, I believe it. I just telling you, I don't recall it. I recall the paper being thrown in my face, though.
All right, and you did get your house back?
Yes.
And Ms. DiPolito received nothing for it, no promises, threats, anything? Or no threats, no promises, excuse me.
Why would she?
Okay. No strings attached. And you also admitted at the third trial that you were hiding money through her so probation didn't know how much money you had.
I didn't say that. I said Dahlia was holding some of my money. I didn't say I was hiding money from probation. I didn't say that.
You said that probation did not know how much you...
They weren't aware of my income specifically, no. But I didn't say I was squirreling money through Dahlia to hide it from them.
All right, and you actually gave her cash in a cashier's check in her name to put in her name to get the house.
Yes.
So you didn't want probation to know how much income you had?
What does this have to do with anything?
I'm not trying to attack his character, Judge. I'm trying
What's
to...
the question even make any fucking sense?
Mr. DiPolito, hold on. First of all, we're going to quit talking over each other. I'm not retrying this case, guys. I've tried this case twice. I told you. If there's another trial, it won't be me sitting here. All right? So, the objection's sustained. Let's move on. It's a victim statement. Listen to the question, answer as best you can. If there's an objection interposed, everyone be quiet until I hear the objection. I rule. Now let's proceed, Mr. Rosenfeld.
One moment, Your Honor. right, but I mean, last thing I'll reiterate is that she did give you the house back, no strings attached?
I received my house, yes.
All right. She got nothing for it, didn't ask for anything for it, didn't ask to stay for a better deal?
Wasn't owed anything for it, so she got nothing for it.
Okay. Nothing further, Your Honor. Thank you, Mr. DiPolito.
Redirect.
Mr. DiPolito, you did your time, right, when you committed your crime?
Yes.
You want to see her do the same?
Yes.
I don't have any other questions.
All right, Mr. DiPolito, you may step down. Thank you.
Thank you, I apologize. I'm just, you know.
Okay. State have further witnesses? Okay. Why don't I go ahead and hear all the witnesses, and I can hear argument. I think that's probably the way to go. So let me then turn to the defense. Mr. Rosenfeld, I want to hear any evidence you want to present. So call your first witness.
One moment, Your Honor.
First of all, I apologize in advance, Judge. It's been a pretty long 18 months. I know we're all pretty burnt out at this point from consistent litigation, and it's been exhausting for all of us, and I didn't foresee myself being up here 18 months later pleading for my client's mercy. So if I'm a little out of it and exhausted, that's where I'm coming from. We don't have any witnesses. I have advised my client to not speak to the court. That's my advice, Judge.
Well, I assume, well, that's your advice. That's fine. If there's an appeal that's going to be taken, I can understand that. So.
And there is, Judge, as you're
So
aware.
in other words, but just for the record, I just want to be clear, your client has the right of allocution.
Yes.
She does not wish to exercise that right based on advice of counsel.
Yes, Your Honor.
Okay.
And unfortunately, we do have, Ms. DiPolito has significant family here in court and friends. You know, also actually over my advice, and I completely understand, Rhonda Muhammad, her mother, and Samira Muhammad will not be testifying at this point for health reasons and emotional reasons. Ms. Muhammad simply cannot get up there. Both Ms. DiPolito, my client, and Ms. Muhammad are incredibly concerned. This has been 8 years of mental anguish and torture for both of them and their families, and they don't think they can emotionally or physically handle speaking again. So I'd asked to rely on their previous testimony at the previous sentencing hearing. Obviously, I would like to have them up there, but I can't.
I mean, that's your call, Mr. Rosenfeld, and the call of your client.
If I have, well, just real quickly, Judge, if I have concerns about family members' health and they express that to me, there's not much I can do about it, but I would like to read letters they wrote in lieu of their testimony.
No, that's fine. I was just going to ask, if you don't want to take testimony, do you want to put on the record anything else?
Yes, they just have a letter they each asked me to read rather than them.
That's fine.
The first letter is from Rhonda Muhammad, Dahlia's mom. Honorable Judge Kelly, my name is Rhonda Muhammad, Dahlia's mother, and I am writing this letter on behalf of her sentencing. As you know, we have been going through this situation for the last 8 years. Not only has this been difficult, but the fact that I am a single mother who does not have the support of a husband or father in this situation really makes it all the more unbearable. It has been very painful, sad, and hard to understand why we have to go through situations like this. Even though we raise our kids setting up good examples and guiding them the proper way. Dahlia was always a family-oriented, caring, and honest person. Because she was the oldest, she had to help a lot with her young brother and sister after I got divorced. She would always worry about everything in the house. Every morning I wake up thinking this is a nightmare.
The media has taken over our privacy. Our lives have been completely destroyed by comments or assumptions that everyone thinks is the truth. The media does not really know who Dahlia Dippolito was before she was arrested. Everyone has judged her based on those videos or calls. She was obviously at the wrong place at the wrong time and got involved with the wrong people. I am not excusing for her actions or words said in the videos. Even myself am horrified because she never used this kind of language in our home. All I know is that people that she met, like Michael Dippolito, were not the right people for her. I never approved of him before being with her. There was something very peculiar about their relationship together. I had horrible feelings as a mother, knowing that he was her husband. She dated two nice and stable guys before Michael. Both relationships lasted several years, and there were never any unpleasant situations or feelings about hostility until Michael Dippolito came into her life. Your Honor, my daughter made a mistake, just as all of us in our lives have made before. We all at one point have been through something we regret, no matter who we are now. We all have the right to have another chance and opportunity in life. She has never been involved in any kind of trouble before. She has complied with all the regulations while being on house arrest. On the occasions when she was given permission to leave the house, she has shown that she is not a danger to anyone or a flight risk. On the other hand, she has shown that during this process, instead of making things up about herself, she has lent a helping hand to others who are encountering various difficult situations. This process has already been a life-changing experience for Dahlia. She needed this wake-up call from God in order to escape the treacherous life she was heading towards with the wrong people. She has grown as a person and matured into a sensitive and compassionate woman. She has developed a mothering nature towards her sweet little baby boy, whom she adores. There is nothing more painful to a mother than to know you will never be able to observe your child's milestones in life. Babies are born into this world with so pure and innocent, without able to verbalize comprehension of their surroundings. However, I know this baby is hurting by not having his mother around to take care of him. Thank you for the time to read this letter. I am begging you to please have consideration in this situation and also consider her faithful and compliant time on house arrest. I know that as a man of God, he will grant you the wisdom to make the right decision. And next, Your Honor, from Samira Muhammad, Dahlia's sister. The Honorable Judge Glenn Kelly, my name is Samira Muhammad. I am the sister of Dahlia Dippolito. This letter is being written in regards to her sentencing. I'm going to address in this letter positive aspects of Dahlia's character and also how the sentence is going to affect many people in her life. You and I both know how much the media is involved in this case. They have done anything and everything possible to make sure that everyone in this county, or pardon me, country, knows who Dahlia Dippolito is and the hard crime that she is being charged for. News reporters have been involved from the beginning, and it's interesting because instead of trying to find out who Dahlia really is and how she got in this situation to begin with, they are more preoccupied with slandering and tarnish the reputation of a 30-year-old woman with no prior record. Throughout these past 8 years on house arrest, I have spent every single day with her and have gotten to see how much she has grown and how much her character has matured. She has become a God-fearing woman who puts others before herself and always tries to ensure everyone around her is content. As many of our loved ones are writing these letters to you, we are not asking you to forget about the past. We know the law is the law, and as citizens we all must abide by it. However, we are asking you to consider the present and the future. She is now a mother to an innocent, beautiful baby boy and has exhibited character traits of humility, compassion, selflessness, faithfulness, and kindness. She has shown within these past 8 years that she is not a harm to herself or others around her. She has also complied with every single regulation set for her on house arrest and never once thought to do otherwise. I understand, Your Honor, that there is a lot of pressure on you to make a decision, which may or may not be an easy one for you, and I respect that decision. Although the media feels that she shouldn't receive any leniency, I am asking that you consider the long-term effects of this decision. More people in the situation are going to be broken and damaged if she is sentenced to prison. Her son will grow up without a mother. I will grow up without a sister by my side. My mother will lose her daughter, and etc. Although we were blessed enough to have her home for all of these years, our family has suffered every single day as a repercussion for past actions. Please, I humbly ask you to contemplate all of this before making your decision. If there is one big thing I have learned from all of this, it's this. At the end of the day, it's not about the way that people perceive us to be. It's all about the way our hearts are and about the way God sees us. I thank you so much for taking your time to read my letters and the letters written by those who have been here to support us. I know it must be tedious by now, but we are eternally grateful. God bless Samir Muhammad. And Judge, there are countless other letters from 2017 that I have provided Your Honor with before, and as attachments to my sentencing memorandum. I would just move these into evidence as Defense Exhibit 1, Judge.
Any objection to Defense Exhibit 1? All right, Defense Exhibit 1 and evidence without objection. I'm assuming it's the same package that
Yes,
you
Your Honor.
sent to me.
And in regard to the 2011 letters, there's also countless letters that are attached. There's just one I'd like to read, and the rest I'm sure Your Honor has reviewed. And this is from Mr. Santana, who was her first boyfriend. I discussed him in the sentencing memorandum. They dated for 4 years and remained friends afterward. He was a U.S. Marine. Unfortunately, he could not make it today, but I think this letter is very informative about Ms. DiPolito's character. And this is obviously made out to the Honorable Judge Colbath, not Your Honor. This is from 2011. Thank you for the opportunity you have provided me in expressing myself on the character of Dalia DiPolito. I am a former Marine who has served honorably in Iraq during Operation Iraqi Freedom Noble Eagle after the devastating collapse of the World Trade Center. During my well-respected career, I have faced many dangerous encounters and malicious people. I can assure you, Your Honor, Dalia is neither of these. The high-profile case has cost Dalia her freedom, which is the most valuable right one has. I write this letter to tell you about a wonderful person known as Dalia. The only person that I have been so close to that I can call her family my family. I advised Dalia that with time, the truth would be on her side. From the facts presented on her behalf, I just don't understand how this could have happened. Besides her family, I know Dalia the best. She is a wonderful person who has been supportive of me through hard times. We were in a relationship for 6 years. And even after our relationship was over, we remained friends. I have known Dalia for 11 years total. I am well qualified to state on her moral character. Honorable Judge Colbath, and I guess now the Honorable Judge Kelly, Dalia is nothing short of a wonderful human being. She took care of me during a combat-related injury I sustained while serving in the war. Dalia was supportive of me during harsh times and always believed in me. Dalia encouraged and supported the military men and women who fight for freedom and defend the Constitution of our country. She and I would go to numerous military functions, and she always reminded me of how proud she was of me and to my sacrifice for our nation. Even when I lost time, at times when I lost hope in myself, she would believe in me and remind me that she would always be there. Dalia has been a caring and loving person. She took good care of her grandmother, which she cherished greatly. Dalia helped her mother often, who was a single mother raising 2 children at the time. Dalia has shown great devotion to my family and welcomes everyone with open arms. While we lived together, Dalia stressed the importance of family and would gladly accept to take care of her sister and even my nephew multiple times. Dalia enjoyed the role as a caretaker of children, wanting them to stay over and entertain them. Dalia and I have even talked about adopting a child as we believed that there are those in life who shouldn't be raised without a family. Dalia loved children and has always been affectionate toward them. Dalia has always talked about helping the needy and doing charity work. She truly believes that it's always better to give than to receive. There are not many people that I can say this about, but Dalia gives unselfishly. She gives from the heart. Dalia goes out of her way for others and goes even further for the ones she loves. It's a shame that the media has misreported and represented Dahlia, thus tainting her name to the public, which she knows so little about her. I know Dahlia to be a conservative, self-respecting young woman who was adored by everyone. She is well-liked due to her personality and friendly persona. Honorable Judge Colbath, I beg of you to understand that Dahlia is not the person she has been represented by the media or the prosecution in this case. Honorable Judge Colbath, if you have... I keep getting tripped up on that. A horrific situation. Your Honor, I can assure you that Dahlia is one of the friendliest and kindest persons I have ever known. And Judge, there are also in this packet countless other letters that are attached to the sentencing memorandum. I'd enter this into evidence as Defense Exhibit 2.
Any objection to 2? Defense 2 and evidence without objection.
There's a few other things, Judge, before the State presents their argument. Your Honor, I believe Dr. Lenore Walker's report, I don't have a copy of it, I believe it's attached to the exhibit.
It is.
And I'd enter that into evidence as Defense Exhibit 3.
Any objection to 3?
And
Defense 3 and evidence without objection.
And finally, this is also attached, but the social history of Dahlia DiPolito prepared by Sheila Cronin as
That was the
Exhibit 4.
mitigation specialist?
Yes, Your Honor.
Any, is that 4?
Yes, Judge.
Any objection to 4?
And
4 and evidence without objection.
I apologize that she couldn't be here. She had a serious shoulder tear, apparently. We are not having the best luck right now with health on our side, Judge. And I have a few other exhibits I'm going to ask the court to take judicial notice of that I'm going to need for purposes of argument.
All right.
So I don't know if Your Honor would permit me to introduce them then, just so we're not going back and forth.
What do you want to introduce?
A few news articles, which Your Honor obviously can take judicial notice of under the rules, pertaining to some comp cases, some representative cases.
The ones that were covered in your...
Yes, Your Honor.
sentencing memo?
And Your Honor obviously can't take judicial notice and allow me to introduce them into evidence.
All right, well, let me find out whether there's any objection. Any objection to me taking judicial notice of the news articles which support the statements made in the sentencing memorandum with respect to other cases?
Yes, Judge, I do have an objection. I think it's irrelevant. It's in totally different cases. They have nothing to do with this case. You don't know it's a news article. It's the media's portrayal of what happened in those cases. We have no idea of the actual facts. We have no idea of what victims said, their positions. I don't think it's relevant.
That goes
Sentencing on this case, not those cases.
That goes to weight and admissibility. As Your Honor knows, you could take judicial notice of news articles, and Your Honor can take them for what they're worth. The state can argue what they just argued during.
Ms. Laurie, I don't necessarily disagree with you, but I'm going to overrule the objection. I will consider them for what they're worth. It'll go to weight and credibility, I suppose, and more weight than anything else.
In the last of my exhibits, I'm going to need them, like I said, for arguments. If you want me to give them to the clerk now, or
You can hang on to them. Are we ready to get to argument?
I'm going to be introducing them into evidence. I don't know procedural how you'd like me to do that.
I don't really care. You can put them in right now, hold on to them for a moment, and turn them in after you make your argument if you want. This is the articles you're talking about, or what else you're talking about?
The articles, evidence that was submitted by Mr. Salnick in the first sentencing hearing, that being the
quitclaim deed, the emails he introduced, where Ms. DiPolito is trying to turn over the property for no strings attached, the emails that were introduced in the first sentencing hearing to Ms. Parker in an attempt to resolve the case.
Are you marking these individually and moving them in? Is that what you want to do?
I will be, Judge, yes. So I don't know if procedurally, if you want me to do it now, or and this is your courtroom, your call.
Certainly is. Okay, what we'll do is, just as you make the argument, then I'll hear whatever objection there is. But I guess I'm candidly wondering at what point of the sentencing we are. Are we going to now proceed to argument, and you'll try to raise these issues in your argument? Is that what you
Yes,
want to do?
Your Honor. So I'll let the state argue and
all right, okay. Well, it's the sentencing. The state's going to get first and last,
Correct.
just like they do in trials. So I'll go ahead and start with the state, hear what they have to say. Ms. Laurie, are you going to start?
Just one moment, Your Honor. Let me make sure Ms. DiPolito has nothing else she wants me to raise.
All right. Hang on just 1 second, Ms. Laurie. We ready to proceed, Ms. Rosenfeld?
Yes. Judge, I'm just going to begin by addressing, Mr. Williams can make his final comments. I'm going to address the different issues that were in the defense's motion for downward departure. Starting on page 19, the need for restitution to Michael DiPolito outweighs the need for a prison sentence. Judge, just the few quick things I would address on this is that solicitation to commit first-degree murder is not a crime where restitution is part of it. It's not a theft. It's not, a crime where there's damages. Yes, she stole money, but I don't think that it's an appropriate sentence or remedy in this case. In addition to that, I think it's kind of hard to say that there's restitution in this situation. It, at the time, would have been marital assets, and you obviously can't steal somebody's marital assets. So, but beyond that, the state would argue that a prison sentence is way more important in this situation than restitution. Page 21, the downward departure based on the outrageous police conduct. I understand the Stedman case that he cited to. I do think this case is extremely different than Stedman. Stedman was a situation where, and I'm sure the court read it, where the police were doing undercover drug buys from somebody, and they basically just kept setting this guy up for more and more and more drug buys, just solely for the purpose of enhancing his sentencing exposure. And in that situation, the appellate court said, yes, you can consider that, because but for the police conduct of this continued pattern of behavior, he wouldn't have been facing the amount of time that he was facing. I think this is a completely different situation. The argument, obviously the court ruled on the entrapment issue, and it was argued and argued and argued to the jury about the Boynton Beach Police Department's conduct. I mean, that was basically, obviously, the theory of their case, of discredit all this evidence because of the way that they handled this. And despite their arguments and any evidence that they brought out, the jury found her guilty. I believe that the jury discounted that. I don't think that anything that the department did, even was it done in the best way? No. Does it negate her guilt? Absolutely not. We're not here to sentence the Boynton Beach Police Department. We're not here to say, well, I'm going to not sentence her as harshly because you should have done things differently. Your job today is to sentence her, not them. I don't think that that should be a reason for departure in this case. The second one, page 23, that she's not a future threat to society. They're arguing that this is an isolated incident, and I don't know if they're, I mean, they haven't spelled it out that it's a departure under it being isolated, unsophisticated.
Yeah, they listed it as a non-statutory,
right.
So I'm not sure they're relying on a statutory downward departure.
I don't think, I'm getting that it's not. As far as it being isolated, does she have other criminal history? No. But I think this is far from an isolated incident. This court heard numerous amounts of inextricably intertwined evidence of things that she repeatedly did. She took steps to plant drugs on him numerous times, have his probation violated, send him back to prison, taking his money from him. This isn't just you went out and you did one crime. She, over months and months and months, plotted and planned and attempted every single way she could to get him out of her life and eliminate him. And when all of her other attempts failed, she tried to hire a hitman to have him killed. So I think it would be, very hard for the court to find that it's an isolated incident in that sense. And I think that the court should look at that. That isolated would be somebody made one lapse in judgment. This was not one lapse in judgment. This was a gigantic months and months and months lapse of judgment. The house, being that she gave the house back with no strings attached, I don't know how they can argue there's no strings attached. It wasn't her house. He bought it. He testified at trial. He bought it with his money. I believe it was bought before they were even married, so it wasn't a marital asset. So to sit here and say, well, you got it back with no strings attached or anything else, to me is disingenuous. And then to say that, well, he also took part, there's bullet points in here of him trying to keep it from the probation officer and him voluntarily signing that deed. Yes, he did. He did it, though, under the assumption of quote-unquote advice from a lawyer that we know from the text messages from the evidence was her ex-boyfriend or her still other lover that was posing as a lawyer, spoofing calls to her and him to get all of this done. So I think that this was done under false pretenses, and it basically was fraud to get it done. And when he did this, obviously he never thought that his wife was going, the woman he loved, was going to attempt to take his life. So I think the House argument is disingenuous.
Objective being referred to as fraud, Judge, that would be asking the court to consider a uncharged crime, and that does go past setting up a larger context of what happened. That's pushing it a little bit.
To the extent you're making an objection, I'm overruling the objection. It's just argument at this point of the sentencing hearing.
Yeah.
As far as the abuse that's talked about and Dr. Walker's report, Dr. Walker made these findings. She admitted in her deposition that this court has read, based on other hearings that it's presided over, that the information that she relied upon in formulating her opinion was based solely on the defendant's representations. So we have to take those at face value for what they are. And you've heard from Mike DiPolito, the victim in this case, the person that a jury found to be a victim of this crime, said he never abused her, never laid a hand on her. And I would point out to the court that, unfortunately the state can't rebut that evidence because we have no examination of her. As far as their recommended sentence and the arguments that the court should abide by, the sentencing guidelines. The sentencing guidelines is the lowest permissible sentence. It is not the sentence that a court must impose. The legislator creates a maximum sentence, understanding that crimes are all different. Every case has different facts. Every person has different circumstances. And so it gives the court a range. And the legislator clearly felt that this crime is so heinous and so deplorable that someone should be able to serve 30 years in state prison. 4 years is just the starting ground, that on the most bare bones case that exists of a solicitation, a person should be doing at least 4 years in state prison. Arguably, this case is far worse from the evidence you've seen of someone, of the defendant who just tried to strip Mike DiPolito of everything he had and then kill him. That doesn't deserve a 4-year sentence. And some, although I think it's irrelevant. Well, I have. I think they're irrelevant. You know, if the state gets up here and says, oh, well, we offered this and they didn't take it, you know, they're jumping up and down. But then they say, oh, well, this person got all this, so you should sentence to this. Every single case in every court in this country is different. No two cases are alike. No two cases have the same facts. No two cases have the same victim. No two cases have the same defendant. I can't speak for these other cases. I can speak for a few here in Palm Beach County. I can tell you Ms. Torrero's case, to my understanding of it, charges weren't even filed. Drastically different situation than what we have here. To my understanding, she was someone who had substance abuse problems, multiple different things, and the evidence was not able to prove the charges. Mr. Chambers that happened here, that's a manslaughter case. In that case, Mr. Chambers was a security guard who came home and unfortunately didn't properly secure his firearm, and his 3-year-old took it and killed himself. And yes, he got probation. Drastically different situation of someone whose child accidentally killed himself through his fault of leaving this gun out is drastically different than that woman who did every act she possibly could to kill her husband. And Aaron Steele, that's a case on here from Palm Beach County, was an accidental shooting where, according to the probable cause affidavit, the individuals were practicing self-defense, helping try to teach each other self-defense. If somebody put a gun to you, thought the gun was unloaded, and the person pulled the trigger and it went off. Again, a drastically different situation. And Shelton Miles is an aggravated assault. I'm not even going to try to compare the two different charges. Judge, that's our arguments against their motion for a downward departure. I just don't see that any of these fit as a valid basis for a downward departure. But even if the court started to try to find different statutory, non-statutory mitigators that applied, a departure is not warranted in this case in any way. She deserves to spend the maximum amount of time she possibly could in state prison. Thank you.
All right, thank you, Ms. Ford. Rosenfeld?
I thought Mr. Williams was going to speak. I thought you mentioned.
I think he's doing rebuttal.
Okay. First of all, Judge, I apologize in advance if I get a little emotional during this sentencing hearing. It's been a bumpy 18 months, and all parties, including the state, have invested, and Your Honor, an excessive amount of time into this, and I think, you know, we're all pretty worn out. And this one definitely hits close to home. Generally, in my experience in this courtroom and my experience with Your Honor, you see that I'm often very scripted, very meticulous in how I go about my presentations. And, you know, I haven't slept much. I've sat in front of my computer in tears at times. And for the first time in my career, for most of this sentencing memorandum, or pardon me, for most of my presentation today, argument, I've been unable to really get my words out and really get them on paper. So there's parts that I've wrote down to more or less read to the court, and there's parts that I hope will just come out through my heart and through, you know, how I feel about this case, Ms. DiPolito's treatment from the beginning, from, you know, whether it be Boynton Beach, the state attorney's office, the media, everybody. My experiences with Ms. DiPolito, my experiences with her tremendous family sitting back there, who I've, you know, really grown to, you know, think highly of, you know, who in time I view as family. They're tremendous, tremendous people. All right. So as stated in this motion, we are moving for a downward departure for several reasons, and we'll discuss those in due time.
and in the alternative for the CBC recommended score of 48 months in the Department of Corrections with credit for time served. And I wanted to give a reasonable offer. I mean, I personally think probation in light of all she's served would be sufficient, but you know, I'm trying to meet somewhere, Judge. I'm trying to, you know, meet somewhere in the middle. As stated in my motion, Ms. DiPolito is a 34-year-old first-time offender who has never in her life been involved in the criminal justice system. She's a loving daughter. I mean, her mother will tell you that. She's a loving sister. Her sister will tell you that. And more importantly, and most importantly, she's a loving mother. I held her in this courtroom. Well, I heard her scream, and she didn't scream about sitting in jail, sitting in prison. All she said was, "My baby, my baby." And I think it's fair to say that her life has been nothing short of exemplary. I mean, the state has given you a small piece of her life. And I'm not going to dispute what Ms. Lori says. I'm not going to dispute what Mr. Williams says. I'm not going to dispute what Mr. Ehrenberg back there says or thinks. I mean, they have a case to try. They're doing their job. I respect that. But they're giving you a piece of Ms. DiPolito's life. They're giving you, and I'll go into this more later, they're giving you Ms. DiPolito at the worst moment in her life. And I implore you to look past that, Judge. I implore you to look past that. For the past 8 years, as we'll discuss later in more detail, she's been confined to a townhouse. Her house isn't big, with minimal social interaction for 8 years. I mean, she's watched her late 20s, her early 30s pass her by. You know, while some, you know, might call house arrest a privilege, I mean, I've heard that term thrown around. I mean, this wasn't your standard house arrest, and Your Honor knows that. I mean, not to knock on John Goodman, but this wasn't a John Goodman situation. She wasn't in a mansion, a palatial, you know, house, getting tennis lessons and dance lessons and working. She was confined to this small house. She could only go on her back porch. She couldn't go on her driveway. She couldn't go in her backyard. She couldn't work. I mean, she could only go see myself on limited occasions, and you know, that was due to the workload. Church twice a week, which we are very grateful for. This court has permitted that and permitted her to grow her spirituality. And medical appointments in court. I mean, it's the most restrictive house arrest I've seen, and if there's ever a situation where house arrest comports to incarceration, this would be it. This is as close as it gets. Now, despite all this, you know, despite these restrictions, despite everything she's gone through, and I'm not justifying what she's gone through. We're not here to do that, Judge. Wasn't crossing Mr. DiPolito to justify her actions. I was just trying to paint a bigger picture for you. But despite all this, Ms. DiPolito has utilized this time to secure her faith, bond with her family. Her and her mother have become incredibly close. They're inseparable. And grow her family. And people can say what they want about her having a child, but she brought a beautiful baby boy into this world, and I commend her for that. And I'll say this again, for those of you who call house arrest a privilege, I mean, I implore these people to sit inside for 8 years. Sit inside a small townhouse for 8 years, only leaving for those limited purposes I listed. Like, she just wasn't given those usual privileges on house arrest that truly makes it a privilege, that would have given her more of a sense of purpose and freedom. I recognize that when you're in house, I have clients who are on house arrest who go to work, they're not in their house all day, they're distracted. You look at Raja right now being tried in this courthouse. Been taking no position on that case. He goes to work every day. He drops his kids off at school. Now that's a level of freedom that Ms. DiPolito hasn't had. And this court must recognize that there is a huge distinction. Being able to go to work and talk to your friends, your colleagues, these were his friends and colleagues he worked with, taking his kids to school. That gives you purpose. That gives you a sense of freedom. And Dahlia never had that. Now, as we all know, from the inception, this case has captured the attention of the media. This began with Boynton Beach Police Department's decision to enlist the show cops and their decision through former Chief Imler and funneled through Stephanie Slater to release evidence on YouTube. Dahlia was thrust into the spotlight and became an international sensation. I mean, to this day, I have friends in Australia, friends in Iceland, who've said, "Oh, we saw your case on television." I mean, there's no way about it that she's become an international sensation. And all the while, this sensationalism overshadowed Ms. DiPolito's right to a fair trial, and not by Your Honor, but just the entirety of the situation, and more importantly, her right to a fair prosecution. I mean, police officers and prosecutors, have capitalized on this sensationalism in a way I've never seen. Whether it be writing a book on it and having a party, or, the career ambitions of Stephanie Slater and, Chief Imler and former Sergeant Sheridan. Now, I had a bunch of photos and posters to bring in from the party, from the book signing, from, Boynton Beach Police Department podcasts. Left them in my office, Judge. Because I'm not here to, we're here about Dahlia. We're not here about the state attorney's office. These are good people. I know we have our problems at times, but, I've also worked with Ms. Laurie. We've gotten along very well at times, Mr. Ehrenberg. Even Mr. Williams, we've had our day. I'm not here to slander them, but there's no way about it that everyone has capitalized on on the sensationalism of this case. And through all of this, and I'd say misguided and often selfish behavior, every single person has failed to consider how a criminally accused should be treated. She was not treated like every other client I've ever dealt with. And that's why I took this case. She was not, from day one, she never had a shot at a fair prosecution. And this goes back to the McAuliffe era. This is a long process here. It goes without saying that media and general self-interest have created unique obstacles and have driven her prosecution. Now, as repeated, and I stated this several times in my motion, regardless of what this court sentences her to, whether it be straight probation and no prison, which, like I said, I think that's what she deserves after what she's been through. She'll forever be branded and forever be humiliated in the public eye. And Ms. DiPolito has no shot in her normal life. And the state's right. If the true purpose of sentencing is punishment, she'll receive punishment that nobody else receives. She'll go nowhere where people won't say that, hey, it's Dahlia DiPolito. Now, before getting into the grounds for downward departure, I just want to briefly address some issues in the state's motion. And the state has consistently argued throughout the process that Mr. DiPolito could have been killed, but for Boynton Beach stepping in. Well, Judge, in our system, we don't punish people for what could have happened. That's why we have different charges. We don't sentence people charged with run-of-the-mill driving under the influence, with DUI manslaughter. We don't punish based on possibilities of speculation. That's not our system. That's not how our system was made. And those factors are calculated into the sentencing guidelines. That's why you have scores for certain sentences. Now, the sentence for, and this is the second point in regard to their motion, for 30 years, I think is just outrageous and disingenuous for several reasons. Now, in regard to the actual legal argument, asking the court to give her an even more severe sentence because her previous judge became chief administrative judge isn't her fault. I mean, that's not Ms. DiPolito's fault. I know what the case law says. I've read the state's case law. She shouldn't be punished more harshly for that. And even if he hadn't been appointed chief administrative judge, I think it's fair to say that...
It's actually chief judge.
Chief judge?
There are chief judges and there are administrative judges.
Chief judge, all right. Even if he hadn't been put in that position as chief judge, I mean, he likely would have had to recuse himself for, you know, comments he made during sentencing. So, you know, these are factors that play into Ms. DiPolito getting a new judge, and she shouldn't be punished for that. Now, punishing her for having 2 or more trials when the state wouldn't resolve the cases pre-trial, and that's not fair. And the state's request for more time is utterly disingenuous. We discussed this last Friday when Your Honor brought up the house arrest issue. And I wasn't aware at the time, I wasn't around back in 2011 in Ms. DiPolito's first trial, that the state actually agreed to give her credit for that house arrest. So if the state's saying, oh, Ms. DiPolito deserves all this more time now, 20 years was too lenient, then why are they agreeing with a 20-year sentence that, Judge, let's give her a little leniency here and let's give her that time for house arrest?
Oh, whether they agreed or didn't object, I don't know. I don't know how that...
Regardless, I mean, they didn't get up there and start, you know, saying, Judge, she's not entitled to this, she deserves the whole 20 years. So they come in here now, after allowing for a more lenient sentence, and saying it's not harsh enough, is inherently contradictory and is disingenuous. There and read text messages to you, which, you know, without question, cast Ms. DiPolito in a very harsh light. You heard him at trial. You heard him at the third trial. You heard him again today. You know, one thing, and Your Honor, you know, made a ruling, and I respect your ruling at the third trial, that Dr. Walker would have testified to, is that this is characteristic of a victim of domestic violence in terms of a lot of the behavior she was displaying. And I'm referring specifically to this sense of empowerment, of strength. This isn't abnormal. The fact that she wasn't telling Mike Stanley, oh, I'm being abused, does not mean she was not a victim of domestic violence. I mean, it's very, I mean, there's 4 types of women, 4 characteristics they show as victims of domestic violence. And the one Dahlia falls into isn't the passive category, it's the active category. And she would have testified that, obviously not to the facts of this case, but in general, there are 4 different types. And Dahlia's behavior does not suggest that she was not a victim of domestic violence. One second. Everything about the house is, you know, being misinterpreted, and we'll discuss that later on when we get into downward departures. Also, Hernandez v. State, I'm sure Your Honor is familiar with that from 2014. It's a second DCA case, 145 Southern 3rd 902, and I made an objection before about considering uncharged crimes. I don't have the case in front of me, and I frankly have not shepherdized it since 2014 or key cited it, but that does go to the judge considering uncharged offenses. So I said I quickly pulled up the case. I have not shepherdized it, so if it's been distinguished since then, I am not trying to mislead this court. I just found that well.
Cabrano v. State.
Huh?
Cabrano v. State, 4th DCA 2017.
Yeah, I'm not sure if it...
No, that stands for the proposition that uncharged crimes introduced at trial may be considered at sentencing. The 4th DCA was called upon to address that issue after the Supreme Court's decision in Norville, which seemed to restrict it did restrict what courts can consider at sentencing. But any of the evidence presented at trial, whether it's inextricably intertwined or Williams rule evidence, because the evidence was presented at trial, may be considered at sentencing.
Okay.
Ironically, they were both Castronakis' cases, but anyway.
Fair enough. And I think Ms. Laurie misinterpreted the purpose of the cases that the other solicitation cases that I did present, and I'm going to go into those in more detail, but I wasn't bringing those up for the purposes that she addressed. I was bringing those up for the arbitrariness of sentencing through the guidelines, and we'll get to that later on in my argument. All right, now. Just to speak briefly about Ms. DiPolito's background, and I know, Your Honor has read the sentencing mitigation report and read my my lengthy motion for downward departure and memorandum, but Dahlia hasn't had it easy. There's no two ways about it. She's had a tough life. We could always say, oh, well, another defendant went through this, but you have to look at each defendant individually and see what they've been through. And Dahlia has not had it easy. She has a loving mother. She had a father who did not care for her, who was physically and emotionally abusive toward her mother during her childhood. Dahlia, unfortunately, being the oldest, suffered the most from this. Her sister's considerably younger than her, 12 years younger. So this wasn't as much of a part of her life as it was for Dahlia's life. I write in the memo how Dahlia recalled hearing the screaming, the crying, as her father was abusing her mother as a child. And this is all coming from Rhonda Muhammad, not Dahlia. This is her depiction of what happened and what Dahlia went through growing up. Now, as I also mentioned, there were serious cultural differences in Dahlia's household. Her father was Egyptian, had very strict Middle Eastern upbringing, viewed women as, to an extent, subservient to men, did not treat her the same, didn't care for her, didn't go to her events growing up. She was just a woman, just a girl. And, this neglect necessarily affected Dahlia DiPolito. High school was no different for Dahlia. 3 years in a row, 8, 9, 10, she was in different schools, lonely, never made friends, was, the victim of her father's strict rules, was always an outcast. And things only got worse for Dahlia. I addressed this in detail, and I'm not going to go through all the facts of her childhood. But, her father ultimately took things to the next level, started having an affair on her mother, and she was in a situation for 2 years. And, in hindsight, her mother's relayed wishing she did things differently. But, as I don't have children, but as all parents, have told me, they all wish they did things differently, looking back. And Rhonda allowed her husband to have this affair for 2 years and to live with his girlfriend on the weekends and come home during the week. And Dahlia being the oldest, she obviously, her sister being very young and her brother being the boy and going out and getting closer with his friends to get away from this, suffered from this. She developed this very traumatic view of men as cheaters, users, abusers, and things only escalated. Her father became very physically abusive with Dahlia's mother, as Rhonda's reported to us. Fortunately for most of the abuse, Dahlia would only hear it and not see it. But Dahlia would see her mother with nosebleeds, with bruises on her body. Yet Rhonda still thought that it was best to keep him around for her children. And she regrets this in hindsight, but she made a decision as a parent. She thought it was important to have a father around. And you said, I don't have children, and these decisions must be terribly difficult, especially when, as a mother, you're the victim of domestic violence. Rhonda also reported that Dahlia, that he came in screaming one day trying to take all their money. He wanted to sell their investment property, he maxed all their credit cards, or draining their savings account. When she refused to allow them to sell the property, he started trashing the house. He shattered the wedding photo, all in front of Dahlia, and he tried to attack her. And Dahlia said, you know, if you go after my mom, I'm going to call the police. You know, I can't phrase it better than I did in my motion. This fell on deaf ears. He came back. She witnessed him attack her. He grabbed her by her hair. He grabbed scissors, and he cut a big chunk out of her hair. And I'm sorry, Rhonda, you have to listen to this, but and Dahlia called the police. I mean, you know, he was arrested, and of course, you know, as a abuser, he held this against Dahlia. He blamed Dahlia for this. Dahlia ruined her life. He didn't take responsibility for his actions. He picked her up from school one day, and this to me is just abhorrent. I'm in her car that they had bought her, and he made her listen to a 911 call he got a copy of. And admittedly, I couldn't get this evidence, and I tried, and I apologize. But he made her listen to a 911 call of her crying, calling the police. And then he said, you know what? You ruined my life. I'm taking your car away from you. I mean, I can't imagine how that experience played on her. Yet Rhonda still, in the effort to have a father around and a father figure in other children's life, allowed her father to come over for the occasional dinner. And this guy would come over, the bread would be served, and he'd take the bread, and he'd tell Dahlia, every time, this is what I had to eat in prison, and would taunt her and repeatedly blame her for helping her mother. Got to the point where Dahlia ran away. She got a ride to the airport from a friend in school. She managed to get on a standby flight and fly to New York. And fortunately for her mother found out about it. Her mother called the police in New York, and they were waiting for her there. But she couldn't be in the household anymore. It was, you know, it was too much. And, you know, I'd say I can't imagine, but I can relate to certain experiences Dahlia's gone through, and it's terrible. I mean, you know, we just taking a break from her history for a second. We look at people in these isolated incidents, and we don't recognize what they've been through, what they've gone through, and what's led them to find themselves in these situations. And it doesn't justify it. It doesn't justify someone's actions, but it mitigates it, Judge. And it's an understanding that you can now have about how Dahlia ended up where Dahlia ended up. Now, you know, we take a step past that. Adele, her father, against her father. He thinks that her father's good to them, and he thinks that they deserve, you know, a good father. And she, to this day, her mother will say she has kept her mouth shut about what she went through and held it in internally because she didn't want, you know, she wanted to give her siblings a chance at having a father. So she kept this in. She held this all in. Now, her father didn't pay much child support. Dahlia started working to help her mother. She would pick kids up from school, working at Pier 1. You know, taking responsibility and trying to help after being abandoned, after being psychologically abused, abandoned, watching her mother physically abused, watching her mother psychologically abused. Now, after high school, Dahlia enrolled in what was, I guess, well before my time, as a Floridian. It was Palm Beach Community College. She majored in business and marketing, and she met who I would consider a war hero, someone who sustained an injury overseas, a Marine, Julian Santana, and had a healthy relationship. Her mother, will tell me, I've talked to her about it, adored him. Dahlia adored him. He was, a tremendous person, served our country, took care of Dahlia, she took care of him. And they, through all of this, they maintained a friendship. That didn't go away. Her family, from what I've been told, has maintained a relationship with him. Unfortunately, he suffered post-traumatic stress disorder overseas, and that complicated their relationship, and that ended. Dahlia has remained incredibly close through all of this up until their death with her grandparents. And another very tragic experience Dahlia went through, she was in New York with her mother, visiting her aunt, and with her grandmother, and her grandmother collapsed in Chinatown coming out of the subway. Dahlia's grandparents, for her as a child, were her saving grace. She didn't have the support of her father. Her and her mother, were very closed off about what was going on. Dahlia did, to an extent, resent her mother for the living arrangement with her father, but her grandparents were her saving grace. So Dahlia, in New York, her grandmother gets off of the subway in Chinatown and collapses and has a heart attack. Dahlia tries to give her CPR in the presence of her mother, but it was too late. Her grandmother had passed away. Now, I think it was roughly 6 months after this, and this is a very misleading, part of this case that has been presented, and maybe the state doesn't know the history, I don't know, but Mike Stanley. She met Mike Stanley in Florida. She was at the dinner with her mother, they were at a lounge, and they met Mike Stanley. Her parents really liked Mike Stanley as well. He was, a very nice guy. They had a healthy relationship. He went to New York. And that was my typo in my sentencing motion, Judge, and sentencing memorandum. And Dahlia would travel to and from New York, and he would alternate weekends and come here. He was divorced, had a 5-year-old child. She had a great relationship with his child, and they moved to California together. So that's what happened. That's where Mike Stanley came from. He wasn't some lover she met while married to Mike DiPolito. She then, after a year, she had trouble finding work. She had a real estate license in Florida. She had trouble getting one in California, having never been apart from her mother and her sister. It does say great things about Mike when she met him. I'm not going to go into all the stuff in the motion about that, but she says wonderful things, and Dahlia's mother and sister say otherwise. They thought something was up with him. Now, I entered into evidence Dr. Walker's report regarding domestic violence, and she did do several tests, and she did determine that He suffered from battered woman syndrome and PTSD. Now, in regard to Mike DiPolito and domestic violence, I do not want to sit up here and slander Mike DiPolito. That's not my intention. But ultimately, Your Honor has to weigh to some extent what you hear from Mr. DiPolito and, make some credibility determinations when determining what was really happening here. So I don't think any of us will ever know what really was going on. I mean, this is a very complicated case. There's so many facets to this case that I don't even know what happened. But I'll tell you, if you didn't see that guy flip out up there and think that's a guy who has a temper problem, he hides it well. This is a man who made his money off of victimizing elderly people. He was a con artist. And to this day, he cons us. He came in here saying, oh, when he met Dahlia, he was a reformed man. He turned his life around. Yet despite that, he was giving her money to write a cashier's check in her name, so probation didn't know where his money was. And he can say what he wanted today. You heard his testimony during trial. He had money he was hiding from probation. He can get up here and lie to the jury, lie to the state, lie to Your Honor about being a reformed man, but that's not true. That's not who he was. And then for the past 8 years, since 2009, since all of this, he's been driving around in sports cars, yet a month before trial, he pays restitution off. And I'm not going to go much further into Mike DiPolito, because like I said, we're here for Dahlia, we're not here for Mike. But the reason why I'm saying this is that when Mike gets up there and says, I never hit her, there was no domestic violence towards Dahlia DiPolito, I want you to think about the person up there who's saying this stuff. This is not a credible person. This is a con artist who showed what temper he has. And no, probation nowhere in the country tests for testosterone. Now, I've went into detail in my report about the domestic violence she suffered. Her mother has talked about it. Ron has explained to me that, despite what he says, that he generally would not come over. There was an occasion, admittedly, at the beginning where he brought her grandfather to a Marlins game, but things got progressively worse. And Dahlia ended up with a guy who displayed the same patterns as her father. And that's not uncommon for children who watch domestic violence growing up. During this period, when this all happened, in 2009, leading up to her arrest, as Mr. DiPolito mentioned, Dahlia's grandfather, Enrique Gonzalez, was dying of terminal cancer. So how this impacted Dahlia during this period, I don't know, but I'm sure her grandparents being her saving grace growing up was terrible for her, and it necessarily affected her emotional health at that time. One moment, Judge. Now, we talked in detail about house arrest and just a little bit about how Dahlia's been doing on house arrest, post-arrest. I know her mother mentioned that after the arrest, she was very afraid she would kill herself, take too many pills. She had grave concerns. But house arrest has been a growing experience for Ms. DiPolito. As I said, she became very spiritual, very active member of her church. She does Bible study. She went from being this free spirit to being this devout Christian. And most importantly, Dahlia's son. 14 months ago, Dahlia had a son, and I don't have kids, but from what I've been told from everybody I know, all my friends with children, there's not a greater thing in the world than bringing a child into this world. You know, her brother, her sister, her mother all indicated that they have never seen a more rapid and greater change in Dahlia than when she had her child. It gave her purpose in life. It gave her a reason to exist. Through 8 years of sitting in her house, doing nothing, she finally had, you know, a reason to live. And people can say what they want about her having the child. You know, I'm hoping the state does not bring that up on rebuttal because I have a lot to say about it. But, you know, she made a decision, and that's her decision. She has a constitutional right to choose what she does with her body, and I respect that. That was up to her. I mean, men have kids all the time in prison throughout the country through conjugal violence, not something that's too unique. But the point of all this is Dahlia is a tremendous mother. I mean, she lives for that child. Like I said, I held her in this courtroom while, you know, she just cried, screamed. I don't know where Neil went, but he called me up and told me to come up here to check on her. And there was not a single thing uttered about Dahlia Dippolito that came out of her mouth. It was my baby, my baby, my baby. She called me just repeatedly from jail, day after day after day, asking, when can I see my baby? I mean, it was every single call was selfless. And the stakes for her son are very high, Judge. I mean, obviously any punishment toward her will punish her son. And, you know, I believe that is something this court should consider. Now, addressing the argument, and I'll start with the downward departure. First, and I did not include this in the motion, but I thought about it earlier on, kind of going through those articles, and that relates to Doreen DeFresney. And that was a solicitation case on the West Coast, I believe, Your Honor. And in that case, they found a downward departure based on this being an isolated incident, unsophisticated, for which she showed remorse. Now, as a matter of law, I guess what the state was saying and portraying to this court was, well, this wasn't unsophisticated. Look at the steps she took to have the solicitation carried out. And they went back and discussed probation violations and things like that. But those are unrelated to the actual steps she took to commit this solicitation. That's what matters. And solicitation as a crime necessarily involves planning. It has to. I mean, solicitation it's the intent in solicitation, you think a plot out, you plan it, and you execute it. It's not a one-step process. It's not like aggravated battery where you get in a fight and someone says, oh, that was an isolated incident. No, solicitation involves planning. So based on the state's argument, the way they presented it, if because there was all this planning behind it, it can't be solicitation, then solicitation could never be an isolated incident, and that departure ground could never be applied to isolated incident.
Well, I'm a little confused. Are you now arguing that as a...
I'm adding that as an additional...
Because that's a statutory...
Correct, Judge, and I'm adding that this is a new statutory ground I'm arguing now.
All right.
That, you know, I thought of while sitting here and looking at Ms. DeFresney's going through her article again.
There are 3 elements to that.
Correct, and the second, Your Honor, is unsophisticated. They could say what they want about the text messages. Like I said, those go to probation violations, other things, not this solicitation, the unsophistication of it. I think going to Mohammed Shihadeh, who you saw, Mr. Shihadeh, wasn't the most sophisticated plot. This was absolutely no different than Mr. Dufresne's plot when she went to someone to kill her husband, and she would give the $25,000 life insurance policy. There were steps taken there. And that also was clearly unsophisticated based on the granting of that downward departure. And finally, remorse. And remorse is obviously very difficult to establish when someone doesn't allocute to the court. However, I would argue that her actions, in particular, as Your Honor will see in a little while, her agreeing to turn over the house to Mike DiPolito with no strings attached prior to sentencing, getting nothing out of it, is an action that demonstrates remorse. She's saying, I don't want the house, take it. They sent over a deed. It wasn't thrown in his face, that's not true. It was mailed over to Guy Fronstein, and I have the emails to establish it from Michael Salnick. The divorce attorneys from 2009 to 2011, there were issues with them not wanting her to do it, but that was out of her hands. That wasn't her fault. That was the advice of counsel. And she had Mr. Salnick turn over the house. I don't want it. They didn't say, Ms. Parker, what can I get for doing this? They didn't call her, ask her. Turned over the house. So I think Your Honor can consider that in granting a downward departure as remorse. Now, the second statutory ground for downward departure would be the need for payment of restitution to Michael DiPolito. Now, Michael DiPolito just paid off a substantial sum to finally logic says now he doesn't have money and he needs money. So I think he does have a need for money. Now you're required to balance that against the need for a prison sentence. I think punishing Ms. DiPolito has been satisfied by 8 years of strict home confinement and social humiliation. I added somewhere in my motion that she's also paid $20,000 in house arrest fees. So she's basically been fined $20,000. These are all things this court should consider. So I don't believe there's this excessive need for punishment, and I believe that this need for payment of restitution to Michael DiPolito necessarily outweighs that. Now, while we're discussing this, I want to go through Michael DiPolito's deposition testimony that we harped on when he testified. When Mr. Salnick asked him, while we're on the subject, is that your desire to see her to go to prison? DiPolito, honestly, no. Mr. Salnick, but if the money was paid in restitution and the house was paid.
We couldn't put anything in that wasn't producing evidence of the trial. Why are they allowed to?
Because, Your Honor, he testified to it at the sentencing hearing. I can address what he testified to. They called a witness and that they brought it in.
It's testimony of the victim. That's why I allowed in that tape. So I'm going to overrule the objection. I'll consider it for what it's worth.
Thank you, Judge. I don't care if they sent Dahlia on a trip to Vegas and let her go. All that does nothing for me. I wouldn't gain nothing by it. I've never said anything about it. And it is already in evidence from Mr. Salnick's sentencing hearing, and it's attached to the motion, but I'd move into evidence, Judge, that portion that's attached to the motion as to Exhibit 5, I believe.
You're talking about the portion of the transcript?
Just the 4 pages that I attached to the motion.
All right. Any objection?
Yes, objection.
Same objection. I'm going to overrule the objection, and we'll go into evidence over objection.
May I approach, Your Honor?
Yes. What's the number? 5. I'll admit it is relevant to the argument of downward departure.
All right, now, after The second trial, after there being that 3-3 split and the two alternates spoke, myself and Mr. Claypool really wanted to resolve this case. Ms. DiPolito did. Nobody wanted a third trial, so I reached out to Ms. Parker. I said, Ms. Parker, what can we do to resolve this? I'm sure the state wants Mr. DiPolito's input. And she expressed that he wanted his money. So I had a phone conversation with Brian Fernandez, Craig Williams, and it was mostly between me and Mr. Fernandez. And I said to Mr. Fernandez that, we're going to look into finding a way to get this restitution. Everyone wants this to go away. Liz said, well, his views might have changed because he was dragged through a second trial, which we'll get into later was not her fault. She didn't get an offer much different than the sentence. And Mr. Fernandez indicated that, and I don't want to misquote him, but in short, they don't pay to play, which to me is nonsense, Judge, because we've all been here and we've all done countless pretrial intervention agreements and probation agreements where restitution or some sort of payment has been the sole special condition, if not one of many special conditions. So moving on from that ground, that second ground for downward departure, I would discuss the non-statutory grounds. And I'm going to start with the outrageous police misconduct, and that's the Stedman argument. And I'm not disputing the fact that Stedman refers to or deals with a sentence manipulation. Those are the factual issues in Stedman. But the same rationale applies, and just because their use of outrageous police misconduct in Stedman deals with the factual scenario of sentence manipulation, it doesn't mean that the same rationale can't be used for Your Honor to downward depart from Ms. DiPolito's recommended sentence. Now, Ms. Lori went into the fact that, the jury rejected the police misconduct claims. Well, first of all, we weren't permitted to give an outrageous police misconduct argument to the jury, so it's not really fair to say that they rejected that defense. But for argument's sake, let's say they did. Let's say they rejected that claim. The whole rationale behind Hines, Reif, Ty Van Lay, Mathis, all these cases is that Your Honor can consider evidence that is rejected by the jury. So it might not rise to the level of a defense, but Your Honor still finds that that evidence can be the basis for a downward departure. I mean, that's the point of those cases. Hines, conduct that is legally insufficient to excuse the defendant's action may nevertheless be legally sufficient to warrant a downward departure sentence. And going on to, I guess what's also in Hines, the trial court can mitigate a sentence based on conduct that is not sufficient to excuse the crime. So, the state's argument that because the jury rejected our argument is exactly what these cases are saying. Yes, they can reject it and Your Honor can mitigate because of it. Now, Stedman does address outrageous conduct by the police. And once again, admittedly, this is in a different context. I'm not saying Stedman is spot on, but I'm saying the same rationale applies for Your Honor to give her a downward departure. And the second district more or less says that conduct on the part of the police, which is not sufficient to excuse the defendant's actions as required to support an entrapment defense, may still warrant a downward departure. And I believe that proposition can be drawn from Stedman. And just to give you their rationale, to require a showing of outrageous conduct as a threshold to establishing a sentence manipulation would be to reject the principle entirely, because such a showing would amount to entrapment and would constitute a complete defense to the prosecution. However, the conduct in this case did rise to the level necessary for did not rise to the level necessary for entrapment. Nevertheless, conduct which is not sufficient to excuse the defendant's actions may still warrant a downward departure sentence. Now, I want to draw your attention to the motion to dismiss, and actually first the state's comments that there was some, I guess, I don't remember what Ms. Laurie said, but some problems with the investigation. Your Honor did point out some problems with Boynton Beach's conduct. And granted, Your Honor did not find that that rose to the level to bar prosecution. And a jury did not find that that rose to the level to justify Ms. DiPolito's, or pardon me, that it was not grounds for an acquittal. But Your Honor should consider this in granting a downward departure. And to quote Your Honor from the order denying the motion to dismiss, the court does acknowledge that while the alleged crime was not manufactured for cops, the presence of a television crew no doubt caused the Boynton Beach Police Department to act, in certain respects, in a manner which is not consistent with good police practices. And then later on, taking any action in a criminal investigation for the benefit of a TV show or for any third party cannot be condoned. The business of law enforcement is enforcement of the laws, not the production of theater. Now, to end, and this is your conclusion, summary dismissal of a case for objective entrapment is an extreme remedy, which must be employed with caution. There are portions of this investigation by the Boynton Beach Police Department which are open to legitimate criticism. The police's shortcomings can be exploited at trial to suggest and argue reasonable doubt. However, based on the totality of the circumstances, the actions of the police here are not so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. Now, while the court, like I said, found it didn't bar prosecution, and the jury found that it didn't justify an acquittal, I believe that Your Honor can still use this outrageous conduct and these shortcomings to mitigate a defense, or to mitigate her sentence. Now, by way of example, in Stedman, you have manipulation, you have the police doing a drug buy. It could stop there. They could arrest the person, it could be over. What do? They do another drug buy. Could stop there, they could arrest the defendant, they don't. What do? They do a third drug buy. Keeps going and going. Now, the type of outrageous police misconduct is distinguishable, but here, and this is not a justification for Dalia DiPolito's actions, but here, when Mohammed Shihadeh went into the Boynton Beach Police Department, and as he testified, he thought Ms. DiPolito had no other options other than to kill her husband or kill herself. At many points, they could have stopped it, they could have tracked her down, and they could have prevented this. Now, once again, this is not justifying what she did or justifying the solicitation. The jury made a finding, but this mitigates it. And like in Stedman, it could have stopped. And I think with that, Your Honor has the discretion to depart. The next, and this would be the third ground, second in my motion, but third raised today, is that a downward departure is justified because Dalia DiPolito poses no future threat to society. And that's the State v. Sachs, Florida Supreme Court. The court held that a downward departure could be based on a finding that defendant posed no future threat to society, and that his misconduct was isolated, which was not taken into account by the sentencing guidelines or prohibited by them, and was not an element of the offense or of the crime itself. And then State v. Bingham, also cited in the motion, Second District stated that the fact that the defendant posed little or no threat or danger to society is a valid reason for a downward departure. Now, State v. Sachs does not say that you have to have both a finding that she poses no threat to society and that it was isolated. It looks at countless factors in there, and it points to those two. But I think the focus there, I'm sure Your Honor's read that case before, is on that Ms. DiPolito poses no future threat to society. And as I've gone through, Judge, she has lived an impeccable life. She does not pose a danger to the society. I'd say her level of recidivism is incredibly low, especially now that she's a mother and would never want to face this again. I think having seen her being torn apart from her son in court, or knowing she was being torn apart, certainly makes her less of a threat to society. And her behavior on house arrest for 8 years, which I'll argue was flawless. Yes, Your Honor did technically find one violation. I wasn't on the case then, but she was advised by counsel, poorly advised by counsel, to do this interview and that it was okay. I would have argued differently if I'd argued that motion to Your Honor, Judge, that she was relying on good faith of counsel. And presumably that's why Your Honor didn't take her into custody, and we do appreciate that. But she was relying on attorneys in making that decision. So in 8 years, she's been impeccable on house arrest. And I see no evidence whatsoever that she poses a future threat to society. She's done nothing in 8 years but abide by this court's conditions. Her house arrest officers were very pleased with her, no complaints. Unfortunately, I couldn't track down her house arrest officer who retired for 6 years. But I know in the first sentencing hearing or bond hearing, it was proffered by Mr. Salnick, testimony of the house arrest officer indicating she's been fantastic on house arrest. Next, and the last ground for downward departure, and I think this is just, in Your Honor, looking at the totality of the circumstances, which I believe you can, and granting a downward departure based on previously stated case law, giving the house back. Now, myself, Ms. Lori, Mr. Williams, Mr. DiPolito will never agree on what happened with that house, and I'm not going to sit here and try to convince Your Honor what really happened, but just a few facts I pointed out in the motion that are very important. When the house was originally purchased, Mr. DiPolito had Ms. DiPolito purchase the cashier's check in her maiden name, and he gave her cash for that. And at the first trial, Alex Moreno testified that Michael DiPolito told him that certain assets had to be hidden to avoid the probation officer being aware of his assets. And he testified at the third trial that he was hiding assets from his probation officer. So, I mean, that's what happened. I mean, that's all there, Judge. Now, if you look at the totality of the text messages, Mr. Williams read ones that he found to be pertinent, and that's fine. Between Dahlia and Mike Stanley, there's a message, and this is important, indicating that Mike DiPolito's concerned with the fact that his former partner and business associate had learned that he had a home in his name. That was his fear, and if you read the text given to you by the state, you'll find that. And the text said he was freaking out the other day when he found that his friend knew we owed our house, it's written poorly, our house so much, he thought we should put the house in my name. And Todd Serber did not testify at the third trial. He testified at the first trial, and he testified that it was Michael DiPolito's idea to put the house in her name, and that he found nothing nefarious going on. Now, it's always been, and I'll give Your Honor evidence of this, Ms. DiPolito's desire to give this back. And from what I understand, and this is based on speaking with Mr. Salnick in his sentencing memorandum, Mike DiPolito's divorce lawyers had stayed the proceedings pending the outcome of the criminal case. So from 2009 to 2011, he says, oh, she didn't give me the house back. She couldn't. So she can't be held accountable for doing nothing with the house when his lawyers are saying, nope, we're not going to touch it. So she was obviously advised by her divorce attorneys to do nothing, and that's what she did. However, despite advice of her divorce attorneys, Mike Salnick sent an email, and I have that here. It was introduced at the first sentencing hearing. I'd like to enter it right now, Judge, and just read from it. My client was willing to give back the house prior to trial and still is. I have in my possession a deed. Quit claiming the house back to your client. He just needs to sign it and record it. She's getting nothing from it. She's been trying to give it back. And here's the quitclaim deed, Your Honor, signed by her on June 10th, 2011, and we moved this into evidence, Judge.
What numbers are they? I'll find out whether there's an objection.
6 and 7, Your Honor.
Any objection to 6 and 7?
My same objection, Judge.
Okay. I'll overrule the objection, allow 6 and 7 in on mitigation. Yes.
Now, while this isn't a separate ground for mitigation, the House, I think, in looking at the totality of the circumstances, and as I said earlier, considering it as part of remorse and the statutory ground, I think you can consider that. Moving on, if Your Honor denies all my grounds for downward departure, I think that the recommended sentence of 48 months is necessarily the appropriate sentence. Now, I'm going to rely on my motion. I mean, Your Honor's heard me litigate this issue over and over again, or a couple times, that the CPC score is a legislator's recommended sentence. The state has their position on it. I have mine. It hasn't reached the appellate court yet. I'm sure at some point it will. But I would say there are no aggravating circumstances that have not already been calculated into the recommended sentence. All the stuff points out are the basis for the solicitation. I mean, if those are aggravating circumstances, then every solicitation has aggravating circumstances, because all of them have planning. Solicitation is a crime that involves planning. You know, the state talks about all of this poisoning stuff, and I've spoke to Your Honor about it. I've read Your Honor different quotes from Mr. DiPolito about this poisoning. What differs from what he said today? It wasn't until the police brought it up to him that he ever thought about poisoning. He didn't spit it out and say, oh, it didn't taste good. That never happened. I mean, that's a blatant misstatement by Mr. DiPolito. And I would say there are no aggravating factors that are not factored into the score sheet. I mean, we have this piece of paper here, a score sheet, that I think is, you know, especially with Fernandez that came out in 2016, I'd say it's a fundamental right for a defendant to have, Your Honor, have a score sheet, and that they should be informed and guided by the score sheet. Obviously, they're not controlled by the score sheet. But I mean, I look at this more often than not with judges, but very often in plea negotiations, as a useless piece of paper. I mean, how it's treated. Like anytime, you know, we want to go down, people say, "Oh no, you're limited by this score sheet." But if it's supposed to be so instructive, then a sentence that so far departs from it, I mean, it doesn't make any sense. I mean, look at the title of it, recommended sentence. And most importantly, Your Honor, I think any sentence that exceeds the CPC recommendation would, as a matter of law, be arbitrary and disparate to another sentence and other sentences imposed under the CPC. And this is the point of bringing in those other cases. I think Ms. Lawyer might have misunderstood where I was going with that. And the cases I'll draw Your Honor's attention to. The first one, famous case, Volusia County, Doreen, I can't pronounce her name, DeFresney, convicted after trial of solicitation to commit murder for hiring a hitman to kill her husband because he was leaving her with little money. So, tried to hire someone for financial reasons. The trial court in that case granted a downward departure, finding that it was an isolated incident. She had shown remorse and sentenced her to 10 years of probation with no incarceration. Now, I believe the state pointed out that she had drug problems. So drug problems should warrant a 10-month probation to 30-year sentence disparity. That's not a logical argument. But same thing. She wanted her husband killed for financial reasons. Lee County, Kimberly Alters, charged with solicitation to commit first-degree murder. Well, she pled guilty to 2 counts of possession of a controlled substance, 1 count of possession of a firearm while committing a felony, and she was sentenced to 5 years probation. And she too avoided a prison sentence. The facts in that case is, as I know them, Judge, were that she approached a confidential informant to hire a hitman in 2010 to kill her husband in exchange for his motorcycle. For his motorcycle. So for the state to say, oh, this is the most gruesome and egregious thing to ever come into this courtroom. For a bike. Five years probation. Annabelcas Terrero, Palm Beach County. I believe that was 2011. Right around the time, interestingly, 2013, excuse me, of or right after Mr. Polito's second trial. You know, I have a police report from that, and unfortunately it's not very useful, so it's about a paragraph. But she was doing undercover work, from what I've read and learned, doing research on the case, for 2 officers, and she gave those 2 officers in uniform her credit cards to kill her husband. She gave them credit cards. She actually gave to kill her husband. There were allegations in that case, like Ms. DiPolito's case, of domestic violence. Her husband had been arrested. In that case was no filed, the domestic violence charge against her husband. And her case was no filed under, I believe that was McCullough's reign at that point. And may I approach with these articles, Judge? They're already entered into evidence.
Yes.
So what is the point of a score sheet when you have this much disparity in sentencing? I mean, it makes no sense. Somebody should not be getting 10 months probation and somebody getting 20, 30 years. It takes away from the spirit of having a recommended sentence. Now, just going through a few things, Judge. You know, I touched on this at the beginning, but I think it's important to address it in this context. I touched on the sensationalism of this case, the immediate attention it drew from the beginning, whether it be Stephanie Slater, Imler, Paul Sheridan. Everyone was capitalizing. Elizabeth Parker in the courtroom wrote a book on it. Like I said, I had a nice big poster of it to show you, but I'm not here to embarrass or bash on people. At a party celebrating the signing of a book. I mean, from the Cops TV show to this party on appeal, it just really overshadowed what was going on here. And there's no way this woman has not been treated differently than other similarly situated defendants. And that's why I'm bringing these other cases that did not draw the same media attention to Your Honor's attention. She was never treated like any of these women. Doreen, Kimberly, Annabelcas. I mean, there's no way anyone in this courtroom can sit there and say that that the overwhelming media attention in this case did not drive the direction of this prosecution. I mean, from the outset, there was no reasonable efforts to resolve this case. You know, I have the emails, and they were in evidence from the first sentencing hearing between Mike Salnick and Elizabeth Parker, where, you know, he keeps asking, can we resolve this? Can we resolve this? No offer, no offer. I have the second case, I never got a firm offer. The third case, and I mean, this was the most, I guess, struggling part for me. After the hung jury, we walk out thinking, all right, we can resolve this. Let's sit down and resolve this case. And we get outside, and there's, a press release through Mike Edmondson from Mr. Ehrenberg saying we're trying this a third time. I mean, she was never given an opportunity to engage in reasonable plea negotiations. And when I tried to sit down and I tried to resolve the case, I couldn't get an in-person meeting. I get a phone call with Mr. Fernandez and Mr. Williams. Mr. Williams didn't talk. Mr. Fernandez spoke, and I spoke, and Mr. Claypool added a few things here, here and there. And the offer was, I believe the term was high double-digit offer, no credit for house arrest. So this, I mean, what incentive did Dalia Dippolito have to resolving this case when her sentence was identical to, or pardon me, her plea offers are identical to what she got in the first trial? I mean, this was, as I put in my motion, an invitation for a second and third trial. I mean, Ms. Dippolito did not, I can assure you, did not want to go to trial once, twice, or 3 times. I mean, her family, it has been a miserable experience for them. It has been a miserable experience for her. They've been dragged through the media, embarrassed, just humiliated. But she hasn't been given an opportunity to resolve this case. And I bring this to your attention not to slander Mr. Williams, Ms. Laurie, Mr. Ehrenberg, any of these. I'm not trying to look poorly on any of you, and I hope you know that. I bring this to your attention because we have tried to resolve this case, and Ms. Dippolito has consistently been attacked everywhere. Everything I read, Dalia Dippolito is making this case being tried a second time, a third time. She's wasting the taxpayers' effing money is what I hear all the time. I mean, this woman did not want to go to trial and never had an opportunity. And I know, Your Honor, I practiced in front of you for years now. I know you wouldn't give a trial tax. But I think it's important for Your Honor to know what has been going on and why we've been here for so many years. And, this is not Dalia Dippolito. She has not been dragging this on. And I would move my emails that are attached into evidence, Judge, as... Mr. Clerk, what are we up to? 8 and 9, Judge?
Any objection to 8 and 9?
Yes, Judge. Same objection.
Same objection. I'll overrule the objection. 8 and 9, evidence without objection. Over objection, I'm sorry. Yes.
And I just want to read one quote from, I put in my memo from Mr. Salnick, and I think he brilliantly predicted what has happened since prior to the first trial. Following sentencing, it is likely this case will be publicized in the national media. Some of the participants in this case may even appear extolling their virtues of obtaining a conviction. That benefits no one in this case except those seeking attention. And he was right. Far too many people have capitalized on the sensationalism of this case, and no one has treated Ms. Dippolito like every other defendant. Now, just some final matters, Judge. And finally, this morning, I mentioned earlier I had trouble putting a pen to paper here and really expressing how I feel about what's going on and, what Ms. Dippolito's been through and what I've been through and her family. And I was able to put some things on paper, and it took me quite a few tears and quite a lot of time, but, I think it's important to go through this. And as young lawyers, we're told not to make these things personal and bring our personal lives into this. not to bring our personal lives into the equation. And Judge, I think when you've spent 18 months working with someone day in and day out, I'd almost be inhumane if I didn't speak on behalf of Dahlia DiPolito. I mean, I've spent every waking hour, weekend, and holiday fighting for Dahlia. And, you know, I can go on about the sacrifices I've made, but that's not important, and that's not why we're here. You know, I've made these sacrifices because I truly believe in what I do, and in fact, I love what I do. I get to sit with people like Dahlia DiPolito. I get to know them, and I get to help them. And Dahlia, like all people who come in this courtroom, and especially Dahlia, more so than most of my clients, most people I've met in my life who've done bad things, is not as bad as the worst thing she's done. And I implore you to think about that, Judge. You know, I've had the privilege of getting to know the person Dahlia DiPolito truly is. And you know what, that's, I guess, also not important. Why I bring up the sacrifices, Judge, and, you know, just to make this, you know, personal and tie this all together, I've had the extraordinary privilege in my life of marrying a, you know, tremendous woman who understands why I do what I do. And the sacrifices I've made in handling this case are meaningless. The sacrifices she's made, not seeing her husband for the first 6 months of our marriage so I could help someone, are truly remarkable and selfless. Now, I bring this up for the following reason. I had no idea how Dahlia would fare when this case went to the jury. You know, it's the jury, when I had no idea what was going to happen, I obviously hoped for the best. You know, but as a defense attorney, you learn to prepare for the worst. And I asked my wife to drive up from Fort Lauderdale from work. I told her I wanted her support, you know, but in truth, it wasn't for me. It was for my wife. Dahlia and my wife had met briefly in court on 1 or 2 occasions, for seconds maybe, with the cameras just swarming at our face outside. But I wanted her to meet Dahlia DiPolito. I wanted her to sit down and talk with Dahlia, and I thought she deserved to see who she's made these remarkable sacrifices for. I mean, I watched them in a conference room talking, laughing, and it was, I mean, it was tear-jerking. It was heartwarming. You know, these 2 people, Judge, just sitting there, you know, like any 2 people in this court. I mean, it was wonderful, and I knew when she walked out of the courtroom, she understood why I wasn't around for 6 months, why I was barely around for the year before our wedding. And she got to see Dahlia for the person she truly is. And that's the problem, Your Honor. Far too often in our system, we forget that we're dealing with people, with human beings. We look at score sheets, small pieces of a person's life, and case law. We put on these theatrical performances in court. And all the while, we lose sight of what really matters, and that's our humanity. And that goes for me too, Judge. I've said and done things that I'm not proud of, and for that, I'm sorry. You know, I've went back and forth with the state attorneys here, the state, and I humbly apologize. And I'm sure they've done things to me, and I hope they feel the same way. We've all lost our humanity, but Judge, we can't lose sight of that, especially in sentencing. I mean, let's put aside the cameras and the media that have sensationalized this case from its inception for a moment. Let's forget about the people who waste their time online judging you, judging me, judging Dahlia, judging Craig Williams, Laura Laurie, Dave Ehrenberg. I mean, let's break this down to what this case is really about. You have a 26-year-old girl who you've seen at the worst point in her life, a girl who made an absolutely terrible decision. I mean, the state can use any adjectives they want to describe this girl from 8 years ago, but Judge, I assure you, this girl from 8 years ago is not this Dahlia DiPolito sitting right here. I can promise you that. For 8 years, she's been punished terribly for this decision. She sat alone in a townhouse, sad, lonely, confused, and as described by one person, and I won't mention his name, a Boynton Beach Police Department officer, as I promised. He said, "She's been standing on a chair with a noose around her neck for the past 8 years, having no idea what her fate will be." That's going to weigh on someone, Judge. She's watched the better part of her 20s and 30s pass her by. And regardless of your sentence, she will forever be punished in the public eye. She'll be branded as the girl on the Cops TV show. I mean, how much more do we have to punish her? She's done nothing in 8 years to suggest she's a danger to society. And everybody knows that. I mean, you're in a unique, difficult situation. I mean, it's a hard job. You're up there, and you have to determine someone's fate. I mean, you're in a position where you can give her a chance to be a mom, a daughter, a sister. You can give her a chance to make something of her life. And, I mean, I implore you, I frankly beg you to give her a chance. I mean, I'm done with the theatrics, the cameras in the back, the media, all this. I mean, in the end, it's meaningless when we're dealing with a human being. That's what matters. I'm just begging you to look at her as a person. Look at her eyes. If you spent 5 minutes with her talking, Judge, you would see this woman is not that person. I'll swear on that. This woman is not that person. And I beg you, look at her as a person. Look at her as a daughter. Look at her as a mother. Thank you, Judge.
All right, thank you, Mr. Roosevelt. Mr. Williams.
We know one thing from all the testimony in this case, and that is to the right people, that is a master manipulator right there. She had every ability to plea up to the court if she wanted to plea. The signature going on there was for 30 years. That's what her plea offer was, the maximum under the law. You deserve to, Judge, you need to sentence her to protect the rest of society from her. If she wants something, first-degree murder is not enough for her. She'll do whatever it takes to get what she wants.
Aren't we at the point in the theatrics, Judge? I think we're past that at this point. Show some.
Overall, Mr. Rosenfeld, this is their opportunity to tell me why they believe 30 years is appropriate.
Is this the same person who was on in-house arrest, who doesn't let the court know she's pregnant, doesn't let in-house arrest know she's pregnant, they do court orders to try to deceive the court, so she's just going for a regular medical check, has a child, and then saves it as a...
Judge, I asked to be heard on this. She has HIPAA rights, she has no obligation, and if the state is arguing that she is irresponsible for having sex and telling the court when and when she cannot have sex, or whether or not she can have a child, first of all, she has a constitutional right, Judge, to have a child. It is her body. She has a constitutional right. She has HIPAA rights. Well, I object to any discussion about this.
Well,
or consideration. I mean, has he been to a prison?
Rosenfeld, my turn to speak. All right. We don't have a HIPAA violation.
I'm saying it would be if she doesn't have to disclose it.
I understand your point, Mr. Rosenfeld. We don't have a HIPAA violation here in a sense.
That's not what I'm saying. That wasn't.
Let me ask this, though, Mr. Williams. Where are you going with the argument with respect to the child? I just want to be right up front.
And the whole goal along was to use it as a weapon in her second trial. That's what was going on. Master manipulator.
Okay, if that's your point.
That's my point.
All right. That point has been articulated, and we can move on.
Am I allowed to go over evidence that was admitted in the first trial that we didn't admit in our trial that defeats what they're talking about the home?
If it counters an argument that's been made in mitigation, yes.
It does. Judge, I'd ask that I play the jail call from the defendant to her mother, August 5th, 2009.
I'd object this is not being defined as fact. If the state wanted to object to me introducing evidence, they could have, but...
They did.
know, darling. I know. Right now. I know. Okay, who do you want me to call? I called already and I called everybody else. What is it you want me to get back here? Everybody can handle that. I'm going to go here and get your lawyer. Okay? Don't worry. Don't worry. Where are you? Are you in that what? Okay, I know you did it. I know you did it. Okay, let's go here. Okay, all right, I understand. Well, let's go here and get it. Okay? Mike is telling me that is coming. Everybody is correct. Everybody is correct. Okay? I'm going to go here and then get in touch with you. All right? I'm going to say, where are you? You on the clock? Okay, well, but right now we're going to need to have a lawyer first, okay? All right.
Yeah, she wanted to voluntarily give the house back, sure. The domestic violence claims, Judge, I don't know how clear it can get. This came from her own mouth to her confidant, who she was using to try to first ask him to murder DePolito back in March of 2009, a month after she's married. And then to get guns for him. I mean, it happened from March all the way through till July, and then on July 31st, asking him again to participate in it. And this is what he testified to. And then basically she tried to lie to Officer Robert, to Detective Robert, and say that her husband was beating her, and that he was selling drugs, he was on probation, and that there's drugs and drugs at the gym every morning. And Officer Robert asked her many times to come in and speak to him. She wouldn't, because she said she is scared for his life. It was all a lie. Because I even told Robert that she tells me that he is
Where's this from? Objection.
This is from the sworn, it was used in impeachment. It's from the sworn statement by Mr. Shahade to the officer after the solicitation occurred, as I recall.
No, before. This is July 31st.
I'm sorry, before, okay. There was a statement before and after. Yes, it was. It was used for impeachment.
Because I even told Officer Robert that she tells me he's the nicest, sweetest nerd, but she can't stand him. He would never lay his hands on her, from her own mouth. How would he ever know that? But she comes in here and defames every other woman who's a victim of domestic violence by trying to use it as a weapon again, like she did her child. Master manipulator. They get up here and talk about these ridiculous poisoning claims. We heard from Mr. DiPolito about drinking the tainted tea. How would Mohammed Shahade know on August 10th of 2009 that she poisoned his tea 10 days before?
Objection, Judge. He said he didn't believe it until he testified to a third trial.
He's going to refer to Mr. Shahade's own statement, which was used in impeachment. I don't know what your objection is, Mr. Roosevelt, but it's overruled.
My objection is these are not facts presented at the third trial. He did not object to impeachment over this. He said that he didn't believe it.
Impeach with what's about to be read, I believe.
I told her when she was asking me about someone to kill him, I said, why don't you just divorce him? Why don't you just figure out some other way? She goes, I tried. I even tried poisoning him. I said, what do you mean by poisoning him? She said, I researched something on the internet about some kind of antifreeze that's odorless, doesn't have a smell, doesn't have a color. And I put it in his tea, and he spit it out. And she just told me that maybe the tea was too concentrated. How long ago was that? Maybe about a week before all this happened, a week, 10 days, or something like that. She told me he took a sip and spit it out. Judge, she's married 1 month. She's already stolen $100,000, deceived her husband into turning this money over to him so that he could get off probation so she could take it and spend it. She buys a truck for a lover of hers and then tries to use that as a weapon for him to manipulate him into having her husband murdered at the time. It was, Judge, when you
watch her on those videotapes, it was humorous for her to kill an innocent man in cold blood. She was laughing about it. Unfortunately, she is the one who, by her own thoughts and own actions, this is who she is. She's vicious. She's ruthless. She's cruel. She's inhumane. And she's heartless. You will never see a solicitation to commit murder with worse facts than this. She is the worst of the worst, and she deserves the maximum penalty punishable under the law. 30 years in prison.
Thank you, Mr. Williams. Well, the state's going to get the last word. So if you got something you want to say, I'm going to give you the opportunity to say it, but the state's going to get the last word.
Real briefly, it won't be at the after. And I feel compelled to respond to the baby comment. And maybe this is my upbringing. My father was a retired infertility specialist. I'm just sick of this state throwing this down your throat. I know you won't consider a judge, and you're not going to consider that as manipulation. But aside from her constitutional right to choose what she does with her body, Dahlia's not getting any younger. I mean, what happens if she was acquitted and she couldn't have a child? I mean, should she be punished for that? I mean, the fact that the state, without any evidence, gets up here and attacks her for, I guess, doing one of the most beautiful things in the world, bringing this child into a world is, I mean, it's kind of despicable, Judge, that she uses as a sword. She didn't know when her trial was going to go. She didn't know. I mean, I guess I don't have much more to say about it, but it's disheartening that in 2017, with men having babies all the time in prison, Dahlia gets attacked like that in court for choosing what she wants to do with her body. It really, it's really distasteful, and I know Your Honor very well. I don't think you'll consider that in sentencing, but I really hope you don't.
Look, I mean,
it's upsetting.
There are two reasonable arguments that can be raised with respect to Ms. DiPolito's son. And candidly, I'll tell both of you, I don't know which is true, and it's not going to play much of any of a factor, affect any factor in the sentencing. One position which could be true is that Ms. DiPolito, desiring to be a parent and out of the best of motivations, had a child. That's a reasonable argument. It's also a reasonable argument, based on evidence that was presented, that she had the child to manipulate the court in a sentence. Both sides could argue those things reasonably from the evidence. Candidly, I don't know what the motivation is, and it's not going to be important with respect to my sentencing. So there are two sides to that argument, and I've heard both sides, and that's about all I can say about it. It could go either way. It could be it was done to manipulate the court with respect to sentencing because it's more difficult, judges being human beings, to sentence a mother than a non-mother. That's true. It also could be that she had a true and earnest desire to be a mother, and it is a wonderful thing. So, I mean, I can't tell which of those two things is true. I can't read minds. I can't read intent and motivation. So, frankly, the child is not going to play a factor in this. It's not something that I need to or want to consider.
All right, I appreciate that. And I will say that the child has never been in the courtroom, and Dahlia would not allow her child to be brought here for this hearing. It was her decision. She didn't want the cameras or anyone to bother or...
That's fine. The only thing I'm saying, Mr. Roosevelt, there are two sides to a reasonable argument here, okay? Yes. So both sides can be argued. Candidly, neither side is going to be considered by the court because I don't know what motivated. It could be purest of motives. It could be to manipulate me. I don't know. But it doesn't matter, frankly.
Okay, and the last 2 points I'll make, unrelated, and I didn't bring this up when I was distinguishing the case law argued by Ms. Lurie, is that in one of the cases, in the first trial, he was sentenced to, I believe, 20 or 30 years. It's in my pile back there, for murder, and I believe it was as an accomplice. And then it came back in the second trial that he was the one who actually slit the person's throat. I believe those are the facts. Facts that were not known to the judge, and he got 50 years. So it was aggravating facts that came forward. And secondly, I'd say in terms of house arrest, I think there are situations where Your Honor can't consider it as confinement based on how restrictive her house arrest was. But irregardless of that, if you can't give her credit for that, I believe you certainly can consider that in imposing a sentence. But I have nothing else, Judge. Thank you very much for your time.
Okay. I did say state gets the last word. Anything further, Mr. Williams? Okay. My turn. My sentence is obviously going to be debated, discussed, critiqued, maybe criticized, I don't know. And so I am going to take a little time, a brief period of time, to explain my reasoning and to explain my sentence. And I'm going to try to put aside as best any human can, all of the extrinsic factors that have floated around this case, the collateral matters, which have had made the case more difficult, frankly, from a lot of different perspectives. I'm going to try to set aside that noise, so to speak, to be objective and to reach a sentence that I think is appropriate. Probably not surprisingly, I don't totally agree with either one of you. And I'll tell you how I disagree and where I do agree. With respect to the state's position on a sentence that exceeds the prior sentence of 20 years, in other words, a request for a maximum sentence going up to 30 years. I believe the state has correctly pointed out that there are exceptions to the presumption of vindictiveness. Generally speaking, under North Carolina versus Pierce, I think the Supreme Court case is that if the sentencing judge exceeds a prior sentence after appeal, there is a presumption of vindictiveness. That presumption can be overcome, but it requires evidence demonstrating that the defendant did something between the first sentencing and the second sentencing. The state has correctly pointed out that there is an exception to that where the judge that's sentencing the second time is not the same judge that sentenced the first time, which obviously is the case here. Judge Colbath sentenced the first time, I'm sentencing this time. So there is an exception in my understanding based on the case law that the state gave to me that under those circumstances, if the sentence exceeds the prior sentence, there is no presumption of vindictiveness, but the defense still has the opportunity to demonstrate actual vindictiveness. I acknowledge that as a legal principle, and so I acknowledge that there probably is authority for me exceeding the 20-year sentence previously handed down by Judge Colbath. But from my perspective, I believe that that would punish Ms. DiPolito for taking an appeal. And so from my own personal perspective, that could be viewed as vindictive. So while I have the legal right to do that, perhaps under the case law that the state has given to me, I believe that the maximum sentence in this case should not exceed the sentence that was imposed by Judge Colbath. So that's how I disagree with the state. With respect to the defense, I have to make a couple of comments concerning downward departures and also the guideline score sheet in this case. So I'll comment on those two things because from that perspective, I disagree with the defense. First, let me address the downward departure issue. Both sides know it's a two-step test. Number one, the court must determine whether the defense has provided sufficient evidence to support a downward departure. That's step one. Step two is, regardless of whether or not the defense has in fact met that burden, should the court depart. So it's a two-step process. As I understand it, the defense has raised essentially three different grounds, interrelated somewhat, but three different grounds for downward departure. So let me briefly address those. With respect to the first grounds for downward departure, that the need for restitution outweighs the need for punishment. I do not believe that ground for downward departure has been satisfied in this case, or perhaps is even relevant in this case.
As pointed out by Ms. Laurie, this is not a grand theft. If this were a theft case, then perhaps restitution would be primary on everyone's mind. This is a solicitation to commit first-degree murder. So I do not believe that restitution really is a driving issue in this case. Even to the extent that Mr. DiPolito would want restitution, I don't think that need or that desire, sitting where I'm sitting, would outweigh the need for punishment. So I do not believe that basis for a downward departure exists. With respect to the second statutory grounds for downward departure, my understanding is this wasn't, candidly, this wasn't raised specifically in your motion, Mr. Rosenfeld, but I understand that it's the isolated incident, unsophisticated, for which the defendant has shown remorse, which is a statutory basis to depart. Candidly, I do not believe the evidence supports that ground for downward departure either. I think, candidly, the first element may have been satisfied, isolated incident. I know the argument Ms. Laurie raised about the other prior acts leading up to the solicitation, but it is her first charged crime, so there are no other crimes. I think isolated incident may be satisfied. I do not believe that it's been proven that it was unsophisticated, given the evidence and facts in this case. Also, I do not believe that there's been sufficient evidence of remorse. I understand the argument. Well, first of all, I understand the handicap if you're not going to allocute because of appeal, so that is a bit of a handicap in raising that issue. But the argument, candidly, that she was willing to turn the house back over and that shows remorse, frankly, just doesn't fly with me. That's not something that I think satisfies that requirement. The last ground you raise is a non-statutory basis, which frankly, if you look at the case law, is pretty wide open with respect to non-statutory grounds. You can argue just about anything under that catch-all, and it may be a grounds for departure. That ground may have been satisfied here, so I won't say that there's not sufficient evidence to consider that downward departure. But candidly, when you get to the second element, it doesn't matter. And because the second element is, even if there was a ground for departure, should the court in its discretion depart, I do not believe the court in its discretion should depart. So there will not be a departure sentence. Commenting briefly on the score sheet, obviously this is a debate that I have with state attorneys and defense attorneys every day of the week about what that means. Is it a recommended sentence? Is it simply the floor? Mr. Rosenfeld, you thought there might be sometime a case deciding that issue. There never will be, because that's simply an argument with respect to how a court should perceive it. The law is clear that absent of grounds for departure, you can't go below it. But the law is also clear that you can go all the way up to the statutory max above it. So that issue is not an issue that's ever going to be decided by an appellate court. It's an argument that attorneys will have in front of judges continuously, and it's been made in front of me continuously. My view of it is it's not a recommended sentence. It is, in fact, the floor. It is, you cannot go below that without grounds for departure. So I do not believe it's a recommended sentence in this case, and therefore my discretion is anywhere from the recommended sentence, or not the recommended, but the floor sentence of 48 months all the way up to what I've described as the 20-year cap. I think that is the appropriate range in this case based on my view. So let me talk then specifically about my reasoning in terms of the sentence I'm going to impose and how I am getting to where I'm ultimately going. I'm going to start with an area where I absolutely agree with the state in a couple respects. Number one, the goal of sentencing is punishment. It's not rehabilitation. The legislature is clear on that. The goal is punishment. So in this case, the issue is what is the appropriate punishment for Ms. DiPolito, who's been convicted by a jury of solicitation to commit first-degree murder. That is the issue before me. What is the appropriate punishment? I also agree with the state that the circumstances and the evidence in this case as a starting point, and let me emphasize as a starting point, because the way I'm approaching this is I'm looking at the aggravating factors, and then I'm going to consider whatever mitigating factors there may be. But from my perspective, the state is correct that this particular crime was committed not in an unsophisticated way, but in a sophisticated way, in a cold and calculated fashion. There was a plan put in place by Ms. DiPolito to kill Michael DiPolito. The jury so found, and the evidence so supports. And it was done in a very cold, as I said, and premeditated fashion. The evidence at trial, in fact, suggested that perhaps at the time Ms. DiPolito may have been manipulating up to 3 different men, including Mr. Stanley, Mr. Shaheda, and obviously Mr. DiPolito, in planning the death of one. So in terms of aggravating factors, the evidence in this case, and the manner in which this crime was committed, I believe, based solely on that, the maximum sentence of 20 years should be imposed if I didn't consider any mitigating factors. So as a beginning point, I think the state is correct that the maximum sentence, and of course I'm defining the maximum sentence as 20 years as opposed to 30 based on the comments I've already made. So as a starting point, I believe the state is correct that the maximum sentence is appropriate in this case, absent any mitigating circumstances. I'll make a brief comment, I wasn't going to, about Mr. DiPolito. I think Mr. DiPolito's testimony, both at trial and here today, also candidly supports the sentence of 20 years. Because Mr. DiPolito, there's been a lot of talk about Ms. DiPolito living with this case, and certainly she has, and I'll comment on that in just a moment. Certainly she has. But Mr. DiPolito, who was an innocent victim in all of this, has suffered through that same 8 years and has been caused to come into this courtroom over and over again and to be exposed to the same intrusion by the press and by others who are curious. And so he has suffered through that. And I know, candidly, Mr. Rosenfeld, I hear you say that you didn't mean to attack Mr. DiPolito, and I'll take you at your word. But frankly, I found his statements compelling to me. I felt he's been honest. He was honest, I thought, at the time of trial, although I can't weigh the evidence. That's the jury's duty to do it. But I can weigh and consider his comments here. And so, frankly, I think on Mr. DiPolito's behalf, again, that is an aggravating factor. So as a starting point, I think the maximum sentence as defined by the prior sentence by Judge Colbath is the correct sentence. However, and frankly, it would probably be easier if I just stopped there and sentenced, as was sentenced before, at 20 years. But I don't believe that's appropriate either. I believe I have to objectively, on my own behalf, not based on what anyone else has done, not based on what anyone else's expectations are, thoughts are, beliefs are, or criticisms that I might receive. I think my job is to objectively consider what I should in terms of mitigating factors. And so I've tried to do that. And so I'm going to consider a few of the mitigating factors with respect to imposing sentence. I'm going to comment on several of the mitigating factors, but I'm going to focus primarily on the 2 that I think are of any significance. Frankly, there are many mitigating factors I do not believe have much or any weight in terms of my sentence. So let me just comment on them briefly because they've been raised over and over and over again in this trial. First of all, and this was raised by Mr. Claypool in his opening remarks when we first started this earlier this afternoon, that the conduct of the Boynton Beach Police Department is a mitigating factor. I do not believe it's a mitigating factor. You are correct, Mr. Rosenfeld, when you point out that I did have a few critical remarks to be made about the Boynton Beach Police Department. I also said the remarks by defense in that same order were overblown. I do not believe that law enforcement should be about theater. I stand by that comment. And there are a few things that could have been done better in that investigation. But the bottom line is, it's not a mitigating factor because the Boynton Beach Police Department, criticize them as you may, in this case, probably saved a life. It was their investigation. You can be critical of it as you wish, and there are points of it which can be critical. I concede that. But the investigation probably, or more likely, saved the life of Michael DiPolito. Because as I said, the evidence supports the conclusion that Ms. DiPolito had the intent to have her husband killed. That's what the jury found, and that's what the evidence supports. And so I do believe that the investigation, where it may have been flawed in ways, did not cause Ms. DiPolito to do anything. There was never any evidence that they induced her to do anything or that anyone induced her to do anything. She did it of her own free will, and their conduct cannot be a mitigating factor in this case. One mitigating factor that requires some weight, I have taken the time to read every single letter that's been sent to me, has been included in the package the defense has sent to me. So anything that's been sent to me concerning those individuals who have now interacted with Ms. DiPolito, have spoken with her, who believes that she is a different person, that she's matured, that she's now a person of faith. I have read all of those. I believe that is a mitigating factor, although candidly I have to make it a slight mitigating factor because I still have to go back to there's evidence to the contrary as submitted during the course of this trial. I frankly hope that Ms. DiPolito is a changed person. I hope she is a mature person or a more mature person and is a person of faith. I think all those things are good. I hope that to be true. But frankly, I can't use that in connection with the sentence in any real meaningful way. Another issue that was debated, objected to, discussed ad nauseum with respect to mitigating factors would be the lack of offers or attempts to resolve this case. I cannot consider that to be a mitigating factor. State attorney, as the executive, makes decisions about what cases to prosecute, what cases to offer what in. That's an executive function. It's not the function of the judiciary unless it's a plea to the court to get involved in that. And so they get to make those decisions just like I get to make my decisions. And whether they choose in any particular case to negotiate or not negotiate cannot be, in my view, considered to be a mitigating factor. Candidly, the other cases that you presented to me, I understand in sentencing in general there can be disparity, but I don't know the facts of those cases. I didn't try those cases. I don't know what those judges were thinking. I mean, candidly, and we all know this is part of the system, you know, we have 6 or 7 different judges here in the criminal division. Their sentence might be different in this case, each of us, and so we probably try to bring our own perspective to the sentencing process. So I really can't consider those other cases to be of any mitigating significance. The publicity is something I've considered, not because there was publicity, but only in connection with the in-house arrest, which I'll get to in just a minute. That's just been the fact of this case from day one. It's an unfortunate fact from the party's perspective that that's something that they have to deal with. But as I said, it's not just Ms. DiPolito that's had to deal with it. I understand it's been an extreme factor for her. It's been an extreme factor for Mr. DiPolito, for Mohammed Shahadi, for the attorneys, candidly for me. I don't enjoy seeing my face on television in Australia any more than anyone else does. And so that's just been a fact of this case, but it can't really be a mitigating factor. There are, however, 2 things I've considered objectively as mitigating factors. One is, although I do not believe the score sheet is the recommended sentence, and I do not believe and disagree that I should sentence to the minimum score sheet sentence in this case, I believe it is a mitigating factor that must be taken into account by any objective judge that Ms. DiPolito has no prior record, and that's why she scores the way she does. And so I do think I have to take that into account as a mitigating factor. The other significant mitigating factor I have to take into account in this case is the time on in-house arrest. So let me comment briefly on that and my perspective on the time on in-house arrest. Obviously, in-house arrest is not the functional equivalent of jail, and therefore there is no entitlement under our law to day-for-day credit for in-house arrest. In-house arrest is not jail. There's a difference between a townhouse and gun club. And so you can't get day-for-day credit. But it is something that can be considered, particularly in a case like this, that is, for various reasons, taken so long to reach a conclusion over 8 years. And so the time on in-house arrest is something I can consider as a mitigating factor. Parenthetically, the sentence that was previously handed down by Judge Colbath, either inadvertently or not, did take that into consideration, because the sentence of 20 years was really not a 20-year sentence. It was an 18-year sentence, because credit was given for in-house arrest where legally there was really no basis for that. I don't know why that was done. Ms. Laurie said because the state didn't object. That's probably correct. I wasn't there. None of us were there except for Ms. Laurie. So for whatever reason, in-house arrest was something that was taken into consideration with respect to the first sentence. And so I believe that I do have to consider, not day for day, but I do have to consider the fact that Ms. DiPolito has been on house arrest for 8 years. As I said, it's not the functional equivalent of jail, but it is a restriction on your freedom and your liberty. And so I do need to take that into account in terms of passing a sentence. And so my primary mitigators in this case against the 20-year maximum sentence are going to be the in-house arrest time and frankly the fact that other than this case, she has no prior record. Taking into account all of those considerations, my sentence is as follows. My sentence is 16 years in the Department of Corrections with credit for 163 days time served. I'm also required to inform Ms. DiPolito of what she already knows, but I'll inform her because I'm legally required to. You will have 30 days from the date of this sentence and judgment to appeal. I also am required to assess court costs in this case, and I realize it's not significant compared to everything else that's been going on. The court costs in the case are $518. Mr. Rosenfeld, I typically ask how defense wants me to handle court costs. You want it in a judgment? What do you want to do?
Judgment's fine.
All right, we'll place the $518 in judgment. I've explained the best I can why I've done what I've done. I've tried to be as objective as possible. As I said, I'm sure this sentence will be discussed, debated, criticized, and that's okay. It's my job to pass sentence, and that's what I'm doing. So it's 16 years with credit for 163 days time served. Giving credit for about half of the in-house arrest time is the way it works out, because I think absent grounds for mitigation, I agree with the state. This is a maximum sentence case, which would have been 20 years under my theory of vindictiveness. Is there anything else we need to do before we conclude this sentencing hearing?
No, Your Honor.
All right. One further thing I'm going to put on the record so that it's clear, I think it needs to go on the court event form. At the last hearing, Mr. Rosenfeld indicated he would be filing a motion for release on bond pending appeal. Since you've indicated that you're going to do that, I'm going to direct the Sheriff's Office not to transfer Ms. DiPolito to the Department of Corrections until such time as I've been able to hear, consider, and rule on that motion. So we'll keep her here in Palm Beach County until I've done that. All right, one last time, anything further from either side? All right.
I just request, and I know it's not your general practice, or most of the general practice, to give a court date for a motion, for any motion before they're filed. But if I can schedule with judicial assistant on Monday, I leave the country on August 10th, and obviously I'd like to be here for that. So if you give us maybe.
Well, hold on, back up from this. Here's what we're going to do. You need to file your motion. All right. Once your motion is filed, I'm assuming the state may wish to have an opportunity to respond to that. All right. How long do you need to respond to the motion? I understand, but I got to set some kind of deadlines. All right, let's say 5 days to respond to the motion, and then I will start looking at hearing time. When are you leaving, and when are you back? You're leaving on August what?
August 10th.
And when are you back?
Not until September 3rd, 4th. Nope, that's a holiday.
right. The bottom line, Mr. Rosenfeld, is I will attempt to set this as timely as I can, but I cannot promise you I'm going to be able to set it before you leave the country, because I have a speedy trial, I've got a murder trial after that, and this isn't the only case, believe it or not, that I have to attend to. So I will do the best I can to set it during my normal motion week. I certainly won't set it when you're not going to be here, Mr. Rosenfeld, but I can't guarantee you it's going to be before August 10th. That just depends on a number of circumstances. So, and it's, frankly, I'll be candid with you, it's unlikely that's going to occur because of my trial schedule. All right. One last time. Anything further? All right. All right. We're in recess. This is not related to Dippolito. Okay. I'm sorry, what are you asking? Oh, Mr. Williams, where are you? Clerk is indicating there was an exhibit placed in evidence that you have.
Dahlia Dippolito being led out of the courtroom in Palm Beach County, Florida, and to a 16-year prison sentence. That's the sentence handed down just a few minutes ago by the judge who presided over Dahlia Dippolito's third trial on charges she hired a hitman to kill who is now her former husband. That hitman turned out to be an undercover police officer. The police faced plenty of scorn and ridicule in this case because the police were also in the midst of filming an episode of the television show Cops. And through one or multiple, rather, of her several trials, Dahlia Dippolito claimed that the police were pushing things a little too far and trying to ham things up for the camera. We heard a lot of blaming of the media from Dahlia Dippolito's attorney, and I can attest that I've never told her to do anything, let alone had a conversation with her. So I'm not quite sure how any of us in the press face any blame. But the judge said that the attention the case has received did not play a role in his decision, nor did the state's bombastic accusation that Dahlia Dippolito gave birth to a child while she was on house arrest, specifically to try to manipulate her sentence. That resulted in some big fireworks, and we're in the process of clipping some of the more bombastic moments of this sentencing hearing, which I think is going down in history as one of the longest ones I've ever seen. It's about a 4-hour hearing when we time it all out, almost right to the dot, in Florida, with testimony rather than just statements. But we've got some of the bombastic moments of this up on LawNewz.com if you'd like to check them out. Again, Dahlia Dippolito, 16 years in prison for hiring an undercover cop who turned out to be a hitman. She was convicted by a jury in Florida on her third trial there for solicitation to commit first-degree murder. A reminder that we are continuing to cover the trial of Eric Campbell in North Carolina. He's the young man accused of going with his father on a multi-state crime spree. The defendant himself was the first person to take the stand in the defense, and he was on the stand for more than a day. The defense now seems to be moving into more of an expert witness pattern after putting the defendant on the stand first. We're continuing to cover that case, and we will continue to cover it next week because it looks like the defense will be a lengthy one. So, a reminder that we here at the LawNewz Network are on the air from 9 a.m. until at least 5 p.m. Monday through Friday. Of course, on nights like this, when court runs late, we stay late so that you can see everything happening live. We'll see you back here on Monday morning at 9 a.m. For now, this is Aaron Keller, and for all of us here at the LawNewz Network, have a good weekend, and we'll see you back Monday morning.